This conference will now be recorded.
Good morning, everybody. It is 9 a.m. on July 14, 2021. This is session 10 in the appeal hearing on UZDP 2019-00562. Based on the chat request that we got partway through yesterday's session, I think for the rest of the week, I'm going to, at the beginning, indicate when public testimony will be taken, so that if we have members of the public who are with us, they won't be sitting around wondering when they get a chance to talk. So, public testimony will occur next Monday morning, July 19th, starting at 9 o'clock in the morning. Each witness will be allowed up to 5 minutes to present their testimony. If it were to happen that this hearing otherwise concluded by, let's say, Friday afternoon, Friday night, the hearing will reconvene Monday morning at 9 o'clock so that we can hear from the public. If the hearing is still going, then we will break the flow of whatever we were doing Friday when we quit, and we will take the public testimony first thing, 9 o'clock Monday morning. Okay. Now, first item of testimony today is to hear from Mr. Evan Maxim. For the record, Mr. Maxim was subpoenaed to appear today, so he is appearing as a result of that subpoena. Ms. Koloshkova, you were the party who asked for the subpoena. I will let you do the questioning, and then we'll treat Mr. Eglick as cross-examiner. Ms. Koloshkova. Oh, Mr. Maxim, I should ask you to raise your right hand, sir. Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your name and spell it for the record.
My name is Evan Maxim, spelled E-V-A-N as in Nancy, M as in Mary, A-X-I, M as in Mary.
Thank you, Mr. Maxim. Your witness, Ms. Koloshkova.
Thank you, Mr. Examiner. Good morning, Mr. Maxim. And did you receive a summons from the hearing examiner in this matter?
Yes, I did.
Okay. And did you have the ability to review that summons?
Yes, I did.
Okay, thank you. I would like to ask you some questions today based on the topics that were identified in that summons. So I wanted to make sure that you had an opportunity then to consider those topic areas between when you received the summons and today. Have you been able to think about things a little bit?
I have been able to think about things a little bit, yeah.
Okay, great. And can you tell me, did you work for the city of Sammamish in any capacity during your career?
Yes, I did.
And could you just describe what your job or jobs were in the relative length of your timing and length of your tenure?
I worked for the city of Sammamish from, I believe, approximately April of 2002 until June of 2016. I started as an associate planner, primarily reviewing construction permits, building permits, land use permits. I was promoted twice at the city of Sammamish, first to senior planner and then a supervising senior planner role. At the end of my tenure, I was involved in reviewing town center projects, large subdivisions, preparing code amendments and comprehensive plan amendments.
And as part of your during your tenure, was that when the city adopted what's known as the town center plan?
I believe that's when it was originally adopted, yes. I understand it may have been amended since.
Okay. And during your tenure as well, did the city adopt a document called the Town Center Infrastructure Plan?
I believe so.
And during your tenure, did the city adopt regulations into Sammamish Municipal Code pertaining to the town center area?
Yes.
Okay. All right. And did you have any involvement, whether reviewing, editing, drafting, or participating on behalf of the city in any of those documents?
Yes, I did.
Okay. And did you have any role in reviewing any applications that had been submitted for property
Yes,
located within the town center area? Sorry.
pardon me for interrupting.
No, you're
I was involved in the direct review of 2 of the applications, and I supervised the planner who completed the substance of the review on the 3rd.
Were you involved in the drafting of code related to how town center development would proceed from a standpoint of the, I guess, application process?
I was involved in the discussion and the review and presentation and I guess preparation of that code with the Planning Commission and to some extent with the City Council. I was not the original drafter.
Who was the original drafter?
I don't recall clearly. There were a number of people working on the project, makers, consultants, which John Owens and I believe Bob Bangford with makers were involved in that discussion. Cameron Gural was the director of community development at that time. Susan Cesar. There were probably others I'm forgetting at the moment. Michael Mathias was the town center manager at that time.
And you were part of the group that did the drafting there? I mean,
Yes.
in some form or other, depending on.
It was a group effort, so there was draft code prepared, and then we were engaged in dialogue and discussion around that code and editing. And I certainly would have commented on the draft code.
Did your work include commenting, editing, drafting, et cetera, on the process known as the UZDP process?
Yes.
And did you review any permit applications subsequently that fell under the UZDP process?
Yes, I reviewed 2 applications, and I was the supervisor, pardon me, for the planner that reviewed the 3rd.
And what, do you recall the names of those projects or the names of the applications? You can use whatever the city named it.
So one project was located to the east of 228th, a townhome project with some live work units by Ichijo. A second project was the TRF Pacific project, which is located to the west of 228th, north of Southeast 4th Street. I believe TRF Pacific was the applicant. I understand the apartment building that was part of that project was just recently built out. Those 2 projects were the 2 that I directly reviewed. The 3rd project, which I believe was referred to as Plateau 120, was reviewed by Robin Probsting, who was the direct reviewer of it. I was her supervisor at that time. And I do not recall whether I ended up signing that decision or if Robin did.
Okay. And I'm sorry, just to go back, the first one you talked about, the Ichijo, what kind of development was that? Do you recall?
That was a townhouse development, and it had, I believe, 4 or 5 live work units on the north side of the development.
Do you recall this? Go ahead.
That would have been, I believe, directly south of, I'm going off memory, but Mr. Galvin and Mr. Stickney's properties on the east side of 228th Avenue.
Okay, who are Mr. Galvin and Mr. Stickney? Who are they?
Pardon me, I perhaps should not have explicitly named them. They were property owners in the town center in the southeast quadrant of the town center.
Okay, do they work for the city or?
No, they are private property owners.
Okay, so you're just, okay, locational.
It was just the reference I had at the time.
Okay, no problem. Just wondering if those are relevant people to our discussion.
I do not. Apologies.
Okay, no problem. And for the Ichijo project, do you recall the zoning for that project?
I do not recall at this time, no.
Okay, all right, but it was within the town center.
It was within the town center, and I could review a town center zoning map to.
No problem.
I think that for herself though.
And then the TRF Pacific, you testified a moment ago, those were apartments?
No, that was a mixed-use project.
I'm sorry.
On the east side of that project is the Metropolitan Market. I believe that there's a hospital facility in that complex, and then there on the west end, there is an apartment mixed-use building. And those are located to the west of 228th, north of Southeast 4th Street.
Okay. Okay, so we have a mix of uses across the zone and then a mixed use building itself as part of that project. There's multiple
I believe
components.
so.
Okay.
Yeah.
And I know you testified that you were supervising Plateau 120, and I don't intend to get into the details of any of these, the substantive details of these applications, but I do just want to complete my question as to whether you recall the general types of uses that were permitted under the Plateau 120.
I believe it was a mixed-use building, apartments above. I believe it was a daycare at the time I was involved in that project. I don't know if it still is.
Okay, right. Was it just one building, do you recall, or was it?
I believe it was one building and some road improvements in the northeast quadrant of the town center.
Were you, well, that was a Robin Probsting project. Okay,
So I was not involved in the day-to-day review and feedback to the applicant.
So let me pull back then. Is there anything you want to add in terms of, this is really, I'm asking you questions, but I want to make sure that you share whatever you think may be useful for the examiner to know as part of the project process. So I want to make sure, is there anything that you want to add about I'm getting an echo.
Yeah, we're getting that lag coming out of City Hall, I think. I'm sorry to say.
Okay, that's fixed. So is there anything you want to add about your tenure in terms of job descriptions?
I'm going to object to the question. Objection. We of course still reserve or preserve our objection to the subpoena for this witness, but open-ended questions like that invite going beyond the parameters of what was defined on the subpoena as the areas of testimony. If there's a particular area that the council wants to ask about, that's fine, but open-ended questions like that I don't think are appropriate in these circumstances. Thank you.
I would generally be inclined to support your objection. However, this question asked him, if I'm remembering correctly, about his work, the nature of his positions with the city.
Correct.
And if he sticks to that, I don't think that it's going to be in a problematic direction. So I will overrule it just because of the nature of the question.
Thank you, Mr. Examiner.
I don't know of anything else that would be helpful to share for this hearing related to my work during that time period.
Thank you. Perfect. So could you describe for us your understanding of how, or I guess the nature of the UZDP application process as compared to other types of applications?
Objection is to the form of the question. The question, and maybe we can have a continuing direction on this from the examiner, should be in terms of when this witness was last engaged in it, which, as I understand it, would be May 31 or at the latest June 10, 2016, I believe. A general description of the process as it may have evolved in the last 5 years is beyond this witness's, the scope of his testimony or of his knowledge.
certainly, and that would be beyond the scope of what I put in the subpoena that he could testify about. Mr. Maxim, as a general guidance in responding to questions from either council, please limit your answers to your personal experience from the time period when you were working for the city.
I will do so, Mr. Galt.
Thank you.
And
You
Mr.
may-
Galt, just for the record, that was my intention with covering the subpoena to begin with as well, to make sure that the witness is oriented towards his tenure time with the city.
Very good. You may continue.
Ms. Gluskova, could you repeat the question? I've lost track of it in the intervening
Yes.
time.
Thank you. Based on your tenure with the city in that time frame, testifying related to that time frame, could you describe for us your understanding of the difference between a UZDP application and other types of permit applications that the city would have normally seen while you were working at the city?
So in general, during my tenure at the city of Sammamish, we had permits that I would generally characterize as ministerial, meaning a very simple review for compliance with code standards. Permits that would fall into that category might include a building permit for a single family house. We had permits that were perhaps a little bit more administrative in that they include a public comment component. So a short plat might fall into that category, where largely the review is for compliance with established black and white zoning codes. But they had the public component, and we were expected to respond to public input. This type of project, I think, this type of permit process during the time I was there was a little bit unique in that it was a heavily discretionary permit on the part of city staff. And because of that, it required more active engagement with the applicant, with the community at large, and more interpretation and understanding of the town center plan and principles and goals than, for example, a building permit would. Because of that, the approach we used was very different than a building permit review. As everyone in the hearing will know, we require pre-applications, or we did require pre-applications for certain types of projects. Typically, those pre-application meetings were intended to, in the case of a building permit, inform the builder or the architect as to what the specific zoning requirements would be. In the case of a project like the UZDP, the purpose of the pre-application was to essentially work from a concept to a specific project application proposal before it came in the door, if you will, as an application and underwent review. So in terms of the substance of the review, there's a significant difference between the UZDP, at least in my experience, and a building permit. And there was a substantive difference in the process between a building permit and the UZDP.
And in terms of that substantive process for the UZDP, when you were working with the group developing code, were you analogizing the UZDP to other types of either permitting or zoning concepts? Can you talk a little bit about, let me strike that question. Let me ask this differently. I apologize. How did the group come up with this concept of a UZDP?
So my memory is that the UZDP, that acronym stands for the Unified Zone Development Plan or Unified Zone Development Permit. At the time that the Town Center Plan was adopted, one of the challenges in implementation of the Town Center Plan that staff anticipated was the aggregation of land by a developer to engage in an actual application permit review with the city. The idea behind the UZDP was to provide enough information to a developer as they were engaged in the land acquisition to allow them to have some certainty as to what the product might look like. That was in part done through the pre-application process. In terms of the philosophy behind the UZDP plan, there were a number of mechanisms that we discussed around how to entitle or how to engage in a land use entitlement in town center. We discussed a conditional use permit process. We discussed a development agreement process. In the end, the analogy that stuck with me was that we were attempting to create an administrative development agreement type process. Development agreement, of course, requires that a project adhere to specific development standards, except when a public good might be achieved through other means. And that type of flexibility was desirable in the town center as we were thinking through land aggregation and how infrastructure might be built long term. So again, to me, the closest analogy is the administrative development agreement.
So why was flexibility important to the group?
It was important because we did not know whether a developer would be able to acquire all or some of the properties in the town center when applying for a permit. So adopting black and white zoning code would potentially stand in the way of creating a town center as described in the town center plan. You might see a balkanized development pattern rather than something that was more consistent with what the town center plan envisioned. So flexibility was desirable there. The other part of this, I think the city staff team was aware that they were not designing the specific project at that time. And so providing some flexibility to accommodate on the ground ideas, on the ground situations, permit constraints was appropriate. And some flexibility in terms of where infrastructure would be located might be necessary. As I recall, the town center plan is split between two drainage basins, providing for some flexibility in terms of where the drainage facilities might be located would be desirable, allowing for some flexibility in ensuring that the green spine was created would also be desirable.
You, when you were putting this process together, what did you understand to be, I guess, necessary flexibility for an applicant to have? Or was that a consideration at all?
Objection is to the form of the question. I think the witness has said that he participated along with many others named, not to mention the council and the planning commission, in putting the process together. The question asked when you were putting this process together. I don't think this witness has testified that he created this process personally.
Rephrase the question, please.
When the group was putting together the UZDP process, what was your understanding of what the group was trying to accomplish for the applicant's role?
So I understood that the city staff were attempting to create a process where we could collaborate with the developer in furthering the goals and principles and policies of the town center plan. The city staff was comprised of a group of planners, engineers, as Mr. Eglick noted, the planning commission, of course, and the city council were heavily involved. Not necessarily design developers who may have control of property and may know more about the on the ground situation. So providing some flexibility to accommodate good ideas from the applicant or the developer was something that I think the city staff were contemplating. It was also important in that conversation, as I understood it, again, this was a group conversation to Mr. Eglick's comment, to ensure that there were guardrails, that the city retained the ability at the end of the day to ensure that the development complied with the town center plan and the town center code. So there was some recognition that some flexibility was appropriate. That was not at the cost of the city retaining the ability to either entitle the property or not at the end of an application process.
Would the market conditions tied to any particular UZDP be relevant for for city staff in that respect?
Objection is to the form of the question. It would require clarification. We're talking about what market conditions. Thank you.
Please clarify.
Would any market conditions related to the particular UZDP application be a consideration relevant for staff in their processing of the application?
So yes, I believe it was relevant in the processing of the application. It was also relevant in the drafting of the code. But in the processing of the application, the city was interested in ensuring that the project would not result in empty buildings at the end of the day. So insisting on a specific use or product on the site was not something that we were contemplating at that time. I believe if you review 21B20, you'll note that there are a number of uses allowed as part of a UZDP plan. As I understand it, the group at the time intended to allow some flexibility for the developer to choose the right mix of uses within the UZDP plan, subject to limitations around the residential density and the commercial square footage overall. And I believe those limitations were primarily tied to transportation concerns.
Do you recall discussion in the town center plan of a concept of a master plan?
Yes, I do.
Was the idea of a master plan, I guess, embodied through the UZDP?
Yeah, I think that was part of the thinking behind the UZDP approval process, was that we would have, in an ideal situation, you would have a developer that would own, ideal at the time, a developer that would own a large block of the town center, and the UZDP application would reflect multiple phases of development over time. This is why I believe there's phased language for construction in 21B95. The understanding there was that that may not happen. And so to the best of the ability of the person, the developer that came in the door first, they should contemplate how the remainder of the town center would be developed at a later date and how their portion of the project, if you will, would fit into that bigger master plan. So in the review, can I reference the TRF project to make this a little bit more concrete?
Sure.
In the review of the TRF project, part of our engagement with that developer was to better understand how that set of buildings, how that set of development would fit into a master plan for the remainder of the town center west of that project and south of that project on Southeast 4th Street.
Okay, yeah, I'm sorry, did you finish or were you gonna?
No, I'm finished. I'm struggling with answering the question completely and not going on to.
No, you're fine. I think you've got it there. I may have some more questions on that line, but I want to stick with the broader concept of the UZDP. So can you describe what the group's understanding, as you see it, was of the level of detail envisioned for the UZDP application during your tenure at the city?
Again, objection. I think the question was somewhat recovered with the phrase "as you see it," but it should be clear that this witness can testify as to his understanding, not to others. And so I object to make clear that the question should be limited to that.
May I take that as a continuing objection and provide a continuing ruling that this witness is testifying solely as to his recollection and his understanding of things that were happening during his tenure. Can we just do that and not have to keep coming back every time?
Mr. Galt, can we have Mr. Maxim just confirm that so that he has said it himself?
Okay, well, just before we do that, there's a construction crew apparently working in the street outside my house, and I'm hearing a lot of the backup signals. Is that coming through for the rest of you?
Not for me.
If it is, I'll shut the window and deal
Hello.
with.
Oh,
Hello. I'm sorry to interrupt. This is Josh
Yeah.
Whited. We at City Hall have lost power to the server and our video screen. We just lost it as you started talking about the continuing objection and continuing ruling. Right after you said continuing ruling, we lost our screen. So we are now in the process of trying to figure out what's going on.
the record can reflect Mr. Eglick just did a post-it note that said city lost power to its server system.
Yes, so we
But
are
the
down.
record said Mr. Eglick's image is clear
Perhaps they call in.
Yeah.
precise, but
Yeah,
Yeah, the image would be clear because we're actually for the video component, we are on our laptops so that you get the video out of the laptop, but all the audio and the screens that we're watching. So yeah, we didn't hear it, and the recording is also perhaps down as well, is my understanding. So
well, the GoToMeeting recording should still be running. My understanding is you folks are recording it in two different media. One, something working through your AV system at council chambers, and then the GTM system is recording it as well. I guess we just have to sort of cool our wheels for a few minutes here. Mr. Eglick, are you even able to hear me?
I can hear you.
no, I'm on my computer. He can hear you across the room. I turned my audio back on my computer as soon as we lost power. So he can hear through my speaker, but he's not set up right now to be participant.
Okay.
We
How
would need a
long? Let's take a recess. How long do you think you might like to have to address this?
It seems like the IT person is saying the reboot's probably 5 to 7 minutes. So can we go for 15 minutes maybe?
Okay, I've got 9:32. How about a recess to 9:45?
Thank you, Your Honor.
Okay, sorry to interrupt your testimony, Mr. Maxim, but it is what it is. We're at recess till 9:45.
This conference will now be recorded.
Thank you. It is now 9:47 a.m. on July 14, 2021. This is session 11 of our hearing, UZDP 2019-00562. Ms. Koloshkova, you were asking questions of Mr. Maxim. You may continue.
I was, and I
Could I
believe.
ask first, and I apologize for this, Mr. Examiner, I really didn't hear your ruling.
What was the question? I don't even.
It was, I think you were saying you were going to do a continuing ruling, and that's about where I got lost on the technology.
Okay. I said, can we accept that as a continuing objection, and I will give a continuing ruling that Mr. Maxim is only testifying to his personal knowledge about things during the time period that he worked for the city.
Thank you.
And then I asked if Mr. Maxim could verbally confirm that for the record.
And that's where we stopped, because I don't think we ever gave him a chance to confirm anything.
Correct.
So, Mr. Hearing Examiner and parties, I am only testifying based on my knowledge for the period of time that I was employed at the city of Sammamish. I'm fully aware that things may have changed since I left the city, and I respect that.
Yeah, I just want to be clear that my objection wasn't missing something. I think the objection was also to the witness testifying as to what other people, participants, thought or intended, as opposed to what he thought or intended. And I just want to make it clear that that's part of the objection.
The witness is not purported to testify in that manner. If he does, then Mr. Eglick can interrupt testimony and object again. But I would like to proceed with my questions, please.
Well, I'd rather not interrupt. I just want to make it clear that if there's a continuing ruling that that's what his testimony is limited to, that's good enough for me, as long as that we don't see anything in a brief or later claiming otherwise. That's fine with me.
Well, he has testified that at least for part of the time that he was a City of Sammamish employee, he had a supervisory role. And I think he is appropriately able to use the royal we in describing his understanding of what was going on. When he says the staff, he was part of the staff, and he's testified that he had a supervisory role for some period of time during his tenure. So I think we're arguing about how many angels there are on the head of a pin right now. I'd like to move on. I guess you can move on, Ms. Koloshkova.
Thank you, Mr. Examiner. Mr. Maxim, I was either asked you or about to ask you if you could, and I apologize for the breaks, but I'm going to reorient you to the UCDP process, which I believe we were talking about. And could you tell us your understanding during your tenure, what level of detail you understood the UCDP application to encompass?
So at the start of a UCDP review, we were engaging in pre-application meetings. I was engaging in pre-application meetings with other staff at the city. And we were starting with a very conceptual proposal. In the case of the TRF Pacific project, by way of example, we were starting with a very conceptual proposal and moving to a very refined proposal by the time the UCDP application was approved. So that's a spectrum of time. There were, by my recollection, several pre-application meetings with TRF Pacific before we reached a place where the city staff advised the applicant that we believed they were ready to apply for their UCDP application. When the application came in the door, there were still additional items that we required correction of or refinement of. I believe the applicant did that, and ultimately we ended up issuing that project approval. So at the start of the application, it was very conceptual. By the time that when I say start, I mean at the start of the pre-application phase. So this was almost the quote unquote blobs on paper, where you're essentially identifying where various types of uses might go, where infrastructure might be located, things of that nature. At the time of the application itself, I no longer recall the specific details that we required for a complete application determination, but those would have been established on the application forms we would have reviewed for that submittal. And the project became even more detailed and more refined by the time it was approved at the end of that review process.
So starting with the pre-app side of things, I mean, this is a mandatory pre-application process, am I right?
My recollection is that it is a mandatory pre-application process. It's also one that staff heavily encouraged when I was there. So again, staff, myself, other reviewers, in my experience, would have heavily encouraged the applicant to engage in potentially multiple times until we believed the project was ready for actually applying.
So based on that, would staff, so the pre-application process, I guess tell me if I'm correct, if the impression I'm getting is correct, that the pre-application process is something where an applicant is taking comments from staff, going back and forth and using those comments to further their design, planning, etc.
Yes, I think that's accurate. We would have also identified, project non-starters, fatal flaws at that time in the pre-application and advised the applicant to avoid those.
Okay, and I guess you had compared this pre-app to a building permit pre-app, for example. It sounds like this pre-app is comparatively more involved from a negotiating and conversational standpoint than a building pre-app. Is that a fair comparison?
Yeah, I think there are a number of ways it's different, and I'll list those just very briefly in case it's of use. I think it is a much more complicated project to provide pre-application meeting notes around. We tended to focus on a specific aspect of the application during the pre-app. It often started with layout, use, kind of overall project massing, if you will. So where the storm facility might go, where the road facilities might go, where the uses would be located. That required a significant amount of internal conversation. And then after the pre-app, of course, I was keeping staff on my side of this conversation, if you will, apprised of these pre-apps. So I would brief my then supervisor, Susan Cesar, or depending on which director was present, Cameron Garral or Jeff Thomas, as to the nature of the pre-application meeting. And that was iterative, so there will be multiple versions, multiple iterations of that pre-application meeting as we refine the project design.
When you were working on the UZDPs that you testified you worked on, could you describe for me, I asked you about the applicant's role a little while ago, and you've touched on the staff's role, but I'd like you to maybe focus on how you understood staff's role to be based on the UZDP code. Is it a question, is it like a applicant submits a question and you give an answer and then the applicant goes and figures stuff out on their own, or is this a series of meetings that you come together? Talk to me about how you handle that role.
So I do not simply, in a pre-application meeting in particular, I do not simply answer questions on a more complicated project. If an applicant has a question, I'm happy to answer that. So if the question is, what is the front setback? Of course, I would tell them. But the purpose of the pre-application meeting, in my understanding, is to provide the applicant with sufficient guidance that they can successfully submit an application that complies with the town center plan, the town center code, so they'll have a successful project at the end of the day. And that required, when I was at Spanish, a more affirmative role for the city staff. So we would be advising the applicant of concerns or project flaws that should be proactively addressed. I also have an opinion around project design, and I would occasionally share that with the applicant. I would try and be very careful to couch that opinion in, this is just a Evan's opinion, not a city code requirement, so that was clear. But overall, what I'm trying to describe, of course, is a collaborative process in the pre-application to ensure that the project is successful in meeting the town center code and the town center plan. One last thought, if I may, Ms. Koloskova. That also included, there were proposals by TRF Pacific and I believe by the Ichijo project that were not consistent with the town center plan or consistent with the town center regulations, and we would advise on that as well. So this was not, it was collaboration both in the positive and the negative sense, where we were establishing boundaries.
You asked my question I was going to ask you. So I guess then when you come into the application, when you get the application in, it sounds like that's already something you're expecting to see.
Yes,
that fair? Okay.
my recollection was that there was actually a product of the pre-application meetings whereby the city documented that we thought the applicant was ready to apply for the UZDP application. And that was kind of the touch point before they then finished the pre-application phase and moved into the actual application phase.
When you were at the city with those pre-application meetings, was it your practice to document pre-application meeting notes?
Generally, yes. There were occasionally pre-application meetings where we received very little information from the applicant, and it was more in the nature of a speculative discussion, and those conversations sometimes did not have notes.
Okay. When you talked about the range of UZDP, sort of the development of the UZDP planning process, was it your expectation that the UZDP, by the time it was approved in these various projects you worked on, would have like an engineering level of detail, a more rough level of detail? Where on that continuum would you expect that to land?
So I would not expect the UZDP plans to have a construction ready level of detail, which is how I normally interpret engineering level of detail, meaning that UZDP plans that were approved would typically not include things like the crowning of a road and the angle of the road down to the curb line, for example, which is an engineering detail. I would expect that the plans would be sufficiently engineered to be an accurate representation of what we would expect on the ground. So we would have road widths identified, we would have street improvements identified, bike lanes, sidewalks, perhaps curbs, landscaping location, things of that nature. In my experience, that level of detail was analogous to what we would see at a preliminary plat, but it would include the building footprint dimensions and the building elevations, at least in concept detail. It would also identify signage location, drainage vault location, drainage system design, things of that nature. It just wouldn't have that final component to allow for construction.
Would, I guess, things like, well, let me use ADA compliance as an example. How would that compliance fit into the UZDP review?
So at the time the UZDP was approved, I believe we would have identified the location of accessible, or pardon me, ADA compliant parking stalls and accessible lanes of travel or through the site. I'm thinking now of the TRF Pacific project. We likely did not have the specific gradients, the landing requirements for accessibility identified on the plans at that time. We would have identified route and reviewed it sufficiently to ensure that it could be built, but perhaps was not fully designed.
Okay. Would your answer be the same for other guidelines like crime prevention, I guess lighting specifics?
Yeah, yes, it would be the same answer. The UZDP plans, the intent of the UZDP product was to ensure that the project was such that it could be built in a form that largely was consistent with the UZDP approval. Items like SEPTED or crime prevention through environmental design would be noted, but the detail of how that design would be accomplished might be deferred to a later date. For example, I can recall that on the Plateau 120 project, we had a discussion related to the lighting standards in the parking lot. The lighting standards prevent the adjacency of very bright areas and very dark areas, primarily for safety. We did require a conceptual lighting plan, and I believe even an estimated I'm forgetting the proper term for the plan, but the document that reflects the candle light at any given point on the site, so that we could document that there were no dark pools relatively close to the light, the brighter spots on the site. The actual fixture design, the light pole itself, could have been specified at building permit or at a later phase.
Okay. If you had more questions about a lighting design, is that something that you could raise in terms of comments on the project, or?
Yes, if we had a concern about, pardon me for interrupting. If we had concerns about the project's ability to comply overall with Title 21B, that normally would be brought up during the project review. If it was something where we believed that compliance was possible, simply not fully documented, we would note that compliance would be required at a later date, for example, as part of the building permit. And Mr. Examiner, for clarification, I'm using the term "we" here because, of course, during project review, I was part of a staff team. So in the context of a drainage review or a street review or something of that nature, I was relying on the project engineer to help me identify when we might have a compliance issue. This was not something where I have the personal expertise to identify a civil engineering concern with my background.
Sure. Thank you for the clarification. So I guess whether you want to use the TRF project or not, can you describe, you've talked a lot about the pre-application and the process overall, but you haven't talked much about staff's role between application and approval or and the final outcome of a UZDP. Can you talk about your personal understanding of that while you were working at the City of Sammamish in your capacity as planner?
So when I was at the City of Sammamish, acting on the review of either the Ichijo, well, of any of the three projects, the planner typically acted as the project manager for the city's review, meaning that the planner was the primary point of contact between the applicant and the city. There were, of course, contacts between the engineering firm for the applicant and the city's engineering review staff. But the planner was typically the primary point of contact. So I was certainly engaged directly with the applicant for the TRF Pacific project or the Ichijo project in terms of advising them on the project review status. I'm hearing a dog in the background. I don't know.
I'm hearing a dog too.
Hang on just a minute. It's from outdoors. I'm going to blank my camera so I can lean over the system here. Come on. During the forced recess, I went out and looked out front. They're repaving the street, so they were out there grinding 2 inches of asphalt off the street. And now the dog started to bark. It sounds more like he's yelping, so I hope the heck they didn't grind the dog. I don't know what's going on, but I've shut my window. That should keep the dog noise out. I apologize. Back to Mr. Maxim.
Thank you, Mr. Examiner. I apologize. I have lost my train of thought in the.
We'll let Ms. Koloshkova start it over again then.
We were talking about, and I think you may have been done with your, or getting close, but we were talking about your role as the planner in the UZDP process between application and ultimate outcome.
Yeah, so the last item I'd add to that role for the planner when I was engaged in reviewing these projects is that we did maintain fairly constant contact with the applicant team around the project review. So if, for example, in the TRF project, we spent quite some time talking about how the public pathway would move through that site, or public access would move through that site. And this was the subject of my recollection, numerous phone calls between myself and the project representative for that application. I would this was the approach I was using.
Okay. You commented, you've used terms both collaborative and discretion in your testimony so far. When you talk about staff discretion, can you tell me more about how you see that, what staff's discretion is maybe under code as you process these applications, or what that looks like?
So I believe the staff discretion under code is referenced in 21B95.
I'm
Apologize,
sorry, we're getting a call now.
phone going off in the
My
background.
phone is, that's not my phone.
Is that,
It's a phone at the house I'm at, which is
oh,
I believe it's been
life
answered. I
is
apologize for
imperfect.
the interruption.
Dogs, phones, servers.
Ms. Kloska, I apologize. I've entirely lost the question.
You were just testifying as to staff's role and talking about collaboration and discretion under 21B95 is what you were just saying.
Yeah, so I believe staff's role, the review itself mechanically, I believe, is described in 21B95 in terms of the UZDP process. I believe there are other sections of the municipal code that describe the pre-application process. The nature of the UZDP approval is discretionary in my mind, in that we are reviewing the application against both the town center code, and then I believe you'll see if you examine 21B95, there are specified town center principles and flexibility provided to staff, which is the nature of the discretionary review. So the approach I used in reviewing these projects was to identify where I thought the city had discretion that it could exercise and where I thought the city did not have discretion to exercise. These are the guardrails I was alluding to earlier. For example, I believe that the city did not have any discretion in the review of a UZDP plan to authorize single-family home construction within the A zones. This was clearly a prohibited item under 21B20. I do believe the city had discretion around some of the design standards related to building layout, building facade, even the location of the uses that were allowed on a specific site. And by way of example, the TRF Pacific site has, I believe, a combination of TCA and TCB zoning designations. The B zone generally was intended to have less commercial development, and the A zone was generally intended to have more commercial development. And to some extent, that was modified through that UZDP process. And I believe I described the rationale as to why that was the case in that decision. And then, again, this is, so you asked about both discretion and collaboration. What I described a moment ago was the discretionary aspect. The collaboration aspect would have been essentially the city and the applicant working together to draw a connection between the town center plan, the town center principles, and the application at hand to provide the appropriate justification as to why a modification to the overall layout made sense, would further the town center plan goals or policies.
Okay. Talking about the town center plan for a moment, since you've mentioned that you're familiar, I believe you've testified with that document, correct?
I am familiar with it. I have not spent a lot of time with it in a few years.
Could you pull up, I'm going to ask my associate Dean Williams to pull up a section of code 21B95060. Oh, we need, okay.
Mr. Examiner, if it's acceptable, I have the code available on my local computer, and I cannot read the code that Ms. Goloskova has
This may
shared.
not be worth.
That's
Yeah,
fine.
sharing is hard.
I have it on my computer too, so I'm looking at it on the screen to my right.
Thank you much. And just for the record, I have a single screen, so if I'm staring blankly into the video screen, it's because I'm trying to toggle. I apologize for that. I'd like to direct your attention to section 4 of 21B 95060. Mr. Maxim, do you see that one?
I do.
Okay. And in what manner did you apply that approval criterion to the UZDPs that you reviewed? Was that
Objection is to the form of the question.
and if I can finish my question.
What's wrong with the form of the question?
There's no foundation that he applied this section to which of the two UZDPs that he says he directly reviewed. And I especially given what he has said his role was, I think it's important to establish whether he did or not before we start asking questions as if he did.
I can break it up a little bit.
Pardon me?
I can break the question up a little bit. It's fine.
Okay, go ahead.
Thank
Just
you.
for the record, I was going to overrule the objection, but if you want to.
I'll break it up a little bit and make life easier for Mr. Eglick. That's fine. So Mr.
Well,
Maxim,
it's not a question of easier for me. It's a question of the form of the question. It's not easier for me, but if you would like me to suggest what make it easier, it would be to establish what zones he was dealing with in the two projects that he reviewed.
I think he can ask those questions on cross.
Let's go ahead and ask him your question.
Thank you, Mr. Examiner. Mr. Maxim, in your work reviewing UZDP proposals, was it part of your job to review and apply 21B 95060 of the Sammamish Code?
Yes.
And was part of your job to review and apply subsection 4 of that code?
Yes.
And for any of the 3 approved well, let me back up. During your tenure, did the city ever deny a UZDP proposal?
No.
During your tenure reviewing and supervising review of proposals, could you describe how you applied subsection 4 of 21B 95060 to projects?
So 21B 95060 is one of the criteria for approval of a UZDP. That criterion reads the goals and policies. So, pardon me. Read in full, the city will evaluate UZDP applications and approve them only if they meet the following criteria, is the lead-in sentence. Item 4, the goals and policies of the town center plan. In reviewing the UZDP applications, I was also reviewing the town center code and the town center plan to ensure that our guidance to the applicant and that the project itself did not move away from what I understood the town center plan to describe and seek to achieve. Mechanically, I no longer recall what I put into the staff decisions related to either the Ichijo project or the TRF Pacific project. My typical approach at that time would have been to cite the specific criteria and establish specific conclusions around how the project complied with that criteria. But as to whether or not I listed out every goal and policy in the town center plan and then addressed that goal and policy in the decision, I think that's unlikely, simply because of the length of the town center plan, goals and policies, and the length of that decision at that point. However, it would have been part of the review and part of the decision considerations on those two projects.
Did you, in the town center plan, are the goals and policies, as you recall them, all perfectly compatible, or do they address competing concepts potentially?
Objection is to the form of the question. That's getting into, I think, testimony that's in the nature of expert opinion as opposed to his work on particular applications.
Overruled.
So the town center plan does have goals and policies that are in tension or compete with each other. As I recall, the town center plan had goals and policies related to natural systems and the preservation of natural systems. It also had policies related to pedestrian connectivity and frankly, mixed use development or residential development. If only one of those policies was fulfilled to its fullest extent, say pedestrian connectivity, you might end up with no consideration of how to protect natural systems, wetlands, streams, things of that nature. So there's naturally a balance between, or a necessary balance between the protection of wetlands, streams, and providing pedestrian connectivity that's realized in a UZDP plan or any project approval, in my experience. Mr. Examiner, I answered a question a moment ago from Ms. Koloskova, and I realized I did not provide a fully complete answer. May I go back to that question?
You may.
The question from Ms. Koloskova, I believe, was whether we had ever denied a UZDP project. My answer at that time was no. I should clarify, we did have numerous UZDP application conversations at the pre-application stage, and often the response there was negative, meaning that we advised the applicant that their project would not be successful, and so the application never came in the door and was never denied. This was part of the function of the pre-application process. It's not a formal denial subject to appeal to a hearing examiner, and we were always clear about that in the pre-application. But when I said no a moment ago, it might have indicated that, might have been understood to indicate that there were only 3 applications that came in the door and all 3 were immediately or over some period of time approved, and that would be inaccurate.
Thank you, Mr. Maxim. Did you finish? So you were answering questions related to the town center plan. And I'd like to just finish up on that. So if there were competing goals, like you were talking about, what was staff's role to review, I guess, how best to sort out competing goals? What was your role, excuse me, during your tenure?
So my role was to be very familiar with the town center plan and the town center code and do my best to advise the applicant around how to address those competing goals during the project review. And that advice at that time was informed by my participation in the discussions or listening to the discussions by the City Council and the Planning Commission around the town center plan documents or the town center code.
So if you had a concern about certain goals, you would have taken those back to the applicant, or you would have just held the info?
If I had a concern that the project did not comply or did not sufficiently address certain goals or policies within the town center plan, I would have conveyed that to the applicant. And in fact, that's what often happened in these pre-application meetings I alluded to a moment ago.
And then that would give the applicant the opportunity to respond as they may see fit.
Yes, and in some cases that meant the project did not proceed.
And in other cases, you would have worked with the applicant further?
Yes, if the applicant was willing to modify to address the concern expressed by the city, we would have sought to advise them on how to do so. That if the concern, Mr. Examiner, I don't know that I can speak to this other than hypothetical, because I'm not confident at this point that it was within the specific experience that I had during that period of time at the city of Sammamish. So I'll note this is a little bit hypothetical, but if we had conveyed to the applicant.
I'm going to object again. We are straying into hypothetical testimony is clearly in the nature of expert testimony, and we object to this witness rendering expert testimony. He's a fact witness on the limitations in the subpoena. Thank you.
I can respond if the examiner wishes.
No, I'll sustain the objection. Let's just stay with real things and not hypothetical.
Okay, thank you. Mr. Maxim, you were going to use a hypothetical, but did you otherwise complete your answer?
I believe I was responding to a question of if there was a conflict between the goals in the town center plan and a specific project, how was that conveyed to the applicant? That would have been something I would have conveyed on the part of the city to the applicant and required that the applicant address in some fashion.
And that would have been in like a review comment or a meeting or any particular form?
Depending on the nature of the concern, it could have taken the form of a phone call, a meeting, an email, written comments, written review letter. So in the case of the TRF Pacific project, we were talking about connectivity through the site. That is a principle in the town center plan, and that was certainly conveyed through all three means, phone call, email, and in meetings.
I'd like to turn your attention next to briefly section 21B 95050 of Sammamish Municipal Code, and I'm not screen sharing this, so if everybody can pull that up on their screen. Are you familiar with this code section, Mr. Maxim?
I am.
And could you please just read to yourself for a moment, refresh your memory on the introductory language before subsection 1? And with that, could you tell us when you worked on UZDP, the three UZDP approvals, excuse me, let me rephrase that question. While you were reviewing UZDP proposals for the city, what was your understanding as far as how you were to implement that code that section 050 based on that introductory language?
The introductory language notes the use of the word should and provides guidance around how city staff should interpret the use of the word should in specific standards contained within the town center code. Section 1A discusses incorporating that mixed use nodes should incorporate a network of pedestrian and bicycle connections. So as I would have interpreted that we needed to have those features within an application, a project application, unless there was a compelling reason not to do so.
Okay, and I'm not asking you to step through each of the individuals. If you want to use that one as an example, that's just fine.
That was my intent, is to use this example. And
Just
I would have used the same
answer
approach elsewhere, yes.
Yeah, okay. So again, we're going back to that iterative process with these principles.
Yeah, and so if the project applicant had proposed something that was not consistent with the town center plan or town center code, part of the staff review would be to determine whether or not the city had language like the should in the standard, or if it was, by way of comparison, a shall statement. If it was a shall statement, generally there was no flexibility to grant to the applicant. If it was a should statement, there would be some flexibility that would be available to the applicant.
And when you talk about standards, are you referring to, what are you referring to there? Are you meaning the design principles or something else?
Both the design principles and the specific design standards. So those would include, design standards, of course, would include things like 21B 25, which I believe includes setbacks, other regulatory standards as commonly understood.
Okay. And is it your perspective that if something is, if a standard is going to preclude some particular consideration, that would be stated in code, or is that part of that, I guess, design principle flexibility?
Objection. Again, we're having generalized expert opinion testimony. We have no foundation that this was addressed in a particular UZDP. I think there's two that Mr. Evan was the planner on, and we're now just having him provide expert opinion.
I would like to clarify that the subpoena is not limited to Mr. Maxim's role as reviewing applications, but in fact expressly explains that it is supposed to be addressing code in terms of the role of the UZDP, level of detail, permitting sequence, etc. So the examiner has asked him to come here to provide his knowledge on those bases.
If I might respond, I think the STCA has required him to come here through a subpoena from the examiner, but the subpoena is, as I understand it, and I think if not, then we have our continuing objection, supposed to be limited and tied to his particular experience. And we have no court reporter, so I can't have the last question read back, but it was not tied to that. It was a generalized question. Sitting here today, what do you think about this? And that's not what his testimony is supposed to be about.
The last item that I listed in the subpoena, it's on page 2 of the subpoena, just above the signature, says, and the understandings and guidance that informed your, meaning Mr. Maxim's, decisions in the 3 UZDP applications which you approved on behalf of DCD. I think the question that's been asked is within the scope of his understandings and guidance that informed his decisions. Objection overruled.
Mr. Examiner, may I ask that at least a foundation be laid that the questions that are being asked even came up in the applications, the 2 applications that he reviewed?
Yes, I'll give you that. Even if he says
Thank you.
even if he says it didn't come up, however, it may still be within the scope of his understanding and the guidance that he received. So, Ms. Koloshkova, do you want to start with a rephrasing maybe, or a preliminary question?
I think Mr. Eglick has been successful in his derailing of my questioning because I don't remember my question anymore. I wish there was a court reporter as well. I understand the city has 2 recordings going. Perhaps that second recording has a transcript going. Is that possible?
I don't know, but I do object to the characterization of anyone derailing anything. This is what attorneys do. Mr. Roos did it quite a bit himself, and I did not impugn his motives.
Okay, folks, let's tamp it down, please. I don't want to let anything get out of hand. So, Ms. Koloshkova, you may ask your question.
I truly have forgotten it. So I'm going to move on to other territory.
Then ask a question.
Unless Mr. Maxim calls my question. I don't think it was all that important.
I'm sorry,
I
Mr.
think I was
Escobar.
following up. Pardon
Ask
me.
a question.
Thank you. So, Mr. Maxim, we were talking about 050 and the applicability of that. And so I think I'd like actually to move to a particular section of that, which is, I'm scrolling down, I apologize. Subsection 4, that's entitled Open Spaces. And if you could just have that available, I don't have any questions about that immediately yet, but I did want to loop back to that. So are you familiar with did you ever, in working on the various town center project materials, work on a concept called a city square?
No.
Okay, then let me orient you. Do you know if there is a concept of a city square in the town center plan itself?
Objection.
I'm
State the
asking if he
objection.
knows.
State the objection, please.
He didn't work on the city square, and therefore he's being asked for opinion testimony on something that apparently he didn't even work on.
I asked him
So
if he's familiar with the concept of the city square in the town center plan, not if he had worked on the city square.
Well, again, I think we're getting beyond testimony having to do with what he was involved in into things where we're asking him to give expert opinions, which was, I thought, ruled out as where we were going in this testimony.
Don't believe the examiner made that ruling. If he did, I missed it.
Unless Mr. Maxim received guidance regarding what to do with City Square if it came into a project that he had to review, then I think Mr. Eglick has a point. And I would sustain his objection.
Okay.
Because Mr. Maxim has said none of his projects, UZDP projects, involve the City Square.
So let me go back to, if I may, Mr. Examiner, subsection 4, the open spaces. And Mr. Maxim, as part of your work on code, was that part of, I guess was that an area of code that you worked on with your group that you identified at the beginning of your testimony?
When I was involved in the discussions around the town center plan and the town center code, I was familiar with that term and was part of those conversations. It was not related. It was not relevant to the UZDP applications that I processed.
Okay, thank you for that clarification. And were you familiar, or did you work on these concepts of a green spine that are talked about in section 4?
I was part of the group conversations around the green spine referenced, I believe, in the town center plan. I believe there's a similar set of terms in the infrastructure plan and in the code. I made a mistake a moment ago in responding prior to Mr. Eglick filing his objection. My familiarity with the term square came from my familiarity with the town center plan and the infrastructure plan, where I believe the term square is sometimes used instead of green spine. I tend to think of it as a green spine in the context of the town center plan conversations I was involved in many years ago.
Okay. Was there with the green spine, could you describe what the concept was that was trying to be embodied with that type of feature in the town center?
I believe it's fairly heavily described in the town center plan and probably to a lesser extent in the infrastructure plan. I believe it was intended to be a common green space available to the public. In some concepts, that green spine or that green space would also be used as potentially a place for low impact development. So possibly stormwater infiltration, a community gathering space, things of that nature. It was intended to be a public amenity within the town center.
And how would that be implemented through the UZDP process, or was that intended to be just a solely city feature that the city was going to, I guess, create itself?
So during the—
I'm going to object as to the form of the question. We seem to be straying into Mr. Maxim interpreting the code. He can talk about what he understood. He's not even talking about other people, but he can't be asked to just simply get up and give a college lecture on the meaning of various provisions. We object.
Mr. Maxim has testified to a number of aspects of code and how the group arrived at certain concepts, processes, and town center considerations. This is no different than all that other testimony that's been provided.
Well, with all due respect, I don't think he has testified as to how these materials were arrived at. He's mentioned a few other names, yes, but that's about it.
I'm going to sustain the objection based on Mr. Maxim's testimony that the city square was not involved in any of the UZDPs that he reviewed. And frankly, my own knowledge in looking at the plan and looking at your three exhibits, because Mr. Maxim, you may not know this, but STCA has submitted as three of its exhibits copies of the UZDPs for Ichijo, Plateau 120, and TRF. So they are in the record and I've seen them. And I realized that none of them involve the green spine. Just physically, they're not where the green spine was shown. So I think we should stay away from having Mr. Maxim seek to opine on that.
Okay, thank you. No problem. So, Mr. Maxim, I just then want to, pretty close to wrapping up my examination, Mr. Galt. I just want to make sure that I've touched on all my questions of various topic areas. Mr. Maxim, so let me just finish up with a couple questions on the UZDP. So with the applications that you worked on, what does the final product of an approved UZDP look like? Is it like a stamped plan that gets recorded or a written document? What does that look like?
Well, it sounds like they may be in the record, but there's a staff decision. There are a number of exhibits attached to that decision. So those exhibits would typically include, my recollection of the TRF Pacific project, for example, would have included plan sets. It would have included technical reports relevant to the project, traffic impact analysis, SEPA determination, largely a body of documents that describe what the city is approving. And then the staff report, of course, documents what the approval was, what terms were established around the approval, and the basis for that approval and code, and based on the site facts.
Did you work with the applicant before the approval to talk through various conditions or any, I guess, lingering concerns that you needed to address in those documents or needed further addressed later?
I certainly did that on the case of the TRF Pacific project, and I believe I did that with the Ichijo project. My recollection of the Ichijo project is less clear, but I believe I can. The approach I used as a planner at the city of Sammamish was largely to inform the applicant of anticipated conditions of approval on any land use decision before issuing the decision. So it would have been consistent for me to then do the same on those two project decisions.
And would you have given the applicant an opportunity to comment if there was something they think they couldn't accomplish or could have been addressed differently?
I certainly would accept comments. I would not necessarily modify the conditions in response to applicant comment.
That certainly makes sense. Okay, let me just, last questions. Right. Could I just have a 5-minute break? I'll review my notes and then I might have 1 or 2 more questions and I'm mostly done.
Okay, it is 10:45. We're at recess until 10:50.
Thank you.
This conference will now be recorded.
Thank you. It is now 10:53 a.m. on July 14, 2021. This is the start of session 12 in the appeal of UZDP 2019-00562. Ms. Koloshkova, you thought you might have a couple more questions for Mr. Maxim.
Thank you, Mr. Examiner. And I actually am done with my direct examination. Thank you very much.
Okay, thank you. Mr. Reglick, do you wish to ask any questions of Mr. Maxim?
Yes, please. Before I do that, can I just ask for planning purposes, was the technology malfunction our morning break?
I think so. I mean, it's
Yeah, for me.
it's close to 11. It isn't going to be very much longer before we're going to have a lunch break.
Okay, I just wanted to get a sense of the schedule. I'm a little disappointed, but I will proceed.
The schedule's all messed up.
Yeah, right. Well, and hopefully the technology holds out. So should I go ahead?
Please.
Okay. Mr. Maxim, I've seen your name, you've seen mine, so you probably know already, but I am one of the attorneys for the city of Sammamish, representing it in this appeal hearing. So good morning to you, sir.
Pleasure to meet you, sir.
So did you do any preparation for your testimony here today?
So I did not do any specific preparation. I have not reviewed code other than in this hearing itself in the last several days since I disengaged from the applicant as their consultant. Prior to that, I had done some research back in mid-June when I was engaged by STCA. I advised the hearing examiner when I became aware of the subpoena that I did not intend to do more research prior to my testimony this evening, or pardon me, this morning.
So, so you said you did some preparation when you were working as a consultant for the applicant. Is that an accurate recounting of what you've just said?
Yes, Mr. Eglett.
Okay, and what did you do then?
I reviewed some of the application materials submitted by STCA. I reread portions of the town center plan, the infrastructure plan, and the town center code.
And did you take any meetings or have any meetings? I'm not sure what the right verb is.
I met with the applicant's representatives, Ms. Kloskova and Mr. Roos, going off memory, I believe 2 or 3 times. and that would have been over the span of time between April and June.
I'm sorry, you were a little muffled toward the end there. I heard June, but there were a few words before that I didn't hear. If you could maybe repeat them.
Of course. I met with the applicant representative attorneys, so Ms. Koloskova and Mr. Roos, 2 or 3 times between the period of April and June. I did not engage in substantive work after approximately mid-June. I was actually on vacation when some of the most recent events occurred, and when I returned from vacation, I ended my engagement with the applicant.
So when you say you met with the applicant's attorneys, were there any other people there?
No, there was myself, Ms. Koloskova, and Mr. Roos.
Was the city attorney for the city you work for now, CTAC, there?
No, they are not my representative in this matter.
Okay. And when you first met in April, had you reviewed anything prior to that first meeting in April with the applicant's attorneys?
Objection, I'm not sure April's been discussed.
Oh, I'm sorry. Well, when was your first meeting with the applicant's attorneys, Mr. Maxim?
Mr. Maxim, I'll let you go ahead and ask your question, but for clarity, Mr. Maxim has now said twice that his time of work with STCA's representative started in April. So, Ms. Koloskova, you missed him saying that. He did say he started work in April. Mr.
I am
Egley?
going. Oh, sorry. I am going to interject an objection, if I may. I believe Mr. Eglick has argued multiple times this witness is not an expert witness. It is uncommon, if not, I'm not sure it's ever happened that a opposing counsel asks about meetings from a fact witness before this examiner. So I'm not sure what the purpose or foundation is for going down this line of questioning.
Well, I don't, should I respond?
Please tell me the purpose.
Okay, first of all, it's not uncommon to ask a lay witness about preparation for testimony, but second of all, the purpose is to assess how much of what Mr. Maxim is testifying to is independent recollection and how much perhaps was prompted, gleaned, I don't know what the right verb would be, from, it sounds like, was it 2 or 3 meetings with Ms. Koloskova, Mr. Roos, when they were using him as a consultant. So that's what I'm trying to assess, or at least have the facts out on the record.
I'll allow it. Objection overruled. Do you remember the question?
I apologize.
I think.
I don't.
Go ahead. I'm sorry.
He said he didn't. Ask him a question, Mr. Eglick.
Yes, sir. Well, let me start with this. So was your first meeting with the counsel for STCA in April, Mr. Maxim?
I believe I received a phone call from Ms. Koloskova in April asking me if I'd be willing to be engaged as an impartial witness, an impartial opinion related to their application. At that time, I notified my current place of employment as required by that place of employment. That is where my April date recollection comes from, the date I notified my current place of employment. I do not recall the specific date I first met with Ms. Koloskova and Mr. Roos. It would have been likely near the end of April or early May.
Oh, go ahead. I'm sorry. I apologize. I have a bad habit of stepping on your lines. Go ahead.
Not at all, Mr. Eglick. At the time I was engaged by the consultant, pardon me, as a consultant for STCA, I did keep notes. I may have in my notes those dates. Once I ended my contact or contract with STCA, I stopped taking notes.
And when you met with STCA attorneys, did you bring any materials with you to the meeting?
No, I did not. The meetings were virtual like this. So they were video conference or phone call meetings.
Did they share any materials with you that they wanted you to review?
They indicated that they would like me to review specific aspects of the decision and specific aspects of the code.
And did you review those specific aspects of the code?
In large part, I reviewed up until, again, I ended my engagement as their consultant. That occurred in early July, again, after I returned from vacation. In terms of substantive work, I had not done any substantive work since mid-June.
And were any particular perspectives or interpretations of the code or the other city materials suggested to you as ones that warranted your attention?
I was asked to focus on specific aspects of the review and of the code, and I did do so. Interpretations of those materials, I did not hear specific guidance from the attorneys. What I was relaying to them in those meetings was my interpretation of that material.
Okay, thank you. Go ahead, I'm sorry.
Apologies, Mr. Eglick. I had a final thought, which was just that it was somewhat similar to the testimony I've offered today in terms of my observation, how things worked when I was there.
And have you reviewed the decisions that I think there were two you said you actually were the direct planner on and one you supervised? Have you reviewed them in preparation for your testimony?
No. Okay. No, I am relying on my memory alone.
Okay. Okay, and thank you. I appreciate that background. You mentioned several people in your testimony. One was, and I just want to, I think I know who all these people are, but the record doesn't. I suspect the examiner does too, but the record doesn't. So I just want to make it clear who they are. You mentioned Susan Cesar, and could you just tell us who she was or is?
She was the Deputy Director of Community Development at the City of Sammamish. She is now, I believe, retained by the City of Des Moines, and I do not know her title.
Okay. So she was someone you were supervised by, is that correct?
She was my boss, yes.
Okay. Then you also mentioned Cameron Gural. I think I thought you maybe mentioned him at some point, didn't you?
I did, yes.
And I think he's now with King County, isn't he?
I believe that's correct, yes.
But what was he when you were at the City of Sammamish?
He was the Director of Community Development.
So he was kind of, go ahead.
Cameron Gural was the Director of Community Development at the time the Town Center Plan and the Town Center regulations were drafted. He left the City of Sammamish approximately in 2013, and I believe during some of the review of those, the two projects I've referred to in this testimony, I believe I was reporting to, the director was a man named Jeff Thomas, and I do know where he's currently located.
Okay, so I think that was another name I had. I was just going to ask you to place him. So Jeff Thomas at one time and Cameron Gural at another were directors of the Department of Community Development in Sammamish. Is that correct?
Yes, sir.
And so they would be supervisors as well of your work, maybe perhaps removed by one level. Is that correct?
That's correct.
Okay. And then you also mentioned Michael Mathias. And what was his position?
He was the Town Center project manager during the development of the Town Center Plan and I believe the Town Center Code. I do not recall whether or not he was still the project manager at the time of the infrastructure plan.
And to your knowledge, since you were there, what did it mean to be Town Center project manager?
I believe he was managing the development of the Town Center Plan and the Town Center development regulations at that time. he was the project lead around that project.
So you were a participant, but Mr. Matthias was actually the project manager, the project lead for the city. Is that correct?
Yes, sir.
Now, do you recall, and I'm going to ask maybe later about this, but do you recall preparing a video presentation or participating in preparation of a video presentation of what the town center plan would look like when realized?
Yes, I do.
And I want to call it a flyover. Is that a fair description, or what would you call it?
Yeah, I think it was a flyover is probably accurate. It was a graphic rendering of what the town center may look like as conceived. And I do not recall what year that was put together. This was work, I think, that was done by a consultant. My recollection is Maya Hadlock, who had put this together to help the community visualize what the town center may look like if built out.
And what was your role in that?
I believe I was the person who was responsible for managing the consultant work. So I believe I supervised that consultant contract, in short.
So would that reflect then your thinking at the time of what a realized town center would look like?
It would have, yes, it would have reflected one of several options. It was intended to be a representation of what the town center plan would result in. It was not the only version of that could have been created, but it certainly was intended to be a representative version.
And that was shown to the public, wasn't it?
I believe it was posted on the city's website for quite some time.
Okay. Let me just go down a few questions here. Now we've got some basics out of the way. You mentioned the process for adoption, and I think, or actually the participants, or maybe the word is stakeholders, I don't know, in the adoption of, for example, the town center code. And you mentioned the planning commission and the city council. Were they involved before or after your participation in those processes?
It would have been effectively concurrent. So the planning commission was reviewing. So we would have developed draft code for planning commission review. There would have been internal review and planning commission review occurring concurrent with one another, meaning that you had staff feedback informing the drafting, and you had, of course, planning commission guidance. Once the planning commission made their recommendation to the city council, the staff feedback and editing was largely complete. My recollection in particular of the town center code is that was reviewed in chapters, and we have had, for example, a discussion occurring before the planning commission around the design principles in my recollection is 21B30, while we were also as staff discussing the entitlement process, which would be contained in 21B95. So
and I'm sorry, I didn't mean to interrupt you, did I?
I was becoming repetitive by noting that it was concurrent again.
Okay. And then ultimately the final decision on what to adopt was the city council's, is that correct?
Of course. Our intent was to, yes, support the city council in their actions.
And you were asked a question about how you looked at the UZDP process and the code adopted for it. Do you recall that?
Yes, I do. And
you recall you used a term as to say, well, this is how I looked at it, and you used a term to describe it. Do you recall what that term was?
Not specifically, Mr. Eglick. I've provided a fair bit of testimony, so I'm not sure what you're alluding to.
I think you called it was an administrative conditional use. Is that what you said? And I've been trying to take notes on the fly here, so I was hoping you would say it so I didn't have to say it and be wrong.
I appreciate it, Mr. Ecklich. I believe I was referring to it as an administrative development agreement.
Okay, all right, fair enough. Thank you. So there is such a thing as a development agreement, right? You're familiar with that in state law?
Yes, I am, sir.
And to your knowledge, and maybe you're not familiar enough with Sammamish code to say, which fair enough if you're not, but Sammamish doesn't actually have a provision adopting the terms of, I think it's RCW 3670B, isn't it?
I believe it is RCW 3670B. I'm not aware of a development agreement provision in the Sammamish Municipal Code.
So I guess I'm wondering, from your participation at the time, if this was going to be, this UZDP process was going to be a development agreement process, why the council didn't just say, well, here's our development agreement process. Do you have any information on that?
Objection as to the form of the question. If he's asking about what council was thinking, he cannot testify to that. He could testify if there's foundation laid to show that there were any discussions with council that he was participating in and personally recalls.
Given
I'll be happy to rephrase the question. I'll be happy to rephrase.
Please.
Mr. Maxim, do you have any recollection of discussion with the council about adopting a development agreement provision rather than a UZDP provision? Let's start with that.
No, I do not recall that type of conversation with the city council.
Was there any discussion at all that you can recall about with the council about the UZDP being a form of development agreement?
No.
Okay. So can we go for a minute to the decisions that you were involved in, UZDP decisions? And I'm looking for my notes here. Of course, I won't be able to find them, but were any of them in what's called the, well, do you know what the CMU is?
I'm not familiar with the CMU as the acronym, no.
Isn't that core mixed use? Is that, I think that's a town center term. I could be wrong, but are you familiar with that term?
I believe the witness just testified he's not familiar with the term.
Well, I just asked the initials before. I now gave him the 3 words.
So I'm familiar with the terminology town center core, which was typically referred to as the TCA 1 zone when I was at the city of Sammamish.
Okay, and you've never heard a reference to core mixed use zone, anything like that?
Not that I recall now.
Okay, fair enough. So you were involved in approving 2 projects, UZDP permits, and then one, I think you said you supervised the planner on it. I hope I have that right anyway. Is that correct?
Yes.
Okay. So, and one was you used some initials, is apartment building with mixed use. I think you said, what are we calling that one?
So that project was the TRF Pacific project, which was located to the west of 228th Avenue, north of Southeast 4th Street on that northwest corner of that intersection. And it extended westerly up the hill on Southeast 4th Street to effectively the top of the hill.
And then there was Plateau 120, which is the one you supervised. Is correct?
Yes, sir.
And then there was another one that had townhomes, I think you mentioned. Is that correct?
Yes, sir.
Okay, what do we call that one, the one that had townhomes?
I understood the name at the time was the Ichijo project, ICHJ.
Oh. Yeah, thank you. I'm sorry. I missed that in my notes. Okay. Which one of those is, well, let's start with Plateau 120, which is the one you supervise. What zone is that in?
I am not certain. I have not re-reviewed the zoning map for Town Center in preparation for this meeting. I believe the...
And you don't... Go ahead.
Answer.
Pardon me, Mr.
Yes,
Eilert.
sir.
I believe the decision that it sounds like is in the record would note the zoning designation for that site. I do not recall it.
Do you recall whether any of the decisions of the three you say you were involved in one aspect or another, or one respect or another, were any of those in the A1 zone?
I believe the TRF Pacific project included some of the TCA1 zone and some of the TCB zone.
So it was split, is that correct?
I believe that's correct.
And that's the only one?
I do not recall whether the Ichijo project was in an A zone or not. It's been too long.
And do you recall whether anywhere in the, I guess whether we call it CMU or core mixed use, or any in the core zone, termed that way?
I believe the westerly extent of the TRF project was in the TCA1, which I understood to be the town center core at that time.
Okay, thank you. I think that you're clearer on that than I am. I appreciate it. So you were describing the process for pre-application interaction with the applicant, and I think you said that the purpose was to get the application ready to be submitted. Is that correct?
I believe that's correct. I believe I also testified that we were trying to advise the applicant during the pre-application process around how to comply with the adopted town center plan and town center code, such that it would be ready for application.
So for the two applications you were directly involved in, did you ever have an occasion when your comments, advice on behalf of the city to the applicant were not followed? Yeah, certainly on the TRF Pacific project, the applicant initially resisted the idea of providing public access through that site. That was an item that we discussed both through the pre-application phase and into the entitlement for that project. And how did that come out in the end?
I believe the city prevailed or required the pedestrian connection through that site. The exact specifics of how that pedestrian connection was memorialized. So specifically, my recollection was that we were looking for a public access easement through the site on effectively private property. I believe the applicant was expressing a concern around liability. I believe we did require an easement in the end. The specifics of that easement I've forgotten at this point.
And did the applicant ultimately submit a compliant application that the city was then able to approve?
So I don't believe Mr. Ecklich, I'm relying on my memory, so I want to make that clear. I believe the applicant reflected the pedestrian connection through the site, and the condition of approval on that project required some form of an easement along that pedestrian connection. So when you ask if they submitted a compliant design, a fully compliant design would have included the easement documentation. I believe I instead required the condition of approval, or established a condition of approval, which the applicant ultimately didn't challenge.
So let me focus on that a bit. I think what you're saying is that the plan, and I don't know how to put this, but the plan showed what physically you were requiring, which was an easement, and then documentation was required later as to the legal specifics of the easement. Is that correct?
I believe that's accurate, sir.
Okay. And any other circumstances in which the city gave direction, you gave direction, and it was not followed?
So specific to those two projects, none that I can recall.
Yeah. So you never really had to deal with the, for example, and tell me if I'm wrong, put A here, and what you got back was A being put there.
So I did deal with that type of situation, but it was not on those specific projects. And by way of explanation, Mr. Eglick, we had numerous pre-application meetings for the site immediately to the north of City Hall, west of 228th. Those, I believe, were also A-zoned sites. And often during the pre-application, what I as a city staff person heard is that for that project to make sense economically, we needed to provide flexibility that the town center code actually did not allow us to provide. Because we provided feedback that would not be something the city could approve, those applications never moved past the pre-application stage while I was at the city.
It sounds like, if I can make a characterization, you were talking about collaboration, but it sounds like it's collaboration, but with a firm bottom line in mind that the city in the end would have to make the discretionary decision.
Objection, I believe.
Yes or no?
Objection.
Is that correct?
Counsel testifying.
No, he's asking him, objection overruled.
Yes, that's correct.
Okay, thank you. I'm sorry, I'm going down my notes here, so it'll take me a minute, but I think it will save time in the end. How many, I think for the two applications we're talking about that you were directly involved in, is the decision, I realize probably signed by the director, but you were the direct contact and decision maker with the applicant. Can you tell us on those, how many pre-application interactions you would have had, whether it's a meeting or a phone call or however that would be?
I don't know if I could give you the exact number. My recollection was it was 3 or 4 pre-application meetings before the actual application came in the door.
And would one of those 3 or 4 be the, I'll call it the formal pre-application, that process that's required under the city code?
Yes.
And the others would be, the other pre-application interactions would be leading up to that. Is that correct?
Yes.
And then on the projects that you worked on again, how many application iterations did you receive? In other words, formal submittals before you issued a decision?
I don't recall again a specific number. Usually it would have been at least one or two. It could have been more.
When you say at least one or two, it'd have to be at least one, wouldn't it? Because you have to get it and look at it. So that's the one, right?
Perhaps I misunderstood your question, Mr. Eglick. Once the application, I understood your question to be related to the number of review cycles I engaged in. The review cycle to me includes a request for more information from the city, a applicant response, likely meetings and conversation between those two events. So one cycle in my answer was intended to reflect one round of review comments and a response by the applicant. My recollection is I went through that once or twice at least with TRF, and I don't recall how many times with EGJO.
Okay, thank you. And would you say on the one that I think you said TRF is one where there was some review, how did you present your comments based on your review of what had been submitted as the application?
So as the project planner, I would have issued a review comment letter that would have encapsulated the planning review. It would have included any other reviews that were complete at that time. So typically a engineering review, a fire review. There was some building discussion related to TRF and the project massing to ensure that the project could be built in a safe way. Those were, the building comments were very low level. Those would have been conveyed typically in a written form, so a Word document emailed to the applicant. We would have had subsequent conversations with the applicant by email, by phone, perhaps in person. That was the approach generally I used and the approach I recall using on the TRF and the EGJO projects.
Okay, thank you. And I think one example that you talked about earlier was on the level of detail on, or level of information on plans. With regard to lighting, I think you said something about you would want to know what the, was it candlelight? That's what I wrote down. That can't be right. Candlefoot, maybe?
It was probably candlefoot. I probably said candlelight, Mr. Eglick. I struggle with.
I'm not sure you did. Whatever it is, what were you talking about there? Because my notes are garbled.
I think the term is foot candle.
Thank you, Mr.
Okay.
My intention was to describe that during the review, we would require sufficient information from the applicant, we being the reviewing staff, myself included, sufficient information from the applicant to be confident that the project could be built in a way that was compliant with the city code. Foot candle, is a term that was used in the town center code at the time I conducted that review, and it related to how bright a parking lot and pedestrian space was adjacent to relatively dark areas. And this ties in both the illumination standards within the town center code at that time and the crime prevention through environmental design standards, or CPTED standards, that were present in the town center code at that time. So my point in that statement was that we would have required documentation that the project could comply, but all of the detail related to fixture design, post height, specific electrical plan might have been deferred to a later date building permit or an electrical permit.
And would the documentation include information that would provide assurance. I think you referred to dark spots. So would you need information, documentation that you could assess and say, okay, there's no dark spots?
I think we'd need enough information to confirm that the eventual construction of the site would comply. So if there was a reason to be concerned that there would be a dark spot relatively close or adjacent to a very bright spot, that could be addressed. The specific means of addressing that type of situation could be handled at the building permit. So by way of example, Mr. Eglick, I believe those decisions included a condition that the following building permits would comply with the applicable local, federal, state regulations in effect at the time of vesting. Those regulations, of course, would include the illumination standards. And this was a way to ensure ongoing compliance, even if there was not entirely a detailed lighting plan at the time of UCDP approval.
And could you look again at 21B.95.050, which I think you discussed with STCA Council? Do you have that handy by any chance?
I have that on the screen in front of me, sir. Okay,
terrific. And I think you had talked with her a bit about the introductory paragraphs. Do you see where right under where it says UZD principles, and then right under that there are two unnumbered introductory paragraphs?
I see that, sir.
And do you see where it says is required unless the city determines that there's a compelling reason to the contrary, et cetera, based on the objectives and policies of the adopted town center plan? Do you see that?
I do see that.
So what's your understanding of that as you applied it in your work for the city? Who gets the final word?
Well, my understanding of this section is informed by the following sentence, which notes that is to allow the city and proponent the flexibility to achieve the town center plans and these principles objectives through other means than those specified below.
And the following sentence as well?
In the following sentence as well, of course. Would you like me to read that into the record, sir?
Well, yeah, I'll just read it for you to save time. The UZDP proponent shall be required to demonstrate that the following are met to the city's satisfaction. The city's satisfaction means essentially the department's satisfaction, doesn't it?
Objection. I think we're straying into the territory that Mr. Eglick already objected to with this applicant testifying as an expert.
I didn't object on the questioning on this section.
You objected to any testimony related to his interpretation of code outside the context of a particular application.
Not on this section.
No, but she's making the point that in general you objected, and I will sustain the objection.
Okay, fair enough. I'm almost through my notes, but it just occurred to me, perhaps, could I then move to strike, because my notes here show that the specific questions about his interpretation of should in that section we were just talking about in 050. So if I can't ask follow-up questions about that language, can I move to strike the testimony that he gave on that language?
I didn't write notes down about it, but my recollection is that he basically just read the code and said that's what it meant. I don't see anything to strike.
Well, I'll leave it on the record, and we can deal with it later, depending on what we see argued.
That's fine. Let's go that
Thank
route.
you. Okay. So you did use the term discretion at one point in your testimony describing the staff's decision-making role. Did you recall that, Mr. Maxim?
I do, sir.
And you also used the term flexibility in describing your understanding of the staff's role.
Yes, sir.
You recall that? But is my understanding of your testimony that the staff has the discretion to be flexible, but within what, at least at the time you were there, was understood to be the parameters of the applicable code, plan, and so on? I mean, is that how you would harmonize that, to use a word you used, I think, in another context?
So the flexibility, as I understood it, was to achieve the city council's intent behind the town center goals and policies. And there were specific guardrails around that flexibility that are called out in the town center code. So flexibility in that context would be, an unforeseen design aspect, which may not be exactly compliant with the town center code, but would further the intent of the town center plan's goals and policies. And that's
when you're referring to unforeseen design aspect, you're referring to something you encountered in the applications you were involved in?
Yes, for example, on the TRF project, there was a discussion around the location of the commercial aspect of that UZDP, and we did provide flexibility around where those commercial components were provided or were placed, because it was understood to further the city council's intent behind the town center plan.
So what was the issue there?
I believe the bulk of the commercial square footage allocation was assigned to the TCA1 zoned property on the west side of that project. There was some allowance for commercial space within the TCB zoned property on the east side of that project. The applicant proposed shifting some of that commercial square footage from the TCA1 zone into the TCB zoned property. Following review of that UZDP plan in its entirety, staff ended up supporting that change in or that modification to the allocation of the commercial square footage.
And was it your understanding that the decision on that change was something that the staff was compelled to approve, or something that the staff made the discretionary decision on?
My understanding, it was the latter, and that was in response. The staff decision there was informed by the applicant's materials and information that were presented with the application. So we spoke a moment ago about collaboration and flexibility. This is the nature of the interaction between the applicant and the staff on that project. The applicant proposed something, and I was trying to determine whether or not we could approve it in the context of the UZDP process and the town center plan's goals and policies.
And what you said, the applicant presented materials on that issue?
Yes.
And do you recall what the materials were?
Specifically, no. I believe the applicant was making the assertion that their anchor tenant, which was Metropolitan Market at that time, really needed a corner visibility in order for that project to be financially viable, and they provided us with sufficient information to understand how that viability would benefit not just the applicant in their project, but also the town center plan.
And when you say sufficient information, did that include financial pro formas?
My experience with pro formas is that they're very hard to obtain from an applicant, but information equivalent to that, I believe, was part of that record.
And what would that be?
At this point, Mr. Eglick, I do not recall the specific materials. I do recall that after reviewing those materials, we were convinced that it was necessary for the project to succeed and that it would be valuable to the city in terms of an economic activity in the town center plan. But the actual form of the materials, I don't recall what those were.
But I guess I'm asking not so much about the form as the substance. In other words, you were given specific tenant and financial information that supported the case for the reassignment?
Well, I can't tell you that because I don't recall clearly at this point. So I don't recall the specifics of that information.
And I take it then that let me go out in another direction. The decision to allow what you're describing in that case was not made on the basis of a bare, this is the way we want to do it request. You required some substance, including in terms of financial information, the form of which you don't recall. Is that a fair statement?
I believe that's accurate, Mr. Eglick.
Okay. 1 minute. Okay, thank you, Mr. Maxim. It's been a pleasure to meet you, if only over the internet.
Pleasure to meet you, sir.
Thank you, Mr. Eglick. Ms. Koloskova, do you have any redirect?
Yes, thank you, Mr. Hearing Examiner. On that last point, Mr. Maxim, so you had asked the applicant to share more information regarding that Met market, I guess, viability or financial analysis?
I believe I did ask for additional information related to that. The timing, I believe that occurred during the actual application versus the pre-application stage. I just truly cannot recall the form or even the substance of what convinced us in the end.
So it was an ongoing dialogue during the application process that
Yes.
you were engaging in?
Yeah.
Okay. You didn't just deny the project?
No, I did not.
Did you ever deny, you mentioned there were UZDPs that did not move forward. Were you ever in a situation where you were, no, strike that, going nowhere, I apologize. Sticking with that project, you provided some testimony related to an easement. And you mentioned that you had put together a condition related to a public easement that you had been, I guess, negotiating. Is that a fair statement with the applicant?
I believe that's, so yes, I did say that, and that is my recollection of that project. I have not reviewed the project decision in quite some time.
Okay. And I don't have any questions about the specific, but do you recall if you actually required the applicant to record an easement before you issued the approval?
I don't believe we require the recording of the easement prior to the UZDP approval. It would have been required during the construction process, likely prior to occupancy of the buildings.
The plans would show kind of where that easement might go, and then the actual recording would come after the approval. Is that fair sequencing?
Yes.
If the use had come up that you had a concern about, is that the sort of thing you would have talked about at pre-application?
Yes, that did come up in the properties I alluded to the north of City Hall. We did have some uses that were proposed that were not allowed. And I believe we conveyed that to some of the applicants at that time, or some of the prospective applicants at that time. And those projects did not proceed.
And I guess I'm belaboring this question about this public access component of the TRF project a little bit, but that was not a green spine requirement for that project?
No, this is, again, my recollection, this was related to the pedestrian circulation through that site.
Okay.
And trying to ensure that there was access for the public to move through that site, not just, specific tenants or users of the facilities on that property.
Okay. Right, thank you. That's all my questions. I don't know if the examiner had questions now that came up.
No. I've decided with the subpoenaed witness, discretion is the better part of valor, and I'm not going to ask any questions. Mr. Reglick, do you have any further cross?
One question, if I might, please.
Go ahead.
Mr. Maxim, I'm back, but hopefully only briefly. Were any of the applications you were involved in call for use of city property?
So, no, I think not that I can recall, at least, Mr. Eglick.
Okay. And on this easement that we're talking about, was an easement over private property in the control of the applicant. Is that correct?
That is correct.
Okay, thank you.
That it?
Yes, sir.
Okay, thank you. And thank you very much, Mr. Maxim. I appreciate your honoring our subpoena and appearing here with us this morning.
Thank you very much, Mr. Examiner.
The subpoena says you're to stay here until discharged by me or some such language. I don't remember exactly. Does either party see any reason why I cannot discharge Mr. Maxim?
No objection.
No objection.
Okay, Mr. Maxim, you're free to go.
Thank you,
or
sir.
you can stay and watch with us if you want.
I think I'll resist the temptation. Thank you, Mr. Examiner.
Oh, okay, you're welcome.
Maybe I should add one thing here. We're hoping to display the flyover that Mr. Maxim mentioned as part of our city testimony. It was a city prepared item. I think it's a short minute or two video of some sort.
An exhibit number?
It doesn't have an exhibit number because this is something we've more recently discovered subsequent to realizing that Mr. Maxim was actually going to testify and trying to do some research. So if we need him to identify it, perhaps we can make some arrangements to do that. It is apparently something that was displayed. I don't know whether Mr. Maxim said this or not, but it was apparently displayed on the city website. So there is a chain of custody for it, so to speak.
I would hope, sincerely hope, and I guess I'm hoping on Mr. Maxim's behalf more than mine because it isn't going to affect me, but I would sincerely hope that you can find some other way to authenticate it rather than having us have to pester Mr. Maxim for that function. He can't authenticate it now because you don't have it to show us. He can't say, yes, that's what I'm thinking about, but maybe there's got to be somebody
I'm getting signals here. What?
Getting a breakup too. I think we're back. It's like on Mr.
We
Golf.
may be able to display it. I'm sorry to interrupt. I apologize. I'm trying to do two things at once here.
I just don't want to have Mr. Maxim have to come back.
Neither do I. I absolutely, totally agree. Mr. Sugg, is that something you can call up on your machine there?
Can we first talk about why this document hasn't even been disclosed until this morning? And I guess certainly the applicant's objection as to both relevancy and why it hasn't been raised.
Let me forestall that kind of back and forth between you two. There is a provision in the rules of procedure that says that materials for rebuttal, even though the city has this little rebuttal thing in the week before the hearing, there is still the paragraph in there that says that rebuttal materials don't have to be pre-filed. And so I would be accepting it as rebuttal generated as a result of Mr. Maxim's testimony, and I'm not going to have a quibble over it, but we probably do need to have it authenticated somehow.
And I would just, if I may, for the record, lodge my objection as to the relevancy of it as well.
Yeah, I'll decide relevancy.
Thank you.
We have objections to testimony on relevance basis. We'd never be getting much of anywhere in a lot of.
I hear you. Thank you.
Mr. Sugg says he can show it. Is that correct? And it's not very long, is it? 3, almost 4 minutes. Is that okay if we just have Mr. Maxim say whether that's what he...
Let's watch it now, get it in. I will enter it as Exhibit 50. What do you want this thing called? ECP video or schematic?
Flyover, maybe? Flyover video, maybe? People are smiling here. I don't know whether that means it's a good idea or a bad idea.
I don't know either. Let's watch it and we'll name it afterwards.
Yes, sir.
Oh, it's on YouTube. It says it's 3 minutes and 51 seconds. So once it gets going.
Is this dated 2016? Is that right at the bottom?
Let's. June 8, 2021 City Council meetings, what that says.
Okay.
I think that has to do more with YouTube, I think, than when it was prepared.
I presume there's no audio. Is this a silent movie?
Oh, now there's music, apparently. Did you do that, Mike, or is that really there? Oh, okay. That's it.
Okay, I would describe it as a conceptual town city potential development video.
Good evening,
City,
Council.
does that work? Who said that?
It was the video, apparently.
Oh,
Oh, Mr. Sugg says that the YouTube auto played to the next video, so it was yeah.
we won't ask him
More
what it
technology.
was. Okay, let me just
Should I
ask,
ask Mr. Maxim?
either you can or I'll just ask him, is that the video to which you were referring in your testimony?
Yes.
Does that do it?
Yes, please. I mean, yes, thank you.
Now may I excuse Mr. Maxim?
Of course.
Okay, Mr. Maxim, you're excused. Again, you may stay if you wish, but you are certainly free to leave. The video that we just looked at is entered into the record as Exhibit 50, and lacking a better name for it, I'm going to call it a conceptual town center potential development video. Something like that. Okay, thank you. It is 11:59. I know on our schedule running to 8, we would have our noon break at 12:30, but let's not be stuck on formality. Let's do our noon break now, since this is a logical breaking point. We'll call it 12 o'clock, and we stand at recess until 1 o'clock for the noon break. We'll reconvene at that time and continue with Mr. Brennan. He'll be the one we'll be finishing his testimony. So we are at recess.
May I ask a question?
We're not at recess. Mr. Eglick.
Yeah, and I'm sorry. I'm just trying to plan the rest of the day. Is STCA planning on completing its witnesses today?
Depends on Cross, right? I have about 45 minutes, an hour with Peter Eglick left. Peter Brennan. Too many of the same names.
I'll be happy to be cross-examined.
We would have fun. And then we have Holly Hebron. The problem with Holly Hebron is that she has daycare. She has to pick up. She has to take care of that. Okay. So we have Holly Hebron, and we had Curtis Koger. I will let everybody know that he is he's okay. Okay. I was gonna say he's in the Miss Amma area, and there's a big fire going there, but I think he's okay. So Holly and Curtis are very limited topic areas. I would love.
Wasn't there another witness? I thought.
That's all we're bringing.
So there was someone from Shook Kelly other than Mr. Zinser, wasn't there? Or am I imagining that?
We had him listed.
Oh, okay. So, but in other words, 2 more witnesses and you're done?
After Mr. Brennan.
Got it.
You haven't had cross-examination of Mr. Brennan yet, so my guess is we might be able to finish them by 8 o'clock tonight. Because remember, this is an 8 o'clock night. That's a guess.
I think I'm tentatively thinking I'm not gonna, because there are some issues. I don't know that I may just tell staff plan on starting first thing in the morning rather than having to stay here till 8 on the chance they might get on for a few minutes or something.
If
We
the
agree
examiners,
then if
yes, absolutely.
STCA completes its direct before 8 o'clock, we will break and restart tomorrow morning at 9.
Yes, we're fine with that.
Yeah.
Okay.
Thank you very much.
Can we go to lunch now?
Ross,
Yes?
for an hour?
Okay. I have 12:02. We are at recess until 1:02.
Thank you.
This conference will now be recorded.
Thank you. It's now 1:04 p.m. on July 14, 2021. This is session 13 in the appeal hearing for UZDP 2019-00562. We are at this time returning back to our testimony by Mr. Peter Brennan. Mr. Brennan is with us on the screen now. Ms. Koloshkova, you were asking him direct questions when we broke off last evening. Mr. Brennan, I remind you, you're still under oath. Ms. Koloshkova, proceed, please.
Thank you, Mr. Examiner. Mr. Brennan, do you recall roughly the category of, or the topics that we were talking about when we wrapped up testimony yesterday?
Well, I think we were getting pretty close to the end there of when we had had some final meetings with the city, and we prepared, we were in the final stretch there of doing our application. We had 4 applications at the time that we were submitting on, and we ended up submitting those on the 4th of November 2019.
Okay. So, and I guess, how would you characterize I guess the quality of the submittal process at that point in terms of your ability to communicate and coordinate the application materials?
Yeah, I mean, I think we had, from my perspective, we used the pre-app notes as basically the substantial notes that helped guided us to for our application and what the city was looking for further information on as part of the UZDP. We felt that we had done a good job of complying with those notes. We also used those notes as a basis for our concurrency submittal, which it's kind of sequential. You basically have the pre-app, which then you need the pre-app to do your concurrency. You need the concurrency as a portion of your application submittal. So, so we felt all those were in alignment.
Okay. And does the current concurrency require, I guess, does the concurrency require any sort of expression, or does it rely on uses that are being proposed?
Yeah, the concurrency. Sorry.
Pardon me.
Okay, so the concurrency, yeah, you identify the uses so that then when our transportation engineer then submits that to the equivalent of the city's transportation engineer, the uses are identified, so then the 2 engineers can discuss what those uses are. So then ultimately, when it goes into the concurrency model, the city is aware then it is modeling it correctly. So I guess by means of an example is if you said that we were going to put in, let's say commercial space, for example, if you said you were going to put in, yeah, we submitted on 82,000 square feet. If you said it was all office, that has a different traffic impact than if you said it was all restaurant.
Okay.
So they have different impacts and amount of I guess trips is how the concurrency model is generating. And so So yes, so we relied on our pre-app, we relied on our the amount of residential units that we pre-apped on, and we relied on our commercial uses that we pre-apped on.
I'd like to go to Exhibit 9. Dean, can you pull up page 22 of it? Sorry, can we make Dean be able to share exhibits again, please? And I'm going to Exhibit 9, page 22. Thank you.
He now can share.
I guess actually, let me start, Dean, pardon me, with page 6. It's Exhibit 9. I don't, maybe the share screen, Mr. Examiner, is just more of the hassle than it's worth. If we're looking at the actual physical documents, I'd be directing everyone's attention to page 6 of Exhibit 9, document entitled Pre-Application Conference. And Mr. Brennan, do you see the chart on that page?
I do.
And does that chart address townhomes?
It appears to, yes.
Okay, and does it has information as to the use and the notes related to that use? I don't need you to read it. I just want to direct your attention to that.
Yes.
Okay.
It is a permitted use with restrictions, and then the restriction has to be set back 30 feet from the sidewalk.
Okay, and then let's go to page 22 of the same document.
And I think that we need to show townhome setbacks from the sidewalk 30 feet. I think that the only addition to that 30-foot setback is on pedestrian-oriented streets.
Okay. And then let's go to page 22. And at the bottom of the page is item number 3. Is that a question that you had talked with staff about?
Yeah, so on our application, we were trying to just get some clarity on some of the townhome product that we had pre-apped on, and we wanted to make sure it was okay to front townhomes onto a common courtyard. And then we also had Wooners as well depicted. And so we just want to make sure that that was an allowed use for the city.
Okay, and was the city's response there, was that clear to you, or did you have any questions about that response?
No, I mean, it appears that the buildings organized around the courtyard can orient to the courtyard provided there's clear pedestrian access between the courtyard and the street. So using the courtyard as an access point to get into a unit and out to the street, or vice versa, seems like it was allowed.
Okay. Did the city at any point during the pre-app or up to at any point during this time frame leading up to the application communicate that townhomes were in any way not an allowed use?
No, that would have changed things dramatically for us.
Okay, but you did talk about the city expressing hesitations about townhomes yesterday, didn't you?
Yeah, so it's kind of hard to describe because I don't have the pre-application plan. Is something we can look at here, but where we had, I tried to explain this yesterday, where we had block 4 in the pre-app, it had townhomes abutting the city square. And I think if we go to the comment from Parks, I want to revisit that on page 19. That was where comment number 4 on page 19 of the pre-app. That's where Parks was, really wanted to get a better idea of how that could work with the townhomes abutting the city square, and that's where that was that I saw was the design issue that the city was mostly concerned about.
Okay. So after, and then you testified already. We don't need to go into this. You had several meetings that don't appear to have notes per se, but you testified about in the fall. At that, I guess during any of that continuum, did you see any reason at that point to do another formal pre-app meeting with the city?
No. I mean, of all the indications and meetings that I had with them, as well as with my consultant team, that we were all moving forward with a formal application, that there was nothing that was a particular roadblock or something that was substantive to not proceed with that.
Okay, and did the city ask for any more pre-application meetings?
No.
During that time frame, or I guess at any point, has the city asked you for information about, I guess, marketability of products or economic feasibility of the plan?
No.
Okay, so I believe you testified, as is in the record, that you submitted the application on the 4th of November.
That's correct.
And you began, I think this is exactly where we left off with your testimony, as you were just about to describe the next steps, or you were in the process of describing those next steps of the review timeframes and application processing components that came next. If you could just summarize those briefly for us and what your role was related to those.
Sure. I mean, I think, you know, with the first one being the application submittal on the 4th, I think for us, it was quite a big milestone because we felt like we were at a point with the city that they really wanted to see an application so they could make some formal comments, and that this was the beginning of a more collaborative dialogue with the city. So we were excited about it. We felt that the application itself had met the requirements. It was in alignment with our pre-app, and then we had addressed the comments that were in the pre-app so that we could, we could continue the dialogue with the city. We certainly by no means thought it was that we weren't going to get comments and there weren't going to be subsequent rounds of comments, but we certainly thought it was a good start. After the submittal, there was some coordination with the city, just in communications around trying to, it's called a letter of completeness. So you submit your application, and then the city has an intake, and they take all the documents in, and then the city will then review the documents, as I understand it, from a cursory level, just to make sure the documents are for that particular application, have a are relevant to the application. But really, it's not a deep dive into the documents, just to make sure that all the things that are requested as part of the application are indeed in the city's file. So, and then once you get that letter of completeness, that is then the trigger for the city then to start their formal review of the application. So there was some communication with Chris Hankins about that, and just kind of trying to gauge that. And we finally, I believe, got
and just to be clear, I want to be a little careful about the passive tense. When you say there was communication, it's you having the communication.
Yeah.
Okay.
I mean, I was definitely reaching out to Chris on a couple different dates there in November, just to try and get my arms around status of the application. In conjunction, Chris and I were also talking because we needed to have a neighborhood meeting, that's part of the UZDP application process. So, sorry, there's two components. There was a neighborhood meeting for our Brownstones West plat application, and there was an open house necessary for our UZDP application. So we had two different public events for the city to review our applications and provide public comment. public comment is also another component that is important, that you are underneath a public comment period for a portion of time after you submit your application. So, so in conjunction with trying to understand when the letter of completeness would come out, I was also working with Chris on coordinating for our open house. And that's where we would provide some imagery for the public, and the public was invited then to City Hall to view our boards, ask questions directly of the applicant. And then the city had also set up some computers there to allow public comment to be entered directly into the system for the city then to include with our application comments. So we received, I believe, our letter of completeness on the 27th of November. We received a notice of application on 12/2, and that is a formal document that then vests our application, as I understand it. And then we, we were then kind of under the impression from early December discussions that the city would take about 60 days to review it, and we would get comments back. And you know, I guess there was, I think on 12/12 when we were at the neighborhood meeting, Chris did mention that he had never seen a project like this in his career that had been so political. So that was kind of an interesting comment. The 12/16, we had conducted that neighborhood meeting, and then really we didn't hear much then after the neighborhood meeting. From there, the city went and did their review, and the next thing we really had formal communication on was on 3/10 when we promised.
I want to pause you there because I want to go back. In my notes, I wanted to clarify one thing, so I'm taking you back in time just a tiny bit. With the pre-application, can you please tell me specifically, because I want to make sure we're clear, what you had to say, what the commercial and residential disclosures were on that concurrency application? How many square feet of concurrency, how many residential units, and do you break those residential units down in the concurrency certificate?
So concurrency is interesting. We applied, well, we did our concurrency on 357 residential units, so 300 apartments and 57 townhomes. For concurrency purposes, though, when they run the traffic model, that's all considered multifamily.
You don't have to share it. Okay, got it, great.
And then, so then the breakdown commercial was 82,000 square feet.
Right.
And I believe that was broken down into, give me a second here, retail. It was broken down to retail, restaurant, and then there's another category called high volume restaurant, I believe it is. Again, I guess we would have to refer to the exhibit on the concurrency.
We can go ahead and pull up the concurrency certificate just real quick. It's exhibit 10. I think that might be helpful just to look at. And exhibit 10, there we go. Okay, so it looks like there's a summary of that in the middle of the page there, if you can see the share screen.
Yeah.
That doesn't seem to have the breakdown you were referring to per se, but that's your
there was a letter issued by the city that I submitted with the pre-app, which I believe is probably it's in that, or there's a letter that was submitted with the application in November 4th that I think is giving that breakdown. Give me a second here. 13S.
S is in Sam.
That's correct.
I see. Ooh, boy, that is hard to read.
Yeah, so that didn't print well, but so I can come back. I can get through it though. I think it's 56,000 in retail. I don't know.
It looks like, do I read this correctly that you actually have listed 57 townhome on here?
57 townhomes and yeah, we applied on 357.
Okay, 357, and that's the concurrency is on the next page on this document as well. Is that right?
Certificate.
If you turn to page 3. There we go. Okay. All right.
Can we go back to that prior page?
Over.
The one with the print overs? Yeah. Let me tell you what I think I'm seeing just on unit counts. I don't care about the impact fee at this point, but I'm seeing single family -4, which would be a credit, I presume, for 4 residences on the property.
Yeah.
And they see residential 30.
So
shopping center.
I have a clean document from my files, so I can help hopefully shed some light on this.
Okay, what's ITE code 231? Is that apartment?
ITE code 231 is
It'd
townhouse.
It'd be the third row.
So it's 231 is townhouse, which at 57. So it was single family residential -4, 210, 220 is apartment at 300, 231 is townhouse at 57.
Slow down.
Sorry.
So 220 is apartment, and that's 300.
That's correct. 231 is townhouse at 57.
31 townhouse, 57.
820 is shopping center at 56,000.
Shopping center, 56K.
931 is quality restaurant at 22,100.
Quality restaurant, 22.1.
High turnover restaurant at 3,900.
High turnover. And that's 3,900?
Yeah.
Okay, thank you.
No problem.
Okay.
And that's 13S, correct?
Correct.
Is it
Correct.
possible for us to resubmit that cover page or a clean?
The examiner can let us know if he needs that.
Okay.
And that was pardon me.
We're good.
Okay, thank you. Okay, Mr. Brennan, let's go back then to, you can pull that doc down, thanks. I apologize for that bit of a historical pause. So when, I guess after you testified, you had the open house, did you receive any communications from the city before you received their written comments in March of 2020?
No, we never, we didn't get, I guess I'll phrase it in regards to if there were no questions that the city wanted to further discuss with us in regards to our application, how we interpreted something, why we made a design decision the way we did, anything to provide any further background on our application.
Okay. So the next substantive, I guess, touchstone with the city is the written set of comments then, is that right?
Yeah, so on March 10th, 2020, we received comments from the city.
Okay. And is that reflected, just to be clear, in Exhibit 20 Do you have that exhibit, Mr. Brennan? I just want to confirm that that's the right material.
Bring this over to me so I can keep leaving the camera here. Exhibit 20. Yeah, Exhibit 20 is their plan review summary letter to me and as representative of the applicant, and then the subsequent documents there.
Here's the next later.
Comments.
Okay, and so what were your steps taken in order to review and address the comments? If you can summarize those.
Yeah, I think some of the comments I think took us, I want to say that did not seem to be in alignment with some of the previous conversations and some of the direction we had received. And so we needed to then, we wanted to have further conversations with the city about their comments so we could get clarification. And I think it's important at this juncture to make sure everyone's aware. I don't know how you would forget, but around that mid-March of 2020, as we all recall, the world changed quite a bit. I think probably around March 15th, everything was shut down and no longer was anybody, I think, fairly much allowed to be even in an office. The city, I believe, was officially closed to the public within 3 or 4 days of this letter being issued. So subsequent conversations were then all around on Zoom calls if we were to organize a meeting, or were on, or things were emailed. Phone became almost irrelevant because the phone numbers we had would go to the city, and then you leave a voicemail, and then you were relying on the city to call back. There was never an ability for someone to pick up the phone because that's no one was there. So it was just the communication side of things. It certainly had its challenges once we received the comments back.
But did you have enough information in those March comments that you could put together a set of responses and resubmittal materials?
Not by ourselves. I mean, I think there was things that the city all had taken a position on that were different than how we had seen the code or interpreted it. For example, their first section is around street topology, and the city wanted all of the TCA1 zone to be pedestrian oriented. And so that was the first we had heard of that. In the pre-app, it identified that they wanted to have pedestrian oriented segments, but they also have other notes in the pre-app about designating things as pedestrian oriented or mixed use and following those code sections that identify that. So that was something that had caught us off guard, and it was applicable to the entire TCA1 zone, which we were only applying in the southwestern quadrant, but that is now a peanut butter spread across the entire A1 zone to the north of Southeast 4th. So we were.
Do you know if that was new information to you? Had the other TCA1 project have to have only pedestrian oriented streets?
Well, that was new information, and And in a subsequent meeting that we had with the city, we tried to clarify that because the TRF project touched the TCA 1 zone. And we asked about that street designation in one of our follow-up meetings, and the city identified that that street was not designated. And so that was surprising to us, because if everything was TCA 1, first of all, why would that not be in the pre-app notes? It seems like it's a blanket statement, so it should be, that would have been easy to have identified in the pre-app notes, as every single thing needs to be TCA 1, or it needed to be pedestrian oriented. But then also, why wouldn't that have been a designation with TRF?
So when you say not designated, what do you mean?
Well, the street orientation, they said had not been designated per the TRF application. So they were not, it appeared that their street topology in that segment did not receive a designation, which in regards to the street orientation, that drives design. Drives design of how your sidewalk widths are, drives design of what's on the ground floor. It drives a lot of things. So that was not designated, therefore not driving design. So it just, to us, was hard to understand that position, since it was communicated that they all had to be in the TCA 1 zone, pedestrian oriented, and that also doesn't comport with the the town center adopted plan. In the plan, there is clearly mixed-use streets and pedestrian oriented. It calls for a hierarchy of streets. I'm unclear how a hierarchy of streets is pedestrian oriented only.
Okay. So that's one example you were giving as to questions that you and your team were raising as a result of the comments that came out in March. Did you have an opportunity to meet with staff virtually or have some phone calls about those concerns or questions?
We did have a meeting with staff virtually.
Okay. When was that?
When was that?
Yes.
Good question. We had 3 meetings with staff. They were, let's see, we replied in June, so I think I can get the, one second. I think we have in the staff response to the.
Perhaps we can look at page 3 of the decision. There's a list of key dates.
Unfortunately, that page 3 is.
Well, let me read you these dates, and you can tell me if these sound correct to you. May 14, May 29, and June 1. Does that sound right?
Oh, right. Yeah. Those are all. Yeah, those are all important.
Okay, so those were meetings. Were you part of those meetings?
I was definitely a part of those meetings.
Can you, so as part of those, were you able to talk through, have dialogue about the different comments that the city had provided?
Yeah, I wouldn't, I mean, the format for the meetings was a bit interesting. It wasn't something where we could go in and talk to the city and collaborate with them, I would say, and discuss kind of how we interpreted something versus how they may be interpreting something. The meetings were set up and we needed to provide our questions to the city relatively a week in advance. And the city then took those questions, and from there, I'm assuming that they directed those questions to the appropriate staff members to reply and formulate an answer. And then we were not given those answers prior to the meeting, and then we would go into the meeting and we would listen to staff read their answer to us. From there, we could ask further questions, but it certainly wasn't a collaborative process of working together. It was staff then just providing an answer to us, and if we had further questions on that, that might have elicited more dialogue on something. Sometimes it did. Other times there was nothing more to discuss.
So these meetings in your work then culminated in a resubmittal, correct?
Yes.
And is that resubmittal contained, I guess, for the most part in, well, I know the city was pardon me, Mr. Eglick had clarified earlier this week that there was a mix-up on one of the attachments to Exhibit 35. So presuming that mix-up is just incorporated in code with the design companion, that full set of materials, Mr. Brennan, was included in that Exhibit 35, is that right?
Exhibit 35 is our June 22nd, 2020. I think we identified a few exhibits that weren't part of that from the code criterion piece that we had talked, I believe that you had covered with Larry, but.
So there's been some discussion, and we referenced the document already, Exhibit 1031, the revised design companion. Was that document also part of your resubmittal in June?
Yeah.
Okay.
Yeah, but you had the design companion is, so just to kind of orient the hearings examiner on this, you have this design companion, which is, it's code, it's graphics, it's a lot of things. And to communicate to the city, it takes on a form that has a lot of graphics and whatnot. But when you get your comments from the city, they're all in an Excel spreadsheet. So the way the applicant had to submit back was we were instructed to reply back on the Excel matrices. So we did that. We put all of our answers there, but that doesn't really tell the story of what your response is. So then you have more of a graphical response. So then we put our answers from the matrices into a more graphical representation of that. And then you have the revised design companion that is now part of the submittal that incorporates all the comments and everything, but is now a cohesive document and reads like a narrative back to our original. So there were 3 documents that are really related to the code compliance, or basically the design companion, as we were calling it, just to kind of get everybody oriented on.
Okay, and if you could turn your attention just briefly to Exhibit 35H, as in happy horse.
Always. 35. Summary review matrix. All right, give me a second. That's a whole nother binder. All right. I've got it in front of me.
Okay, so is that document the Excel spreadsheet matrix response that you were referring to?
Right. So this is the Excel spreadsheet. It's pretty much all, it's going to all be words. It doesn't have a graphical representation sometimes that is necessary to communicate our response.
Or at least, I guess it's a table, perhaps. Yeah. Okay. So the binders. I'm sorry, we're having a colloquy about the document number, but we'll look. Okay. So let's go back to your cover letter, please. And is this a document that you wrote?
So the document was scribed by Steve Roos and then was worked on collaboratively by our team. So it was a collaborative.
Okay. And I guess the factual information in here, did that come from you?
Yes.
Okay. All right. So, and I just want to ask you about some of the factual information in here. I'm not looking for your analysis as to, I think there's a little bit of case law that's in here. And we're on Exhibit 35A.
Okay, thank you. That's what I wanted to know. 35A is an alpha.
Yes.
Thank you.
So I'd like to use, well, if you could tell me what was your purpose with providing this cover letter to the city, apart from all that volume of other information that you had already that you were providing separately?
Yeah, I think it's similar to what we were seeing from the city. The city would provide an overview letter, and this was a letter in response to their overview letter. So in their overview letter, they kind of highlight the major items that they're concerned with in the application, but then they go through all their series of very granular, detailed comments. We try to reciprocate with the same letter.
Okay. And in this letter, did you cover does this letter cover your thoughts and responses regarding the major considerations of the USDP proposal?
How we interpreted the major ones, yes.
Okay. So let's walk through a couple of these so that you can talk about both. I'd like you to address the city comment and where you were trying to go with the application based on this resubmittal. And we can start with page 2. There's a topic entitled Green Spine.
Right. Right. So the city, for the green spine, obviously, as we've had many conversations about this design element up to now, we know that it's important for the city. We wanted to, they were concerned about the green spine and what was actually going to be delineated for the city, and what the city and how we were identifying that on the plan. So that was kind of their first major issue. And so we identified that we would be dedicating a 12-foot pedestrian trail that would go north-south. That would be exclusively for public use. And then we had 19 feet on each side of that 12 feet, which equates to 50 feet, or basically the entire that green spine easement that we would create a public access and use agreement. And so and that's a component that was articulated as part of the secondary zone in the TCIP. So we're following that design guideline that may also be supported in the green spine companion. So that was kind of what we were basing those measurements on for our secondary zone there.
And then you were talking about easements that would go to the public related to those particular provisions. Is that
right? So there'd be 12 feet dedicated to the city, and then there would be 38 feet that would be accessible, but we would maintain it. So it would be privately maintained, but publicly accessible, I believe is how that was articulated.
Okay, and then there was also a discussion of additional public easement in your second paragraph there.
Oh, yeah. Well, also, so in addition, we're proposing to grant public easement for additional open space beyond the 50-foot green spine to be available for other public events and activities. So it's, yeah, so it's the idea is to make the space available for a vibrant mix of both public and private uses, and that there'd be further details in the public access and use agreement. So, you know, we wanted it to be a multi-purpose area. And so we needed to have, we have areas for private because we have that courtyard area, or I should say green spine area that is bookended by the two buildings, would have, it's a pedestrian oriented space. So it would have uses and retail uses and restaurants is how it was envisioned. Those things would be on the edges, and then there would be uses in the middle that could be for public and private.
So did you feel like you had sufficiently responded to the city's comment regarding more delineation of the public versus private use areas?
I mean, yeah, we felt we did. I mean, we felt like we had covered that and tried to, but we also, you know, invited the city too, in the last sentence of that second paragraph. We invite the city to further discuss that. I mean, I would think it requires further discussion. It's a public-private use agreement. So.
Okay. And is this also where you talk on the last paragraph there about your choices regarding the city square component?
Yeah, so the city square was a component that came back on the application comments that also was one that was a little surprising because the comments from the pre-app, we were discussing city square in the Notch property. And I think if you recall my testimony yesterday where we got comments from Parks about that. They were concerned about the townhomes abutting that city square property, and it required further discussion. We tried to have that further discussion with the city, talk to them about enclosure, talk to them about how we could design a space together that could flex for the city events, how it could spill out onto the commons. Lots of benefits there, accommodate regional stormwater. And then that conversation got cut off with the city. So when that changed our direction with the application in regards to omitting that area, those two blocks east and west of the city square.
Right.
So we can have further discussion about that.
Okay.
So we wanted to have further discussion about that, and that's where we left that and thought we were leaving that with the city. But then the city comes back in this comment section and says, well, the city square needs to be north or south of Southeast 4th, and really taking some language from the TCIP as to that direction there. And that was not where we had originally left it, I thought, with the pre-app.
And so when you comment here about north of Southeast 4th, had you disclosed that STCA had an ownership or control over the area north of Southeast 4th? Do you know if the city was aware of that?
I guess.
It's okay if you don't know.
I think along the way we had been fairly transparent with the city after we had achieved a certain level of aggregation that we had a lot of property. I mean, they were aware that we could be citing things on our property because we had aggregated quite a bit. And so, and I think we made sure that it was clear. I think we wrote it in this letter actually that we cited it on STCA property. So if they weren't clear, the letter certainly identified that.
Okay. And then finally on Greenspine, you responded, it looks like on the following page, relating to the amount of hardscape.
Yeah, so once again, we refer back then to the TCIP and I'm assuming the Green Spine Companion to identify some percentages there for the secondary zone, which we were calling it the secondary zone, because the city square then was, per the TCIP, was in the primary zone. So we were identifying the city square north of 4th as a primary, making our section south of 4th then a secondary. And then we were just following softscape and hardscape for the green spine and those percentages.
Okay. So
and
the letter,
and we do say, once again, we do note in that section that we would be happy to discuss it further with the city. You know, take into consideration, please, that this is the first time anyone's applied on anything in the green spine. So it lends itself to more discussion because you're now dealing with the different levels of documents that we have, and we'll probably have 3 or 4 different design guidance documents or code or standards that we're all trying to work with to get to be compliant with the green spine.
okay, and I believe there has been a fair bit of discussion as to the green spine from the standpoint of the revised design companion and the project narrative in exhibit 1031, excuse me. I don't need to go back over that. But was it your impression that you had covered all of the topic areas that the city needed you to cover in order to continue for its review? Or was there anything out there that you had left that you had sort of reserved in order to discuss in a different forum or anything like that?
Well, I guess I just want to make sure I got the context of your question correctly, because we've talked about the green spine here. I've got about 8 different topics here on this letter. So I want to make sure if your question is referring just to the green spine and that we feel like we covered that, I would say yes.
Okay.
But I've got these other components of my letter that address then the other things that we felt we had covered.
Right. And I want mostly, for the most, I mean, we don't need to go through each of the topic areas in the letter from the standpoint that this document, the examiner can read it. But I do want to focus on a couple other major considerations that have been, I guess, some of the more salient legal issues or appeal issues that we've been talking about. So perhaps we can move to page 4, number 5 on alleys. And I don't need you to read that discussion, but again, what was the point of you addressing alleys as in your cover letter and not just sort of as another piece of the puzzle in the inch worth of submittals?
Yeah, alleys are a very, I would say, they're a very interesting part of this project, because there's the alleys, as you get a certain number of units, the Sammamish code directs you to having units be alley loaded, not front loaded. And so then the product then, or in a townhome setting, you need to move to an alley loaded product, because if you're going to apply on more than a certain number, and I think it's more than 20, then it's an alley loaded design. So then you have the alley. So there's then you move into, how do I design an alley? And that then moves you into the public works side of things. And you have 2 areas that you are to focus on. There are interim public works standards, and then there are the 2016 standards.
And we don't need to go, I mean, because we've actually talked, I'm going to pause you there just because we've talked about this quite a bit. What I want to focus your comment on is the consideration as to essentially your understanding of where things stood in terms of which standards govern and how you reflected that in your letter.
Well, we had a meeting with the city, and we were inquiring about this, and that's where there was a portion where the city had said that 9.3 was not applicable, and 9.3 is the alley standard in the 2016 standards. So that comment from the city there then was in alignment with how we were interpreting it, because the 2010 interim standards supplant the 2016, and in the 2010 standards there's more flexibility for alleys to have intersection or 90-degree turns and other things that we were looking for in regards to how we could do a configuration and a planning for our units.
If the city, once you provided this information to the city, if there was any, was there any reason that the city would not have been able to continue talking to you about these types of considerations through further meetings or reviews? If they did not, if you had misstated anything in there from their perspective? Any
Not
reason?
my opinion. I mean,
okay. And I guess because I want to ask you the same thing on number 6. I really want to not go through a lot of detail on this because you did cover it at length in the letter. But I believe at the end of page 7, you indicate, I quote, "We respectfully ask the city carefully review these and other points." And then you go on to talk about, in the alternative, we will modify. Again, what was your point of leaving? What was your point of these types of comments?
yeah, I mean, the point was to make sure that the city was aware of what our thinking was. And I want to also make sure that this letter was part of our resubmittal for all 4 applications. So it had a component here that tied together both sides. So when we wanted to basically continue any dialogue, and if there were any more questions, we wanted to make sure that they felt that we were ready and willing to discuss any questions they may have. And it's a complex application. It's hard to communicate everything through words, and we felt that having dialogue would probably be necessary.
And when you say all 4 applications, are you also referring to the TC B and C zone work, or what's the 4th application?
Yes, because
Okay.
The alley design in regards to our resubmittal, we had the same things that were on the alleys that were in the A zone that were also in the B zone, but we did end up getting comments back on our plat that were alley comments on the plat. So when you said before, did you think that was a reason to be that for denial? I guess I'm going off of my experience with the plat where we didn't get denied. We had more comments and another round to review and resubmit to the city.
Okay. And then let's turn to page 6, if you could, of 35A, excuse me, and you talk about in here, townhomes in the A1 zone. So when was the first time that the city raised to you, at least as far as you understood it, that they had a concern about townhomes as a use period in an A1 zone?
I would say these notes, or their comments, was the first time that we felt that this was different than.
I'm sorry, when you say their comments, which comments?
Their March 10th,
Okay,
2020 what was it, 2020 comments, that we felt that it was a different perspective than what we had seen in the pre-app. As I noted, we did acknowledge that there were some concerns around townhomes on the by the city square as we had proposed it, but other areas, I mean, just the comment that you wrote, that you pulled up earlier about the courtyard, well, that block was on the A zone in the pre-app. So they were saying that townhomes were okay to put on a common courtyard in the pre-app. So the first time we felt that, first time we really were getting the indication that townhomes, that they were not allowing townhomes in the TCA1 or taking that position, was from these March 10th, 2020 comments.
And in your letter, you start out with responding that you've incorporated a fully landscaped 30-foot buffer. Why is that the focus of your letter?
Well, that acknowledges the request by the city to make all streets pedestrian oriented. And
okay, so even if you disagreed or were debating over the street styles, you could still accommodate townhomes on either one. Is that your point?
Yeah, we had originally designated it as mixed use, which was a different setback. But if you put a townhome on a pedestrian oriented street, then the code says you got to set it back 30 feet.
Okay, so in light of, I mean, you have your conversation before in the letter, you have your conversation about the townhomes. There's a lot of room to continue figuring out exactly how to characterize that portion of the UZDP.
Yeah, I mean, I think that it's important to understand that the townhomes play a part in our application, similarly to the commercial, similarly to the apartments. And that it stems to, you know, how you put density on the TCA1 parcels. The maximum density on a parcel, on a A1 parcel, is 40 units. So when you're looking at putting, where we have blocks 5 and 6, where we have 2 multi-story buildings that are 5 stories over ground floor retail, which require a underground parking structure, that's an expensive endeavor. And those buildings, you know, require a certain amount of density, and then they have the ground floor retail, and that all blends together for that type of structure. In order to do that, to move that density around on these parcels, you have some parcels with lower density, and you also have some parcels with no density. So block 7 has just commercial. So we can move all that residential density and consolidate it on blocks 5 and 6. And this really isn't much different than if we want to take the TRF example. They had B zone parcels, and they took all their density from those B zone parcels and consolidated it up on the A zone, and they took their A zone density and put it there, and then they also received some other bonus density to then put 159 unit apartment there. So the way that the density works here has got to ebb and flow with where you're putting your buildings.
Okay, and can you talk to us a little bit about the interplay between the commercial maximums that we had touched on a little bit yesterday, just the idea of commercial, how you as the applicant or as the aggregator of properties would balance that commercial with residential across a pretty complicated set of properties.
Right. So where we looked at this core mixed use area was buildings 5, 6, and 7, the Notch property, and blocks 8 and 9 on our resubmittal, on our 622 resubmittal, as really being the core area where we would consolidate retail. And that also then works in a manner to blend with going north of 4th in a similar block structure. So we put the 82,000 square feet in blocks 5, 6, 7, and 6 and 7. The way we have the road network there is that road 225th comes down and sets up perfectly for block 9 to have retail right there as to set up basically like a retail triangle right there. Then you have the city square, and then you also have block 8. So in the way we were looking at it is that really sets up and meets a lot of the goals of the town center, where they want it to be pedestrian oriented, want to be able to park, want people to have all the blocks be walkable, and we have then a nice distribution of our commercial across 5, 6, 7, and then some future blocks.
And why, in your mind, does it make sense to put townhomes then on what are now termed blocks 3 and 4 versus more either straight commercial or mixed use buildings?
So I think there's a couple components to that answer. I think 224th provides a nice logical break there for a transition into product, or a transition into a different product that respects the wedding cake design from the city. The city has the TCIP talks about ringing the TCA 1 with residential use, either low or medium, and that makes a perfect sense as ability to start transitioning over from where we are at the core mixed use. Like I said before, the way that you're calculating density, it requires that you have some areas with lower uses and or commercial only uses, and then some areas that have higher density. And I think then that the townhomes then we're blending that with the next zones, which is the B and the C. And keep in mind, the zoning lines are based upon historical properties. So we're approaching the edge of the TCA 1 zone. So it's not super smooth in regards to how the zoning is right now. So we then use 224th as that break point to then transition over into townhomes, make it an integrated development with the BC zoning, and have one cohesive looking development from the layperson's eye.
Okay, and then and again, this has been, as far as a use is concerned, this has been relatively a consistent depiction throughout the application process. Is that fair?
Yeah, I mean, I think that
I'm going to object. I'm going to object. It's just a bridge too far as a leading question, and there's been a lot of them, but that one just is a bridge too far, I think.
It's fine. I'll withdraw it. I can ask.
Either withdraw or rephrase.
No problem. No problem. I don't need to go there. And yes, sometimes I'm just moving the witness along a little bit. So I guess with this letter, well, there's one other category. I don't think it's addressed in this letter, but it comes up in the resubmittal that I'd like to have you testify about, which is the affordable housing calculations and density calculations. Is that a calculation that you worked on?
Yes.
And are you familiar with the city's conclusion related to that topic area?
I probably have to refresh my memory.
Okay.
I mean, I guess
we can.
I guess I'm not sure.
So let me ask you a different question. Let's start from a different place. When you completed your affordable housing calculations, how many affordable housing units did you come up with?
In the TCA 1?
Yes, for this UZDP.
77.
You came up with 70. There we go. Thank you. And this is, I'm sorry, what's the exhibit number on this one again? And we're on 35E. go to page 2, to page 2 there. So if,
Correct. Line 17.
yeah. So if we go to line 17 there, we've got some black numbers and a red box. Can you describe what those depictions are?
What,
Yeah, so
what exhibit, excuse me, what exhibit did you say this was?
35E as in Edward.
Thank you. And we're at Bates page what? Looks
2.
like 2. 2? Thank you.
2.
So
go ahead.
You want to ask me a question or you want me to?
Nope, you can answer the question I just asked. Go ahead.
Okay, so this is the city's density calculator, and you need to fill this out for whatever you're applying on by zone. So it's calculated, it's used based on acreage, and in basically this line that we're looking at here is the affordable housing proposed. The 77
That's line
units,
17. Okay.
Line 17, the 77 units is per the city's density calculator of what was calculated for our project. And then the column that is to the far right is a column that we inserted as something that we wanted the city to consider as just in the way that they were doing their calculation, which we felt there might have been an inadvertent error in how their spreadsheet was calculating. But we filled out their spreadsheet in the manner that was provided to us, and we submitted on those units. We just wanted them to, as part of our application, consider that there might have been an inadvertent error there that we wanted them to consider, and we certainly invited conversation about that.
At the bottom of that page, there's an asterisk in a rather large paragraph. Is that a summary of your analysis there?
Yes.
Okay, perfect. Now, had the city come back and put a condition of approval, we can be done with that exhibit. If the city had come back and put a condition of approval on a USDP and said 77 units, is that a problem for the project?
Versus 76?
Correct.
No.
So 76 is just basically, it's a question of which is the right math and appropriate in terms of the bottom line. Is that fair?
That's fair.
Okay. Sorry, I'm looking through my questions just a moment. So you provided your submittal June 22nd. Did you receive any, I guess, comments back or requests for meetings? Any discussion about those submittal items from the city in the coming months?
Not to my recollection. There was, I guess I can say, there were some formal documents that I think the city issued as far as completeness, and that I think they sent out, but I don't recall the city ever reaching out to discuss anything about our application submittal with us. Is
that a surprise to you?
It was consistent with what we had seen from the last one, as far as they didn't reach out to us on that one either. But we had certainly invited conversation about it. And once again, I mean, I think the surprise comes from the fact that this is an extremely complex submittal and has a lot of things that require more conversation, in our opinion. But we invited that on multiple occasions and throughout our letters and throughout our approach to the application.
So did you reach out at all to the city and check in with them if they wanted to talk about any piece of the submittal?
I believe at some point I did reach out to Chris Hankins to ask how things were going, just because we hadn't heard anything. So I think that was in the September timeframe.
Okay. And
In
did
what
you,
time frame? Could you say that again?
I think it was in the September 2020 timeframe.
Thank you.
so what was that conversation? What topics were you able to cover with Chris Hankins at that conversation?
You know, I was just trying to get an understanding of where things were at, and were there any substantive things that we, should, we can talk to the city about, or is there anything that, is everything, clear, or do we want to talk about anything? And Chris was not, he didn't stress that there was anything that we needed to talk about, and didn't indicate that there was any major issues. So, and then I believe shortly after, we received a letter that was in regards to the city needing more time to review.
Okay, would that have been a September 30th letter?
Yes.
Sound about right? Okay. And did you have any problem with the city asking for more time to do its review?
No, I mean, I don't think we had any issue with it. I think, I think what we were still struggling with understanding is, at that point in September, we were now, where are we? We're roughly 90 days into this review. You have no questions for us, want no meetings with us, and want 2 more months. Because it was set up, I think it was set to then be delivered. I think we got it back on November 13th, I think was the notice of denial. So we had no communications or any indication that anything was heading in this direction. Okay.
So you're in September, and just for the record, that's Exhibit 38 is this letter of extended review. So again, did at that time, did Mr. Hankins indicate there was a problem with the application, or there was a potential for denial, or there were issues that really complex issues that need to be worked out still?
No.
I'm sorry? You froze.
No.
Thank you. Okay. So between September and November, any further communications from the city? And did you try to communicate with anyone at the city at all?
No, nothing from them. And we were just being respectful of where it's at. I mean, I think you've also got to understand too, that we're still underneath COVID protocols. Anything that would be a communication with the city would be via email or voicemail that then would get a phone call back. I mean, in my opinion, I guess we were under the impression that if the city had needed some clarification, they could reach out to us. We were certainly had left that door open.
Okay. And at this point in time, was still a type 3 review process with all 3 applications going forward, to the best of your knowledge?
Oh yeah, no,
along with the other. Okay. Okay.
Never
so
communicated that changed.
Okay.
That could change.
Right. So you get. And then there was another Exhibit 39 is another notice of extended review from October 8th. Did the city talk to you at that time about having any concerns or need to cover anything about the application?
No.
Okay. So then you get the decision dated November 13th, and that's Exhibit 40 in the record. Did you get any contact from staff in any way, shape, or form before that decision came out?
No.
No one even told you they were issuing a decision either way?
Well, I think the letter said that we were supposed to hear on the 13th. I think that that's when what their letter said.
Oh, okay, the extended review letter.
Yeah.
Okay.
And
Okay. Did it indicate?
I can't recall if there was any conversation with Chris that may have just reconfirmed that date, but there was nothing that was ever an indication that there was anything wrong or a need to have a conversation.
Okay. So you get the city's decision. What was your reaction to what did you do in reaction to the decision?
Well, I mean, we were certainly surprised that the notice of denial, that we were at notice of denial. I mean, we weren't thinking that was going to be the response from the city. We thought we were still into, you know, a comment period and having more, would have more review cycles. So I called up Chris and we talked, and he said, you know, hey, it's a process, and there were many cooks in the kitchen on this one. And, you know, he asked if we were going to appeal it. And we just were, there wasn't any way to say anything that he was offering of why, you know, a particular portion of the application or anything was what it was hinging on. He just, you know, he just was saying that this is kind of where we're at.
Did you have any ability to talk with him about substantive issues? Was he open to talking with you about substantive issues at that point?
No, you know, it was more that the denial speaks for itself, and, you know, and just referred me back to that. And, you know, and just was, you know, saying it's all a process, and that's kind of where we left it.
And was there anyone else at the city that you could have reached out to find out if you could talk about the decision further? Or was Chris your main point of communication?
Chris had become the main point of contact for this application process. So Chris was the person.
Okay. So I guess considering, let me just sum up, did you ever meet on anything substantive about the application with the city after the June resubmittal?
No.
And did you ever refuse a meeting from the city?
Well, we weren't asked, so I didn't have that opportunity.
And you testified, you've already testified you reached out to staff, so I won't ask you to go over that again. So here we are in this appeal. To sum up where you're at now as the project applicant representative, I mean, where would you like to see the outcome of the UZDP process, or where would you like to see this UZDP process go? Were the examiner to agree on any issues in remand?
I think that, you know, we started preparing for this pre-application in 2018, and we sit here in 2021, and, you know, I would like to see that this UZDP 2019-00562 can continue forward. I would also like to see that that we can also engage with the city on a master planning process, that, you know, we use this UZDP as one building block, and we're also able to work with the city on the other components of master planning, so that we are all on the same page as we go through future pre-apps and future applications, so that we can come into these types of things with a shared vision and understanding of what we want. There's all these great themes within the town center of regional stormwater and green spine and your road network and having great public spaces and trails. And we want to be able to have a plan that we've laid down with the city. Now that we have this aggregation, that was the biggest challenge to this project in the town center going forward. We've aggregated it, we brought it together, and we have the properties now where we are open to roads being on our property. We're open to trails on our property or parks or whatnot, where that may be a limiter for people who are just trying to come in and buy one property. So we've taken a lot of these obstacles out, and now we feel that we can walk together with the city and really create an amazing town center for not only the city of Sammamish as staff and everyone working together, but for the city as a whole. So that's my wish.
Okay. That completes my questions for this witness.
Thank you. I think instead of starting with Cross now and then taking an afternoon break in about 30 minutes, let's take a little bit of an early afternoon break and do that now. Is that acceptable? Hearing no objection, is 10 minutes the usual 10 minutes okay? Yes? Yes? Okay. It is 2:30. We stand at recess until 2:40.
This conference will now be recorded.
Thank you. It is now 2:42 p.m. on July 14, 2021. This is the start of session 14 in the appeal hearing on UZDP 2019-00562. Mr. Eglick is going to begin his cross-examination of Mr. Brennan. Mr. Brennan, I'd remind you, you're still under oath. Mr. Eglick, please proceed.
Thank you. Mr. Brennan, are you employed someplace with a name?
Yes.
Other than as are you self-employed or do you work someplace?
I work someplace.
Where do you work?
Innovation Realty Partners.
And what is that?
Excuse me, we have that wonderful lag.
The rescue's coming. This should be better. We're back to the good microphone.
Okay, what was your answer to his question, Mr. Brennan? I think it got gobbled up with the echo. Mr. Brennan, what was your answer to Mr. Eglick's question?
Sorry, can you repeat the question?
I think I'm going to take a page from opposing counsel and say I can't remember. I think I asked you what.
Yeah, he asked you the name of the entity that you were employed by, and you said,
Sorry,
I think
I answered that one. Innovation Realty Partners.
And what does Innovation Realty Partners do?
It's a land development company.
And what land development is it engaged in?
I guess maybe I should. It's part of a. I guess it's the operating company that is for land development projects. I guess I should rephrase that.
And what land development is it engaged in?
Engaged in the Sammamish Town Center.
Anything else?
Right now, I don't believe so. Like this one's big enough for us.
I'm sorry, I didn't hear. After I don't believe so. I'm not sure I heard
This current
what you.
project.
Well,
This current project.
say it again, please.
We're only engaged in this current project.
Has Innovation Realty Partners ever done another project?
I don't believe so. Not underneath that name.
For some reason, I'm getting your first sentence, but the second sentence is always kind of dropping off a little bit. It may be poor hearing on my part, but if you could try to keep your voice up a little bit anyway, I'd really appreciate it. Okay, what's your professional background? Do you have a particular degree, higher education in a particular field?
Higher degree meaning past college or just university?
Let's start with college, I guess.
Yeah, I went to a 4-year university.
Where was that?
I went to college. Yeah, I went to Santa Clara University. Can you hear me?
Pardon me? Someone else was talking, so I couldn't. No.
I went to Santa Clara University.
Okay, and what was your degree in, please?
Marketing.
And since then, what have you done in the way of a profession, I mean?
I worked as a consultant in the software industry for a while.
Somehow and I really apologize for this, maybe I'm the only one who's experiencing it, but it seems to be getting garbled.
You're not the only one. I couldn't hear the name of the industry that he said he worked in.
Neither could I.
I'm having the same problem.
Okay.
Fixed.
Maybe I'll log off and log back in.
What kind of a microphone? Maybe be closer to it or something?
What you just said then was fine.
It's just the computer microphone that I was using in the last Zoom call.
Let's try your answer again. He asked you what you've been doing in your career since you graduated college.
Right. So I worked in the software industry for a while as a consultant, business analysis for large software implementations. And then I moved from there into the construction industry, worked for a general contractor for a while, and then did my own projects as an owner GC, and then moved into an owner's representative role for large projects, and then moved into a consulting role working in land development, and then eventually got hired by Innovation Realty Partners.
So you're not then a principal in Innovation Realty Partners. You're actually an employee who represents the principals. Is that correct?
That's correct.
And you mentioned yesterday, I thought, that the area that's the subject of this UZDP application we're having a hearing about actually has 2 different ownerships. Did I understand that correctly?
Yeah, that's how we applied. There's STCA LLC, and then there's STC JB1 LLC.
And what's the relationship between those and those 2 entities in Innovation Realty? I'm just trying to understand the kind of structure here.
Objection as to relevancy. If council could clarify what type of relationship he's referring to.
Well, I was thinking of assuming it's a business relationship. So.
Do you mean with respect to the processing of this application? Or are you talking
No, he just explained what the relationship between the 2 STCs is and innovation.
Innovation Realty Partners is operating. both LLCs.
I'm sorry, say again?
Innovation Realty Partners is the operating manager of both LLCs.
Okay, thank you. That may be beyond my business knowledge, but I think I understand what you're saying then.
Okay.
Do you have any training in professional training in architecture?
Not that I've gone to school for, but I've been involved in, doing general contracting and had to understand plans and how to read plans.
So general contracting mean that's the kind of, you get a contract and you build something, is that right?
Yeah, I mean, I worked for a general contractor, so he was building the different projects, and so I then would work as the construction manager to hire the subcontractors that would then have to execute the plans. So I had to have a working knowledge of how to read plans and whatnot. And I wouldn't say that I know every symbol on every plan, but I have a working knowledge so that I can help direct the subcontractors when I was in that.
Have you had any training in economics?
I did take an economics class in Santa Clara, but I don't think that is enough of an economics as far as formal training.
Okay. And have you had any professional training in land use planning?
No, I have not.
And am I correct that I think we learned this from Mr. Hermanson, that in the decisions, when there had to be decisions made among the STCA team, that you were the ultimate decision maker. Is that correct?
I think that they were collaborative decisions that Innovation Realty Partners would make together.
In other words, whoever is involved in Innovation Realty Partners that you work with, is that correct?
That's correct.
Okay, and that's not Mr. Hermanson or Mr. Zinser, is that correct?
That's correct.
Okay, so who would that be?
I work primarily with Matthew Samwick and Michael Lance.
Okay.
Mr. Eglick, could I ask you to move away from the mic just a bit? Remember that the
Yes.
curtain is more sensitive.
Yes, and thank you. I've kind of getting a lot of mic confusion because we swapped them out. So is this better?
Yes, you were just very clear, but you were rather booming.
Oh, right. Okay, thank you. Let's see. Now, I think in your testimony yesterday, you said that you had built a variety of projects over the last 10 years. And I'm trying to understand, are you talking about projects in the city of Sammamish that you've built over the last 10 years?
So, no, let me clarify that. Maybe my testimony wasn't crystal clear. I started out in the general contracting field and building projects for the first 10 years of my career in the construction real estate industry. So, and those projects were in the Portland metro area of Oregon.
Okay, thank you. But I think you also said yesterday you were the main contact person between STCA, the applicant, and the city of Sammamish, correct?
Yeah, that's correct. You could call me the point person.
Now, I want to jump ahead here, or behind, or however you want to put it. So towards the end of your testimony, you were talking about your aspirations for this appeal process. I don't know if you recall that.
I do.
And are you asking the examiner, as part of your aspirations to this appeal process, to require the city to permit townhomes on blocks 3 and 4?
Well, townhomes is a permitted use in the TCA 1 zone. And we applied on that based upon our pre-app and the knowledge that we had of that. And so my request is that we are able to continue processing this UZDB application. And
So is that a yes?
I request that this application continues to move forward, yes, and that we then use this as the initial building block for a master planning process.
So I apologize for interrupting you. As the examiner will tell you, it's a fault I have. But I do want to have you answer the question I asked, which is, are you asking the examiner to require the city to approve townhomes on blocks 3 and 4?
If the examiner is the ultimate arbiter of approving our application, I'm asking the examiner to take the information that's been provided, where townhomes is a permitted use in the TCA 1 zone, and our understanding of that, and to apply a ruling to that.
You referred to the pre-application as part of your basis for contending that townhomes are okay for the particular UZDP about which we're here today. Can you tell us what particular applications were involved in that pre-app?
So the pre-application was submitted that covered the A, B, and C zones. So it covered basically from 222nd to 226th. And so that pre-application had covered those, the B and the C zone and the A zone for all parcels except block 9.
So in other words, the pre-app wasn't just for the UZDP application we're about here today, was it?
It was larger in scope. And one of the comments from the city was that we needed to separate this pre-app, which we could use for both applications, but we needed to separate the TCC zone out and submit as a plat on that could not be incorporated into a UZDP.
So that's a yes, that the pre-app was for more than just the application we're about here today. Is that correct?
That's correct. It functioned as the pre-app for an application that was a plat application and the UZDP application that we are here for today.
Were there any other applications involved?
I guess if you want, I think we applied on a UZDP and we applied on a plat for the TCC in the B zone. We also applied on a binding site plan and a plat that falls underneath the umbrella of the UZDP. So there were 4 applications that this pre-app served to qualify for, or I don't know if that's the right word. It was a pre-app that we used for those 4 applications.
Was there a particular urgency for STCA about the pre-app for the application we're talking about here today?
I'm not sure I understand, like urgency. Can you help me understand what you mean by urgency?
In your mind, was there some time sensitivity that you needed to get the pre-app in and processed with some time sensitivity?
Well, as I understand it, I believe we were in a moratorium, and we had previously submitted a memorandum of understanding to allow us, that we had gotten approved back in 18, that we had that would allowed us to then pre-app. So I think the next step was to pre-app. So I'm not aware of an urgency outside of, once we received the MOU and our ability to pre-app, we then started preparing for that and put our application for pre-app in.
Wasn't there some concern about time sensitivity vis-a-vis a concurrency certificate?
No. When you pre-app, once you pre-app, you have 6 months to turn your application in, or your pre-app is no longer valid. I guess the director could provide an extension on that if they chose to. But so then the pre-app, once you have that, it sets everything in motion, and you are and then you are eligible then to submit for concurrency. So you couldn't submit for concurrency until you did the pre-app. So once we submitted the pre-app in, then there were timeframes that you needed to meet in order to preserve your pre-app, the relevancy of your pre-app within the 6 months, and then you would get a concurrency cert as well, which a concurrency cert could also expire.
So were you concerned about some of the time period running? I think you said it was 6 months?
Yes, of course. I mean, you would be concerned that you were getting your application in a timely manner to not have to request an extension from the director.
And was your expectation that a pre-app would be a approval of a project as proposed in the pre-app?
Absolutely not.
And I think you said you submitted your application then after the pre-app and so on. You submitted it, when was that?
When did I submit the pre-app? I think it was April. I think it was April 2019. City was typically around a month to 6 weeks to schedule that pre-app. So if the pre-app meeting was on May 23rd, I'd say it was in April. I don't have the date right in front of me.
And that was your pre-app submission, did you say that?
Right. So you submit your pre-app materials to the city. They then digest those materials and start formulating their pre-application comments, and then you have a pre-app meeting.
Okay. And when was your concurrency certificate issued? I think that's Exhibit 10.
According to the key dates here, August 14th.
And did you understand the concurrency certificate to provide you with any land use approval?
No. I'm sorry, are you asking if the concurrency certificate means that you get a land use approval?
Yes.
No, I did not.
So you agree that if you list townhomes, for example, as part of your concurrency calculation, that doesn't mean townhomes are approved, does it?
That's correct. In concurrency, I think we covered this, that multifamily homes is how the concurrency is submitted for both townhomes and apartments.
Okay. Then could you look at Exhibit 20, please?
Have that?
I'm juggling notebooks here, and these were comments that you received from the city once it had received your application, is that correct?
That was the March 10th letter, yes.
Okay, and could you look at page 2? Second paragraph. Would you agree with me that the city there has a clear declarative sentence there that or paragraph that suggests that townhomes are not going to work for the application you submitted?
Townhomes are listed as permitted use in the TCA 1 zone pursuant to 21B.20.040. However, townhomes are permitted within 30 feet of the sidewalk on the ground floor of designated pedestrian-oriented streets or corridors. Okay, so that means we have to set them back 30 feet. Is that how you interpret that?
Well, why don't you go ahead and keep on going?
As mentioned above, all streets or segments of streets in the TCA 1 zone are required to be pedestrian-oriented. I think I covered that in my last testimony, where I'm confused by this blanket pedestrian-oriented designation for all streets, as I don't understand how that meets hierarchy components of the code that also ask for mixed-use streets. But let's continue on. As a pedestrian-oriented street, and by applying the minimum 30-foot separation, the townhomes proposed adjacent to 224th Avenue Southeast as part of this project proposal are not likely feasible.
Okay, so you got this letter, and then how many meetings did you have with the city after receiving this letter?
3, I think.
I'm going to ask.
Pardon me, did you say?
I'm going to ask for clarity on the question, how many minutes or how many meetings between the receipt of that and what point? Up till the current?
That's a good point. Between when you received this letter and when the city issued its next set of comments.
So that is between the time frame, just so we're all clear here, March 10th and then the city did not issue another set of comments. They issued a notice of denial on November 13th, 2020. So you're asking for all the meetings between March 10th and November 13th, 2020?
Yeah, and I misspoke because I think you had a meeting at which the city gave you some comments, so I apologize for that. But how many meetings did you have between that and the city's decision? And that being the March 10 comments.
So I believe we had 3 meetings via Zoom with the city.
And in any of those meetings, did the city agree with the explanation you just gave of why this second paragraph on page 2 of Exhibit 20 was incorrect?
Well, I think to understand paragraph 2, you have to go down to paragraph 3, because paragraph 2, the last sentence of that, if the city is providing their opinion that they're not likely feasible and we can set them 30 feet back, then they are feasible. But if we take the next paragraph, then I think that's something that maybe we need to hover over.
Well, let me ask you the question again. Was there a question in your mind after reading paragraph 2, second paragraph, that is, page 2 of Exhibit 20, as to what the city's position was on townhomes in the UZDP application? In that UZDP application about which you were meeting?
So,
okay.
The thing that,
and did the city, let me ask you another question, because that was a yes or no question. Another question. You had, I think you said 3 meetings with the city after this March comment letter. Did the city ever indicate to you that it had changed its position in those 3 meetings?
well, the city did change their position by this letter. So they changed from the pre-app in the first paragraph, or in the first page where they talk about street typology, and they talk about that everything had to be pedestrian oriented streets, which was not the position they had on the pre-app. So then,
Mr. Brennan, you're not answering my question, and you have had your platform with your counsel. I would appreciate if you answered my question, please, sir.
Well, to answer your question, the last sentence says, as a pedestrian oriented street, which everything now needs to be a pedestrian oriented street, according to the city. So then they're saying that they're likely not feasible, but that doesn't tell me in that second paragraph why they're likely not feasible. If townhomes are permitted use and they're 30-foot setback, then that sentence means to me that they think they might not be feasible because of the 30-foot setback. But we provided a plan on our resubmittal with 30-foot setbacks and showed that they were feasible.
I'm going to ask again, was there any indication that the city changed its position between the March letter, which is Exhibit 20, on townhomes and that UZDP application that you were talking about, and when the city issued its decision? You had 3 meetings. In any of those meetings, I'll withdraw that. Let me start over. You've made your argument several times here today. Did you make the arguments you're making here today to city staff, or did you keep them to yourself?
I believe we discussed this with city staff because we were confused by it.
Okay. And when you discussed it with city staff, did city staff say, you're right, we're going to change our position on townhomes in this UZDP application that you have submitted? Yes or no?
I'd have to look back at the notes. I can't recall.
Okay. You have your notes there?
Well, I have to find the meeting notes and the particular question where we had asked this.
Well, you've made a lot of bold assertions here today about essentially what you've characterized as callous and unresponsive city staff. So I'm trying to pin down
Objection.
exactly
This witness
what
never ever made such a statement.
I think the intimation has been clear, and I'm trying to pin down exactly
Counsel can
what
save
this
that for
witness.
closing.
I'm trying to pin down exactly what this witness is claiming, as far as I think he's called it staff unresponsiveness. So I'm trying to pin down what went on in those 3 meetings and why this witness came out of those 3 meetings with whatever impression he came out with.
Well, let's try to do it without putting unnecessary adjectives into the questions regarding
Fair enough.
personalities.
I don't agree with those characterizations, by the way. I thought characterizing how my clients have been characterized, but you're right, and I apologize for that.
So I think at this point you probably, with all the dialogue that's happened, you probably need to ask him the question again, because I doubt that he remembers.
Well, you were saying, Mr. Brennan, that you had meeting notes and you had to check them before you could be sure as to what the staff position was after your 3 meetings. Is that still your testimony?
The confusion on this particular topic extends to paragraph 3. So if we're not going to review paragraph 3, then it's out of context of why we needed to have a discussion with the city about these 3 paragraphs.
I appreciate your sentiment, and I think you've made that point, but I'm making a different question, asking a different question that I'm trying to discern for the record whether, understanding you had a different point of view, there was any reasonable confusion about what the staff's direction and position was.
That staff was not permitting townhomes in the TCA 1 zone?
I think that's a little broad. I think what the staff position was, and that's what my question is about, the staff position was about this UZDP application about which we're here today. I don't know about the syntax of that sentence, but I hope the gist is clear. And I'm asking whether after those 3 meetings, you were confused. I understand, and you've made it quite clear that you disagree, but was there any question in your mind as to what the staff's position was with which you apparently disagree?
That we couldn't put townhomes on a pedestrian-oriented street?
I'm going to say it again because that's a hypothetical. I'm asking you whether there's any question in your mind about the staff position on the townhomes in your UZDP application about which we're here today for the appeal.
There is a question in my mind on staff's interpretation of what they're giving me. They're giving me 2 code sections here. And if we're not going to look at the 3rd paragraph, then it loses context of why I'm confused. The 3rd paragraph says that buildings adjacent to pedestrian streets are required to be located within 3 feet of the sidewalk and feature a pedestrian-oriented facade. STCA's proposal to locate townhomes adjacent to 224th Avenue Southeast does not comply with this requirement, nor is it consistent with the adopted Sammamish Town Center plan. So I can answer the question now because the city is now requiring all streets in the TCA 1 to be pedestrian oriented. Pedestrian oriented streets with a townhome on them need to be 30-foot setback. Yet they're quoting another component of code that says pedestrian-oriented streets require everything to be 3 feet setback. So they're telling me that they're allowed with a 30-foot setback, and they're not allowed on a pedestrian-oriented street because everything needs to be a 3-foot setback. So I am confused.
And did you make those points and arguments to city staff, or did you not?
I believe we did.
In the meetings you had, the 3 meetings you had with city staff, is that correct?
I believe we brought it up in at least one of those meetings.
Was more than one, though, where you brought it up, didn't you? I mean, I can ask staff, but I'm trying to cut to the chase here.
Do you have an exhibit where we brought it up that we can all focus on?
Well, I'm asking for your testimony, that you've given testimony about the discourse you had with staff, so I'm cross-examining you about it now.
I believe he answered the question. He testified he spoke at least one meeting about this.
All right. Well, thank you. Then I guess I'll move on. And did you address questions on this issue in the same way that you are here today? Was there any difference in how you addressed it with staff, Mr. Brennan?
I mean, I would address things with staff as trying to express my confusion and trying to understand how, in this particular example, how 2 code sections, how you have a permitted use, you set things back 30 feet, but then there's another code section you're referencing that doesn't allow me to set it back 30 feet and requires it to be within 3 feet. To me, that's a perfect example of something that we should have a conversation about and further understand it.
So I understand you're very much on message, but that's not the response to my question. So I'd ask you to respond to my question. Did you explain your concerns to staff any different than the way you are explaining them here today in your testimony on cross-examination?
I'm sure I tried to explain them as best I could. I'm not sure I understand. Is there some way I'm explaining it right now that is, I'm not sure I understand.
Can you think of any difference?
I tried to explain our position of just, trying to lay that out for staff of, we're confused with this particular part, but you got to understand too, the way that we were communicating with staff was by submitting questions, and then staff would basically they would tell us what their interpretation was. But we remained confused on this one because of the comments we got in the pre-app, that we got it as an allowed use. We didn't get anything in the pre-app that suggested that we were bound to all pedestrian-oriented streets and that this would not be allowed. So if this was not an allowed use and only this realization came up at the March 10th comments after they had a full-blown application in front of them, that seems to me like the pre-app process didn't function correctly.
I'm going to try to bring you back to the questions I'm asking, and I'd ask you to try to address them rather than provide, I think, answers that stray kind of far afield, because otherwise we'll be here quite some time. So let's go on to another question. Was there any confusion in your mind, and I think you've said a few times that you didn't agree with the staff position, but was there any confusion in your mind that you want to acknowledge today as to what the staff's position was? I know you didn't agree with it and you found it confusing that they had the position they had, but was there any confusion in your mind about the staff's position on the townhomes in the UZDP application in particular that we're here about today?
There was confusion in my mind on their interpretation of the code and how they were applying it.
Is that to say that you did not understand what their interpretation was as opposed to you did not agree with it?
Well, in this particular instance, we were confused and how it's permitted but not permitted based upon a street topology.
So that's a disagreement, isn't it? It's not a confusion because you knew what the staff position was. You simply did not agree with it. Isn't that correct? Yes or no?
That I didn't agree with it. We didn't agree with it. We didn't agree with their position.
Okay. And after, and you know, you guys know the chronology so much better than I do, but I think we're talking about March comments, then 3 meetings, and then what's the next thing that happened after the 3 meetings?
We provided our resubmittal.
A resubmittal of your plans. Is that correct?
Yeah.
And
so
and the town.
We responded to all the city comments and provided then a resubmittal to all the comments that the city had given us in their March 10th comment.
And what changes did you make with regard to townhomes in your resubmittal after the March comments and the 3 meetings with city staff?
So in regards to the townhomes, we made 224th completely pedestrian oriented. And then we set all the townhomes back 30 feet that abutted 224.
Anything else?
Well, we changed the layout quite a bit on everything, where then the townhomes that were not abutting 224th were actually abutting a large park area with that would then function as an area for a pedestrian trail and tree retention, and that was part of the other application. But they all, like I said before, would cohesively work together.
And did you make any comments to the city on what you had done with regard to the townhomes?
I am sure that we had comments in there in our responses.
And is it your testimony then that you expected the city to accept what you had done?
I think.
With regard to townhomes, and I'm sorry to interrupt you, but I wanted to make that clear.
You know, we thought that we thought we were all within the understanding of the code, how we understood it. So yes.
When you say we, you mean STCA, don't you?
Yes, the applicant, STCA.
Did you think what you had done was within the city's staff's understanding of the code?
Hard to say. I don't know how city staff, you know, is. I think that's a very good point of where more conversation could have been useful and more.
So having interrupted you, I will apologize again, and please go on.
I'm good.
Are you sure? Because I really don't want to step on your lines.
That's okay.
Okay. So when you say that you said something about more conversation, you mean more conversation because what you submitted wasn't consistent with what the staff had conveyed as to its understanding of the code. Isn't that correct?
I think we provided justification for our position in our submittal letter, and we struggled with how staff. I mean, there's 2 components there that where you have a permitted use And on pedestrian-oriented streets, you need to set it back 30 feet. We did that. We followed that component of the code. And then there's another component of the code that's talking about structures need to be within 3 feet of the sidewalk. In our understanding of that is when you are then providing ground floor retail and the other components that are part of pedestrian buildings then sit 3 feet back from the sidewalk. So for example, like a coffee shop or a retail store. But if you put a townhome in, you had to be 30 feet back. So we didn't see that you were a townhome and you were also a retail shop use at the same point in time. So you had conflicting setbacks. So we took the position and tried to explain this to staff that this is a townhome product. We're setting it back 30 feet as a permitted use, and that component of the 3 foot was not applicable to us because we were complying with the 30 foot setback.
I think you told STCA council that you were surprised and expected to have another round of discussion with the city before it issued a decision. Is that correct?
Well, just from my understanding of other UZV applications and our own application with the Brownstones West, it was logical that we thought we would receive another round of comments and continued dialogue.
Do you know what the definition is of the word impasse?
You can define it for me.
It means you've come to a point where you can't make further progress because there's divergent views and no movement. Don't quote me to Merriam-Webster, but that's would be my definition. So would you accept that definition for my question I'm going to ask you?
Okay, yeah.
And I'll ask city staff the same question. I hope I remember to do it or someone reminds me. But from your testimony, isn't it correct to say that on, for example, this issue, and maybe on others, but on this issue that we've been talking about, STCA and the city department were at an impasse?
I don't think so.
How many more meetings would you have wanted to have before you would agree that it was time for the city to simply make a decision?
Well, I don't have a number in mind, but I guess I would be looking at it as we need to maybe adjust the process or how we've been treating the process thus far to have a different type of conversation to really understand each other and how we continue to move forward, because the process, in our opinion, we were applying on things that we had said in our pre-app. We felt we had good direction from the city, and that UZV application would be the next logical step, which would then also create more dialogue and refinement that we would then all come to an agreement.
So is it your idea then that UZDP process never leads to a denial?
I guess I was not under that assumption going into it, because I felt like the major items that could be that the city wouldn't like or didn't want in their town center would have been vetted out in the pre-app process.
But I'm not sure what, and I was trying to take notes on it while you're saying it, but I'm not sure what your answer is. Is it your understanding that a UZDP process never can lead to a denial?
I think that it could lead to a denial if you pre-apped on something and then you didn't apply on that, or you changed directions from where you went from a pre-app. I could see that you all of a sudden had a pre-app and then you put out something that was not what you pre-apped on, and then the city would say, well, this wasn't even your pre-app, and then that could be grounds for a denial because it wasn't consistent with what they had seen before. But I think in this scenario, we were consistent.
So is it your testimony then that your understanding was that if you move from a pre-app to submitting an application, you're assured of approval?
I would say eventually the process, as we understood it, was to get both parties through this framework of the UZDP towards an agreement and towards something that both sides think is agreeable.
So is it your testimony that when you move from pre-app into the application that you submit, that application is assured of approval?
Jeff can ask an answer.
I think it's been asked. I don't think it's been answered.
It may have, but I'm interested in letting this discussion go on, so overruled.
I think that there's many things to consider. I think if you're going to give me the question that if you submit from a pre-app that and you have an application that is different from your pre-app or has different uses, and do you expect that that's going to get approved? I would say, I don't know. I don't think so. It has a likelihood that it could be denied because that's not what you had shown the city before.
I'm still not, I think, hearing an answer here. What's your concept of what a pre-application review provides for an applicant?
I think the pre-app review provides guidance from the city and shows the city what you intend to apply on. And if the city they're giving you pages and pages of notes there and direction and guidance, and in the absence of seeing anything that is something that the city doesn't approve of and feels like is a violation or of their plan or something that they really don't agree with per the code or per the plans, then that would have been vetted out in the pre-application process. And I believe that the reason you would do that is so that you don't go around and around with putting together an application, going down these paths with the city, and then getting to a place where we are today.
So is it your testimony then that after the city's pre-application review and the comment, I think, in that matrix that you referred to with STCA council, that you understood that you could, for example, do as many townhomes as you wanted in the area where you've proposed your UZDP application?
Are you saying for the entire UZDP or for the areas in the A zone that we had cited townhome.
Well, I'm talking about your specific UZDP application.
Yes, so, and you're saying we could do as many townhomes as we wanted in the UZDP application and then have not done any commercial or any apartments? Is that what your question is?
My question is, I think you're saying, well, the pre-app said townhomes are under the zoning code, and I'm paraphrasing here, a permitted use in that zone. So is it your testimony then that you understood you could do townhomes any number and any location in the area for which you applied for a UZDP?
I guess I don't look at it that way. I look at it as saying that the townhomes are a permitted use. We showed townhomes in our pre-app in certain locations, and we showed an apartment building or 2 apartment buildings in locations, as well as a commercial only in a location. We then showed commercial areas, and we pre-apped on that, and that plan is what I understood was the plan that could be submitted on as an application. I think if we had changed everything to be townhomes and had omitted our commercial areas and our apartments and everything, then the city may have wanted to have another pre-app to discuss a completely new townhome application.
So when the city reviewed the pre-application, did you understand that then to lock the city in as to, let's take one factor, street designation?
Well, I think the street designation, if we want to hover over that example, was given to us as identifying a topology. The topology that you identify in a UZDP application is a unique piece to the town center, and the topology of a street drives the use, so that you put on the blocks. So it's a very important component of anything that you would apply on in the A1, 2, or 3 zones. So when we pre-apped and provided the city with our configuration, and they identified for us to show street topology and all those things, but didn't give us feedback in regards to saying townhomes were not allowed. And I think as applicant, our assumption was if we are applying in relatively a similar manner that we had a pre-apt on, we felt the city doesn't lock the city in. I think the city and the applicant agree that this is a good pre-app to continue to move forward with.
So how long did the city have to review your pre-application material? Do you know?
Give me a second here. So we submitted on 4/16/2019, so April 16th. And then we had the meeting on, May 23rd, 2019. So that puts us at 5 weeks.
And how, do you know what your pre-application materials consisted of?
Yeah, I might not get them all correct, but we had provided the city with density calculators for all 3 zones. We provided the city with kind of more of a illustrative plan that showed where we were looking to cite the different components of residential and commercial and where the city square was located. We provided the city some preliminary drawings on grading, utility runs, because part of the pre-app process is with Sammamish Plateau and Water, so we wanted to show them where we were intending to put sewer, where we were intending to put water. I think we might have a preliminary kind of storm. We talked to the city about a regional storm, so we had cited some vaults actually on the city property and wanted that as a discussion topic in the pre-app. Then we also broke down each one of our blocks for the city to help them understand parking, units, and all that, all those components. I remember if we had given them any report on
I was more asking if you know how the components and material is great, but I'm asking you how, do you know what the bulk of it was? How many pages?
I want to say maybe, I don't know, 30 pages maybe.
Total of only 30 pages, including schematics and all that?
I think that's in the realm.
So not particularly detailed, was it?
I don't know how to answer that. What do you feel is detailed?
Well, let's compare with the actual application.
Okay.
How big was that?
It was much larger, but had a lot more components of geotechnical reports and stormwater reports. Had a lot of other reporting that I think add to the volume of an application, but I think that we provided information that was sufficient. I don't know that it seemed to me that the information was sufficient for them to come up with pre-app notes that didn't have any particular issues that they felt were going to prohibit us from applying. So maybe you'll have to ask the city staff what they expect for a pre-app submittal. It certainly can't be an application submittal, then what would be the point of a pre-app?
I'm sorry, could you explain that last comment in your remarks there?
Well, an application submittal is obviously a major effort and involves quite a few consultants and quite a bit of resources and time and money. So to go down the path of an application as a pre-app would be a significant cost to the applicant when you're trying to vet out some concepts and trying to vet out if this is something that the city would like to continue pursuing. And we felt from our pre-app and our submittal components that the city did want to continue doing that through the application process.
You were aware, weren't you, after the city reviewed the pre-app that it had a position different than STCA's on pedestrian-oriented streets?
Well, there were several comments in the pre-app about pedestrian-oriented streets, so you want to direct me to the one you're referring to, and we can talk about those?
Well, you were on the call, yes, on the conference yesterday, weren't you?
Which one?
Do you mean, was he listening? Was he in the hearing?
Yes, that's what I meant. Thank you. Were you listening yesterday?
Was I listening to the hearing?
Yes.
I think so. I mean, I don't know if I heard every word. So I guess which testimony were you referring to?
Testified yesterday.
Oh, I'm talking about when he wasn't testifying. I assume he was listening to himself when he was, but I'm talking about earlier in the day.
I'll be honest with you. I'm not sure I heard too much because I was preparing for my own testimony and trying to, familiarize myself with my own testimony. So.
And do you have notes of by the way of your interactions with the city?
Notes, Mayor, actually. I have notes, some notes with some of my interactions. Yes.
And are they contemporaneous?
Can you define that for me? Sorry, I'm not.
He means, did you prepare the notes at the time that the interactions occurred or immediately thereafter?
Oh, I guess there might be some notes that I took during a meeting that would be on a notebook, and then there might be some notes that I have after. And
would you be willing to share them with us?
I'm going to interpose an objection here. I believe the examiner actually ruled on this very topic in response to a request from the applicant regarding when we asked for the city's internal review notes and communications.
I did, and they said no.
Well, we're not asking for anything privileged, which I think was the issue for the city. There were a number of comments. There were a number of comments made by Mr. Brennan that I think referred to his notes or seemed to be based on contemporaneous notes. And maybe I'll withdraw the question. Let me just go to another question and we can flesh this out a little. If that's okay, Mr. Examiner.
That's fine.
Thank you. Mr. Brennan, you made some reference to a comment that you claimed was made by Mr. Hankins. Do you recall that?
We've had many comments, so maybe you can refresh my memory on which one.
Well, it's the one where you claimed that he told you that he had never seen a project that was so political. Is that an accurate reflection of what your testimony was?
Yeah, I remember that.
Yeah, well, do you have notes as to that comment?
It was just a comment that I had heard, and I had made a note about that.
When you say that you had heard, and I will ask Mr. Hankins about it, but I want to ask you first. You heard that with your own ears, is that correct?
Yeah.
And where was that? Where was that?
I believe that was over a phone call.
Are you looking at something to check on that?
I am.
And what are you looking at?
I'm looking at some notes I put together for my preparation that was trying to look back on past communication, because it seems to me testimony that you've been asking about a lot of past communication, so I wanted to have some reference points.
And how did you prepare those notes that you're looking at now to answer my question?
From my own personal notes.
And do you have your own personal notes there that you based what you're looking at now on?
Can I interpose an objection as to this line of questioning? What's the relevancy to the appeal issues?
Well, the testimony was given, and I'm not going to move to strike because I think even that leaves a bad taste. And I would like to know where that comes from and what the basis for it is, because I think the testimony was given and was apparently prepared to be given to provide a certain coloration to the appeal contentions, which incidentally were ruled out by the examiner in his order on interlocutory motions.
Seem to be focusing on this a lot.
Well, it's a pretty serious allegation.
In the years that I have done quasi-criminal, quasi-judicial, or excuse me, quasi-civil, quasi-criminal personal property forfeiture hearings for various police agencies, and that goes back to 1985, my experience has been that sworn testimony, say by the police officer, is far preferred over just a copy of the police officer's report. And I routinely will accept the sworn testimony over the written report. In fact, I've had hearings where criminal defense attorneys don't want the police report in. If he can't remember it, too bad. Therefore, as far as pursuing further, what his notes are, where his notes came from, etc., I'm going to sustain any objection to pursuing that further. I will let you continue to ask him questions, at least up to a reasonable point, regarding where he heard it and what he thought he heard. But we're going to accept his sworn testimony as his evidence regarding this. And the city is certainly welcome and able to put on sworn testimony from somebody else that may have a different recollection of what was or wasn't said. And if Ms. Koloshkova starts crossing that person and saying, I want to know where your notes are that show me how you got this, I'm going to say the same thing to her. I don't think it's appropriate or necessary to pursue that.
Thank you. Well, let's start, Mr. Brennan, with the who, what, where, when, why, etc. You were on a call just between you and Mr. Hankins. Is that your testimony?
That's my testimony. So I kind of got my a little bit more orientation here. So it was back when we were discussing the neighborhood meeting or the neighborhood open house. I think it was for the UZDP open house that was coming up on December 16th. So it was back around December 12th, kind of how I recalled it. And Chris wanted to make sure that I was clear that when we're in this open house, that staff and applicant cannot appear to be close, as he put it, and that it was not something that we were, I guess, looking like we were together in any way, shape, or form. That there was there needed to be and make sure that there was a difference between staff and applicant, and that we weren't, I guess, appearing to be closer than just those roles. And then that's.
And what date was this?
I believe it was the 12th of December 2019. And
the comment was then made with regard to the concern that citizens were politically, in your testimony, that the comment was made with regard to the concern that citizens would view this in a bad light because the issue for citizens was so politically fraught. Is that correct?
No, it had nothing to do with citizens. I think the political side of things was all internal.
So you were talking about the neighborhood meeting, and you're testifying that Mr. Hankins suggested that you not appear too close because what? you wanted to maintain the distance between the regulatory agency and the applicant for the public to see?
Ask him that. I didn't really understand, that, it wasn't like we were going to be anything more than all cordial with each other, but I wanted to make sure that there was a difference between applicant and staff.
So what you are testifying you heard, and we'll hear from Mr. Hankins on this, was something that had to do with an appearance of relationship between applicant and staff, not politics in the city internally. Is that correct?
All I can say is that he said it was the most political application he'd been a part of. So I'll have to ask him what that means to him.
Well, I think I'm going to ask him, and I suspect he's going to have a different memory than yours, but I'm trying to get yours, and I want to make sure I understand that the comment was made in the context of how staff and the applicant appeared to people at a neighborhood meeting. Is that correct?
Well, for Chris, I mean, I can't speak for him, so there's a component there.
I'm asking about the context. I'm not asking you to speak for him. I'm asking about the context.
I think the context he was concerned about is that we have a neighborhood meeting that is going to have not only citizens at it, but staff members and have other public officials there. So I think he wanted to make sure that, as I said, that it didn't appear that we were close with each other.
We being you and Mr. Hankins, is that correct?
I don't know what that means. It could have been applicant, it could have been consultants, it could have been anybody on the development team.
I'm sorry, I didn't hear your last words there. They trailed off.
It could have been anyone from the applicant side.
I think his actual words were development team.
I said development team,
Okay.
but I would broaden it to applicant because we would have consultants or whatnot, so on our side.
Okay, could you look at Exhibit 9 at page 4, please? Section 2C.
Yep.
And were you listening when this section was discussed with Mr. Zinser?
I was not.
Do you understand, or do you have an understanding of how this comment related to the materials that you had submitted for pre-application?
I understand what they're writing here.
Well, let's assume for the moment that this comment refers to streets relating to the proposed townhomes in the UZDP application for which you were having a pre-app. When the application was submitted, were the streets relating to the townhomes entirely pedestrian oriented?
Well, no, they were, I mean, we have the section on page 10 of street front orientation that talks about that there needs to be a hierarchy and there needs to be a pedestrian-oriented. UZDB application should identify the intended street types for each of the new streets. Pedestrian-oriented, mixed-use, residential. Should contain adequate information about frontages. So there, and then the 1D on page 10 says the requirements for properties fronting on pedestrian streets and corridors are set forth in SMC 21B.30.0301.
Mr. Brennan, do you recall what my question was, Mr. Brennan?
Well, yes.
I'm asking whether you recall what my question was, Mr. Brennan.
Well, maybe I don't.
Okay. My question was simply on the application that was reviewed, the pre-application that was reviewed, were the streets associated with the townhomes all designated as pedestrian-oriented streets?
Oh, okay.
Yes or no? Yes or no?
Well, I need to check that.
It's a yes or no question.
I don't recall. We did put together a street typology.
Mr. Brennan, we will be here a long time, and I think it's really unfair because I understand what your arguments are. Believe me, I do. I don't agree with them, but I understand them. But I'm asking you to help us establish some basic facts. And you've talked quite a bit about how you were entitled to rely on the pre-app and so on and so forth. So I'm asking a basic question about the pre-app comments that the city gave you. And it really is a yes or no question.
You're asking me to refer back to the street topology plan that we submitted with the pre-application. And I'd like to be correct on that because it sounds like this is a very big question. So can I please have 30 seconds to find that map?
You take your time. Well, it's up to the examiner, actually. It's not up to me.
You can have more than 30 seconds, but not take your time. That's too generous.
I stand corrected.
Look for your pre-app map. And just once you find the map and see what the answer to his question is, just give us a high sign and we'll listen.
Okay. All right. Okay, so it appears from the plan that we submitted that we did identify the streets that were we did have identified several streets with townhomes on them as pedestrian oriented. There was one segment that it appears was designated as mixed use.
I didn't hear the end of what you were saying. You said that it appears that there was one segment and then it kind of tapered off.
There was one segment that had townhomes on it that was mixed use, and the other streets were designated as pedestrian oriented, according to the plan we submitted.
And after the city provided its pre-app comments, how were the streets designated related to the townhomes in the actual UZDP application?
I would need to look at that application. Because we have
Sure.
we have that street topology in the application.
Sure.
But I believe that we provided, again, a mixture of mixed use and pedestrian oriented.
Mr. Brennan, aren't there at least 3 streets that are designated as mixed-use streets in the pre-application submission?
Three streets that
There-
townhouses
there-
on them? Let's get
I'm sorry, I just...
3 streets that have townhouses on them, or just 3 streets somewhere in the UZDP? Because his testimony was specific to streets that have townhomes on them. I just want to make it clear here, so we're not, we're confusing apples and oranges to begin with, but we don't need to put them in a blender.
Townhomes, how many streets were designated as pedestrian in the pre-app materials, Mr. Brennan? If we could go over that again.
Okay, 1 second. It looks like there was a segment, well, 224. There was wasn't how it sits today. And then there was a street called Street A that had a segment of it, which probably would today would be the equivalent of Southeast 5th Street. And then there was Street B and Street C, which were abutting the city square. And there was Southeast 6th Street. And then there were segments on Southeast 5th Street that were mixed use. There was a segment on 226th that was a mixed use. And 225th Place Southeast was also pedestrian oriented.
Am I correct that we do not have the pre-app site plan as one of our exhibits?
Yes, and that's part of what the confusion is here, is we've been trying to figure that out, but apparently it is not an exhibit.
I don't remember seeing it, so and Ms. Koloshkova was indicating with her head nod that it's not in the record.
We did not include it as an exhibit, and we didn't see it in the city's record.
There was that oblique rendering that Mr. Zinser testified about. I think it was Zinser. I don't think it was Brennan. The orientation was from the south, looking sort of northwest-ish, and I believe that was the version that had block 8 and what we now know as 4 combined with the city square and the notch. And I don't know whether that was supposed to be the pre-app version or whether that was just another scheme that they were looking at. But that exhibit, I think that picture is in the record somewhere. But whether that is a rendering of the pre-app version, I sure as heck couldn't say.
The exhibit the examiner is referring to is in Exhibit 13C as in cat. but I guess the witness could testify that if this is.
So you have the street topology from the pre-up submittal, that topology, and then you have topologies that were in both of our application submittal.
You're talking about this as opposed to that. So isn't it
You know,
the case?
may I interrupt? Wouldn't it be good if we had a copy of at least the pre-app site plan as an exhibit? We're doing so much talking about this darn thing. When we have it made an exhibit?
Yes, it's Shook Kelly, the one we've kind of come up with. We've been looking at trying to figure out how it fits. Kelly CSL.05, which includes the street type designations on it. And I don't know how we do this.
Mr. Brennan.
Somebody probably has an electronic copy of it.
Right.
And when we're through,
we can take a 2-minute break. I can see if I can figure that out with folks.
We're close enough to the supper break at 5. Let's just stagger on. Let's not have another break.
I'll sort it at the dinner break.
But see if we can find a way to get it. I would love to have the pre-app site plan in the record so we know what we're, at least for reference purposes, when I'm writing a decision, I won't be just trying to envision in my brain what everybody's talked about.
Sure, of course.
We'll reserve exhibit number 51 for the pre-app site plan. And if there's more than one site plan, we obviously want one that somehow or other shows a street typology.
Should I go ahead or?
Yeah, sure.
Okay, and I'll try not to stagger too much. You said we're going to stagger through.
I'm assuming that your cross is going to take us past 5 o'clock.
Yes, I think that's a fair assumption, and I apologize for that. But
but all I'm saying that for is that, in all likelihood, then after we come back from the dinner break, we might actually have the pre-app site plan that we can all look at. Because if it gets emailed to me, I can bring it up on the screen on my desktop computer. Anyway, keep going, Mr. Reglick.
Okay, Mr. Brennan, didn't the number of mixed, or the amount of mixed-use streetage, if that's a word, associated with the townhomes in your UZDP application increase between the pre-app and the application that you submitted?
I guess I'd have to see it. I mean, perhaps, and we probably have to clarify which application you're referencing.
I'm starting with the application that you submitted after the pre-app.
So the 11/4/2019 application?
Yes.
You know, in that, yes, we were following pre-application guidelines. So we were taking the vehicular circulation, comment C, into consideration. Streets in the TCA zone must include entirely pedestrian-oriented segments. And I think that's a key word. And then refer to the town center infrastructure plan resolution for guidance. We did that. But then we also had guidance that was development standards, site planning, and design requirements, which then talks about street frontage or orientation or pedestrian oriented, and also designations for mixed use. So we got guidance on both street topologies in the pre-app. So I think that
I don't want to cut you off, but I'm just hoping you can agree with me that the amount, the level of quantified mixed use street associated with the townhomes increased between the pre-app and the application that you submitted after the pre-app.
I think the road configuration had changed a bit. And
well,
so,
I'm not asking for the interstices. I'm asking for a bottom line answer. And maybe your counsel can have you explain what she'd like to hear you explain. But I'm just asking, didn't it increase between the pre-app and the app, the amount of mixed-use street frontage? Associated with the townhomes. Sorry, I left that out.
associated with the townhomes. I would say that we made 224th Avenue Southeast mixed use, which on this application or on our pre-app, it was pedestrian oriented. So I guess that would be an increase. I think that we were addressing two components there, which was that the mixed use streets as in the TCIP, there's this call out for A and B street. So
remember his question, Mr. Brennan, his question was more or less mixed use streets on the submittal than on the pre-app. You started your answer perfectly by saying we converted 224th to mixed use, but then you started explaining why. At this point, he doesn't want to know why. He just wants to know whether there's more or less. Am I right, Mr. Eglick?
Yes, sir.
So if you could hone it down to that, it would be most helpful.
Okay. I think there were more on the townhomes.
Thank you. I think you referred to the wedding cake concept in your testimony. That's been discussed a bit over the last couple of days, and you were saying that applied. And correct me if I'm wrong, but were you saying that applied to why townhomes on blocks 3 and 4? Is that correct?
I think the townhomes started providing a good transition by being a part of the A, B, C zoning there and making it and tiering down from the mixed use buildings in 5, 6. And so we felt we were meeting the intent of the wedding cake by using 224th as kind of that dividing line and allowing it then to tier down from a 6-story building to a 3-story building.
So the townhomes you're saying are transitioning to what?
Well, where that zoning line is right there on as we get to the edge of the TCA one, and then it moves to the TCB and then quickly to the TCC. So what we were doing there is once we went west past 224th, then we were tiering down in the A zone to transition from that A zone into the BC zone, and then ultimately back into the pre-existing neighborhood.
And I guess I'm trying to, and we talked with Mr. Zinsser about this as well. You're talking about transitioning, beginning not outside of the A1 zone, but you're talking about transitioning within the A1 zone. Is that correct?
Right. I mean, the zoning line is drawn on a pre-existing parcel. We've talked about the roundabout shifting and how the roundabout shifting from where the TCIP had it, where that was more in alignment with the AB zone. So, you know, it's a transition. I mean, it can't be perfect. We're working from a zone with some existing property lines, and we're trying to do our best to interpret the plan and honor the plan in tearing down to that townhome product, and then provide a cohesive development between 224th and 222nd. I think we've also discussed the need for, you know, on our side of how we're balancing, you know, how we achieve the density for the blocks 5 and 6. So,
I guess maybe I'm not asking the right question, but it sounds like your testimony is the same as Mr. Zinser's, that part of the thinking behind the townhomes on blocks 3 and 4 is that the wedding cake starts going down to lower tiers or layers within the A1 zone, as opposed to the A1 zone as a whole being all the top of the cake. Is that a correct statement?
yeah, I mean, I think that the TCIP calls out the need for, you know, kind of the ring around the A1 zone is that transitional area. So I think we expected that component of the TCIP in how we were treating it. You know, another way to treat it, if there's a line, you know, if a road falls on that line, I think that also provides some good transition, and then you can do something on one side of the street versus the other side of the street.
Blocks 3 and 4 aren't in a ring around the A1 zone. They're within the A1 zone, aren't they?
Right. So I think the way maybe you can help me with it if I'm reading the TCIP wrong, but that they said the edges of the A1 zone will be this ring of lower to medium intensity. So I felt like we were honoring that.
Okay, and I appreciate your providing an explanation. You also talked about the affordable housing calculation, and I think you said you had worked on it personally. Is that correct?
Yeah.
And you showed an exhibit that had some corrections in red that STCA had made on the city's calculation. Is that correct?
That's incorrect. I think we provided there was just some interpretation on our side and wanted the city to consider that, but we submitted the density calculator as given to us by the city for the calculation.
So what are you saying that the red, and I think that's exhibit 35E at page 2 is what I've got here is what we were looking at, but are you saying those red annotations were not corrections? What did you call them?
It was our interpretation, and we thought that there might have been an inadvertent error in the city's density calculator that we wanted them to see what we wrote there and take that under consideration. But we submitted the density calculator as the city, per the city's calculation on the left-hand column.
And had you ever raised that before with the city?
As far as any sort of error in the calculation?
I don't know what you would have labeled it. I'm asking if you ever raised that correction before with the city.
Perhaps we probably we may have discussed the affordable units as far as how they're counted.
So does it perhaps mean you've checked your notes and you can't tell, or what are you trying to express here when you say perhaps?
I guess I think we may have discussed it with them.
Okay, I think we'll leave it as I think we may, and I'll ask staff about it. Actually, I will ask you one other question about it. I apologize for misrepresenting what I was going to do. I looked, I couldn't find it. Can you point to any submission you made to the city? Tangible submission. In other words, I was going to say in writing, but nowadays that would probably be electronic, in which you raised this issue before Exhibit 35E.
I can't point to it off the top of my head, but if you have something that you'd like me to review, I'm happy to do that.
Well, I said I couldn't find it. That's why I'm asking. I'm just trying to make sure that I'm not missing something.
Okay.
You also made a comparison with is it TRF project in your testimony? Do you recall that?
In regards to, I mean, I certainly referenced the TRF project, so.
That project is split between, it's not all in A1 by any means, is it?
No, not mostly in the B zone.
Okay, that's what I wanted to clarify. Thank you. Did you submit any data to the city? And by data, I'm talking about economic, financial, and/or marketing data to the city with regard to the townhome aspect of the UZDP, for which you applied?
No.
Did you have any that you could have submitted?
Are you looking, I guess, what kind of data would you be looking for?
For example, data that shows the economics of development on blocks 3 and 4.
No, we didn't have data for that submission purpose. I think, as I discussed before, the townhomes provide our ability to shift density from that land over into the consolidated blocks 5 and 6. So
you said you didn't have something for, and I didn't hear the word, and then I heard purposes. So what was the word before purposes?
Sorry, I wish we had a court reporter. I don't recall.
Me too. Me too.
I think he said either that or those. I think.
Okay. Thank you. So you didn't submit any data, and you didn't have any data showing the economics, for example, of development of blocks 3 and 4, correct?
Correct.
Okay, thank you. I wanted to kind of inquire a bit. You said you would go into meetings with staff and listen to the staff read answers to us. Do you recall saying that?
Yeah, I mean, that's how our follow-up meetings would start, and then they would read the answer that they had prepared for us, and then that was the first time we would have seen the answer to anything that we had submitted as a question. for them on our pre-app questions, and then we could dialogue after that.
Okay, so in your testimony earlier today, you said you would sometimes dialogue, but isn't it true that in the meetings with staff, there was always a dialogue?
Yeah, I mean, I think that there were some points that were had more question around them to dialogue on, and there were others where the answer stood for itself. There was no dialogue.
Well, when you received the city answer, did you respond in a meeting?
I guess we'd say like, okay, that's clear. Is that kind of what you're asking for from that response?
No, I'm asking for what happened, because I want to make sure that we have an accurate impression of what occurred in the 3 meetings that you have acknowledged. And I want to make sure that I think we're talking, what, May 14, May 29, and June 1, are those the meetings that you were part of?
Yeah, I think that those were the follow-up meetings from the first round of submittal comments.
And did the staff not let you talk?
Oh, no, we could talk.
Okay. And did the staff listen? Did they hold their hands over their ears, or were they going la 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 la, or were they listening?
No, it wasn't like that. I'll say no. I think I think that staff then would give us their position, and perhaps some areas were, we saw eye to eye, and perhaps some areas there was still, maybe a question or maybe not.
And one of the areas where I take it, since you talked about in your testimony with STCA council, one of the areas where you didn't see eye to eye was on the city square. Is that correct?
Well, I guess where the dialogue had started was with the pre-app and the city square, it just north of the Sammamish Commons, and we were talking about that, and we had comments in our pre-app about that, and we were wanting to continue that discussion about that, and that's where I noted that we had put together a presentation, and then the staff did not want to pursue that conversation with that presentation, and so we made a decision there that we would omit the city square and what's now blocks 8 and 9, so that we could further discussions with the staff about the city square and the integration of those 2 blocks with it. So we were, I was under the impression that where that location was still, a location that we could talk to staff about, but then I guess what we saw in the comments was that was different. I wanted to see the city square in this application.
That was a lot of ground to cover. I'm going to try to backtrack and cover some of it in pieces. You're saying that the city wouldn't discuss City Square with you? Is that, and if I misunderstood, fair enough. I'm just asking. I thought I heard something like that.
We had set up a meeting coming out of the pre-app. That was one of the comments from the pre-app, that we would discuss City Square with the city. And so the city wanted us to come up with some concepts and then discuss that with them. And so part of our concepts that we had come up with was to discuss with them about how to, some of the components that we had understood from our consultants of how to make a successful retail environment around a large open space. Because the city, from the parks comment, wanted to see that those were pedestrian-oriented streets around the city square, and that they would be, they would also have retail around the city square. So what we were trying to communicate to the city is that those large, expansive open spaces in circumstances can be retail killers and hurt retail just from a walkability standpoint. So we wanted to discuss that with the city about that. And that was the presentation that I had put together with Larry from Shook Kelly. And we had some concepts in there as well to review with them on how we thought that all could work and also work for their requirement of wanting that city square to flex with different uses, get bigger, get smaller.
If I may.
Okay, so let's back up.
If I may, I think that the reference material that Mr. Brennan is talking about is Exhibit 1025, if that's helpful.
Thank you.
Thank you. So let's go back and try to retrace the steps. So you did have a conversation with the Parks Department about the city square question, is that correct?
No, so not entirely. We got comments from Parks as part of the pre-app. And then the next step was to further discuss with them, some city square concepts. So so go ahead, I'm sorry. So we had a meeting set up, and then we needed to provide our meeting materials, and I provided those materials, and then staff reviewed that, and then canceled that meeting, saying that the materials didn't meet the pre-app notes. And I guess our thought on that was that this was, this was not a formal design as far as like trying to meet each design criteria. It was to try and talk about some concepts about how to integrate park with the blocks so that both sides could see success in this. The city could see a successful city square, and the applicant could also see that the retail was going to be economically viable. Like it would not have issues with the expansive space in between the next retail store if you were to walk across the park.
So would it be accurate to characterize the impasse as one between looking at retail as an imperative for the city square and one looking at the public open space, emphasize on the word public, and its availability and utility from the staff point of view? Is that where the divergence occurred?
I think, I think that we just looked at it and said, okay, this requires more conversation, and where we needed to make a decision then was that we had a pre-app. We had that meeting got canceled in August, and we needed to make a decision on moving forward with our application from our pre-app, and then and we were, I guess, a couple weeks away, and we got our concurrency. So we decided to omit the block 8, the city square, and 9 from our application at once.
So, and
so I wouldn't say it's an impasse, I guess, to finish answering your question. It wasn't an impasse. It was just, we decided that it was something we should table till a future application for blocks 8 and 9 in the city square.
So effectively, it was STCA that withdrew city square consideration from its UZDP application. Is that correct?
We did, yeah. We decided that we would have that as a future application.
Okay, looking at Exhibit 35A, which I think you discussed earlier in your testimony. I just wanted to ask you a couple of quick questions about it. And this was what you, STCA, submitted along with the application, or its resubmittal. Is that correct?
Can you give me just a second to get it in front of me? Okay, got it.
And did you say before, I thought you might have said, well, hang on a minute, I don't want to, I think the examiner's looking for it.
Got too many binders here, just trying to find 35A.
All right, you should see how many are here. I can't carry them. So, Mr. Brennan, I think you testified before. Who wrote Exhibit 35A?
I said it was scribed by Steve Roos, and then our collaborative effort with our team. Then we wrote the letter, and it was my signature on it.
Okay, so when you say, did you? It's a verb I haven't heard that often. You said, did you say it was scribed by Steve Roos?
Yes.
Okay. And effectively, isn't this letter an explanation of why what you've submitted isn't what the city asked for after all?
I think it's an explanation of our thoughts and what we were trying to, and further narrative about how we were answering the city's comments.
But it acknowledges, doesn't it, that on various salient points, this isn't what you asked for, here's why. Is that correct?
Objection. That mischaracterizes testimony. If council wants to point him to a specific paragraph or statement.
Well, I'm asking for his impression of the letter that his lawyer wrote for him to submit to the city.
Objection, argumentative.
Okay, first off, I don't care who wrote it. Mr. Brennan signed it. Ergo, that's a Latin word that means therefore. It's his letter.
Well, for example, like if we looked at this section, we looked at a section on tree retention. We had originally applied in another one of our applications about that we wanted to have, that we were looking at a code section that would allow us to reduce 50% of the trees in that particular application. And the city wanted to see the full 25% retention. So in that particular area, we show that we write a paragraph there that explains that we included the 25%. And we would no longer be using the code provision that allowed for a reduction in tree retention. So
let's look at page 5 of the exhibit.
Okay.
And this is the point you've been making about what's been called street typology. Is that correct?
Yes.
And does this say we're going to do what the city asked us to do? Is that what you intended to say with this section?
I think the section
or does it say
an explanation to how we approached it and how we interpreted the code and the guidelines and the adopted town center plan and the TCIP and the other guidance that we have to go off of. And at the end, we said, if after reviewing this, that he still feels that everything needs to be pedestrian oriented, and we will make everything pedestrian oriented. But we tried to provide the city with our specific position that we didn't think that the blanket spreading of pedestrian oriented was how we saw the IP and the adopted town center plan, and we wanted them to consider some other segments that might be mixed use.
So if you were raising this for the first time, or let me ask you this: looking at the first paragraph on page 5, for example, were you thinking you were raising this for the first time with the city?
Well, the only thing to go back to would then be the pre-app, right?
Well, no, you had 3 meetings and city comments as well in March.
Well, so you had the pre-app and then you had city comments. So
yeah, and I'm asking about, were you raising this argument with the city for the first time in this letter?
I'd have to look back at the notes for those other 3 meetings. It could have been raised there. I'm not recalling that right off the top of my head.
So you don't know whether this is the first time you'd raised the arguments in the first paragraph on page 5 of the city? You have no idea?
So we get the comments from the city on March 10th, and like I said, it could have been in one of those 3 meetings that we may have talked about the street topology as well. So I would need to familiarize myself with the content of those 3 meetings.
Okay, and then on the top of page 6, you say, if you really mean it, city, then we'll make the necessary adjustments to adjacent building setbacks. Do you see that?
Yeah.
Okay, so what's involved in adjustments if the city really means it?
You broke up there in the middle. Could you say it again?
Yes, sir. I moved the mic closer, maybe. What's involved if the city really means it in making what you say are the necessary adjustments to the adjacent building setbacks?
Well, I mean, the way that we were looking at the code and the TCIP, it calls for 2 different types of streets that have different uses on them.
That's not his question. His question is simply at the bottom of page 5 and top of page 6. The applicant says if the city really wants them all to be PED oriented, we'll change them. And what he's asking you is what's involved in changing them. Am I right, Mr. Egley?
Yes, sir.
He doesn't want an explanation about different points of view. He just wants to know, okay, you made the offer. What would be involved to carry out that offer?
Then we would change them and then adjust the uses on those pedestrian oriented streets accordingly. We have to.
I think he's trying to find out if it would mean a wholesale change to things or just little tweaks or what. I'm curious too.
Well,
what would be involved?
Well, I guess I would say that for Southeast Fifth, if you want to take an example, we called that mixed use. And the reason we called that segment mixed use as it went east-west is that would tie in better with the residential neighborhood. So if it went pedestrian oriented, then that would be a different sidewalk configuration. That would be bigger sidewalks there. So once it hits the B zone there, that sidewalk would change from its larger 15-foot, I believe, wide sidewalk down to a 12-foot. and then anything that would be on abutting that pedestrian-oriented segment would need to be set back. Well, I guess if it was a townhome still, it'd be set back 30 feet, or if you changed it, you could change it to some totally different use, I guess.
So then you're telling Mr. Eglick and me that it would require a change in the width of the sidewalk to convert from mixed use to pedestrian. And it might require a change in setbacks to convert.
No, I think it would change it in setback, because if you were trying to put a townhome product there, then you would still be bound by the 30-foot setback.
Okay, but their requirement was that every street in the A1 zone had to go ped oriented.
Right.
And pardon me for my abbreviation, but that's how I've been writing it in my notes. And it's instead of pedestrian oriented, it's ped oriented.
That's clear. Where we had townhomes, they were fronting 224th, so those would be set back 30 feet. This Southeast 5th is a side street that continues into the BC zone. So I guess my assumption would be that if you're meeting pedestrian oriented streets and it's a townhome, then you'd have to have a side setback of 30 feet as well.
So in effect, don't you eliminate some townhomes?
If we're still under the assumption, or if we're under the assumption that the townhomes are able to be approved with a 30-foot setback, then yes, you would lose a few townhomes or to comply with the side setback.
Okay. Mr. Examiner, I don't know. I think we've got 3 minutes left. Can I assert a point of personal privilege, maybe that we end 3 minutes early for personal reasons?
Certainly, and I will even make the lunch hour 3 minutes longer. It's not lunch, though, it's dinner, I guess. It is 4:58 according to my computer clock. We stand at recess for the dinner recess until 6 o'clock.
Thank you.
This conference will now be recorded.
Thank you. It's now 6 p.m. on July 14, 2021. This is the start of session 15 in the appeal hearing on UZDP 2019-00562. I would like to note, with thanks to Mr. Williams, that during the dinner recess, he sent, I believe, everybody, at least all the principals, a copy of the pre-application submittal made by STCA in this matter. It's 30 pages long, and he sent it to us so it's in a Dropbox form, which means it won't have Bates page numbers on it, but it'll have PDF page numbers, and we can refer to things by PDF page. So we will enter that into the record as Exhibit 51, the pre-application submittal package. So, Mr. Eglick, you indicated, I believe, that you had a few more questions for Mr. Brennan. Mr. Brennan, I remind you, you're still under oath, sir. Mr. Eglick, go ahead.
Thank you. Do you recall, Mr. Brennan, that there was also a comment from the city in Exhibit 9, which is the pre-application review comments, I think is what they're titled, about alley standards?
If you can point me to the exact reference.
Page 17, well, for example, page 17, number 10.
Pardon me, are we in Exhibit 9?
Yes.
Yes, I see that.
Okay, so are you familiar with the divergence between the city's view and STCA's view with regard to the alley standards?
Yeah, the divergence comes in with the other standards that are also applicable to the town center, the 2010 interim public works standards. And the street design standards of that, which I can't remember the code reference, but it says it supplants 2016. So there's been lots of discussion around which standard would take precedence.
And with the submittal that you made in, or I mean STCA, in June, which standards did you apply in the application you submitted?
So there was one of our meetings that we had with the city. We were asking for further clarification, and in one of the comments we got was that the 9.3 didn't apply in this case. So then we were operating off of the interim public works standards, the 2010 standards, as a means of creating our alleys for the application on 622.
Do you recall that the city clarified what it meant with regard to the comment you just referenced with regard to the 9.3 standard to STCA?
No, I don't recall. Do you have it there?
Okay, then I'll just ask you this and we can have the staff address that. So does that mean that what you submitted in June essentially was based on STCA's interpretation of the applicable standards? Is that correct?
That was, yeah. So we were then working from the 2010 interim public works standard there for some of our design there.
Now, if the city's view prevailed on that particular issue, what would that mean in terms of alley placement?
Well, then the alley placement then would be subjected to, I guess, the 2016 public works standards.
And what would be the ramifications of that?
It would definitely be a different design. The 2016 public works standards have different. They have so, for example, there can be no intersections or 90-degree angles in a alley, so it would be a straight alley. Our alleys that we submitted on had some intersections and some 90s. We felt that with that in the 2010 standards, that was allowing us to provide a park that we were putting in our application. So we felt it had really good benefit. We were following the right standard that would offer such a amenity to the public. But in 2016, everything needs to also front a right-of-way. So all your townhomes would need to front a right-of-way if you are putting townhomes in. So
when you say a change in design, you're not just talking about minor tweaks. Then you're talking about a fundamental change in the project design. Isn't that correct?
I think the block structures of 3 and 4 would be changed quite a bit.
Okay. Okay. Let me see if I have anything else on my list here. Oh, as long as you have Exhibit 9 open, and I imagine you heard this discussed yesterday, perhaps, if you were tuned in then, but you also, when you received the pre-application review comments, you also took note, and I assume, tell me if I'm wrong, disagreed with pre-application page 10, pre-application comments, page 10, 1B. As I said, I think this was discussed yesterday as well.
Town center plan has a street network with TCA.
I'm sorry, I didn't hear what you said.
Sorry, I'm just reading the comment here. So, okay, so sorry, I'm oriented. Sorry, so what's your question that I?
It was actually a fairly softball question. I just wanted to make sure that when you received the pre-application review comments back when, that you also you took note of 1B on page 10, and that's of Exhibit 9.
The town center plan identifies the street network within the TCA zone as pedestrian-oriented streets and corridors for design review. Without reading the parentheses there. So the town center plan, I disagree with that because the town center plan does have mixed use and pedestrian-oriented streets in the plan.
I think my question was not whether you disagree with that. I think it's fair to say we're kind of assuming that at this point, but that you took note of this at the time you received the pre-application review comments.
Yeah, I mean, I see that, but if we look at the town center plan, it has mixed use streets and pedestrian streets in the TCA 1 zone. So I don't know.
Let me go at it another way. When these pre-application review comments were received and they're dated May 23, 2019, I assume you received them pretty contemporaneously with that. Is that correct?
Yeah.
Did you throw them in a drawer and, say, I'm not reading those, or did you sit down and read them?
No, of course, I read them.
Okay.
And so
thank you. No other questions.
Thank you, Mr. Eglick. Any redirect, Ms. Koloshkova?
Yes, thank you, Mr. Examiner. Mr. Brennan, you provided some testimony with respect to the exhibit that is now Exhibit 51. And that is just for the record, that is the pre-application materials. During the break, did you have a chance to review and confirm that those were materials that you and your team submitted?
Yes, I believe those are the materials we submitted, yes.
Okay. And did those plans include both mixed use and pedestrian oriented street segments?
Yes.
I'd like to turn your attention to Exhibit 35A. I just want to revisit this one discussion point you had at some length with Mr. Eglick. Could you please turn to page 7 of 35A?
Look at the letter. I'm going to get this back.
And if you could read that.
Which page?
Page 7.
The signature page?
Pardon me?
The signature page?
Yes.
Okay.
From the top?
Yes, if you would just take a look at that, and does that fairly represent what your position was when you resubmitted in June?
Yes.
And going back to using the example of the townhomes topic, what would be, if that was perceived as a quote unquote remaining issue when it comes to this discussion about pedestrian oriented versus mixed use streets, what would be the ultimate solution to that remaining issue if staff and STCA disagreed and you ultimately wanted to get your UZDP approved, what would you do?
Make them pedestrian oriented.
And I believe you testified that would involve 30-foot setbacks for the townhomes and potentially a loss of a couple units. Was that right?
If it's also a side setback, then yes.
If it's also a side setback? Is that
Yeah,
what you
it says it has to be set back from the street 30 feet. So if it's also applicable as a side setback, then yes, that's correct.
Okay.
We lose a couple units and 30 feet.
Is that a deal killer?
No.
Is the city square a required component, to the best of your knowledge, of any particular UZDP application?
Not that I know of.
Do you know, is it addressed anywhere in the town center plan, to the best of your recollection?
I believe it's a town center infrastructure plan concept.
And has the city ever pointed you to a regulation in 21B95 that explains requirements or parameters related to the concept of a city square?
I don't believe about city square. I think it's fine.
I'm sorry, I didn't hear you.
I don't think city square, just Greenspine.
Greenspine? Okay. And is that in the design principles that you're referring to?
The Greenspine design principles, is that what you're saying, that document?
Yeah.
No, I was saying that the Greenspine has references in the SMC that they've referred us to.
Okay. Yeah. Yeah. Okay. That's fine. Does the decision, does the city's decision raise a question of market factors as a basis for any of their decision points that you recall?
Not that I recall.
Okay. And did the city ever ask you for any information regarding either a market analysis or market feasibility, or whether retail works under certain circumstances, or any of those marketing questions?
No.
Pardon me? I need you
No.
to speak up, but you're too far from the mic.
Fine. No.
Okay. If you had been asked to provide that material, is that available that you could compile it for the city?
It's not something that I personally do for our team, but I think it could be provided by other, I think we could provide it.
Okay, yeah, I mean, just like you would provide engineering material or a geotechnical, you wouldn't put it together, but you could submit it.
Correct. Objection is the form of the question. There's some testimony built into that and an analogy that I would love to cross-examine on, except the council is not subject to cross-examination. Thank you.
To be honest, I'm not sure what change you would like her to make in the question. So I'm not sure whether to just shut up or sustain or overrule you.
Well, the problem with the question is it assumes an analogy to geotechnical submission, and I forget what the other one was, that are actually required by the city code, and creates the impression that this is something analogous to those. And it would be, I think, appropriate to ask the witness to make that analogy, and then I could cross-examine on it. But to build it into the question with a witness who you're essentially examining on redirect is kind of ultra leading.
Okay. I will sustain the objection, rephrase your question.
Thank you. Mr. Brennan, could you provide a set of market analysis materials as a submittal component to the city for your UCDP application if requested?
Yes.
Thank you. Can I turn your attention to SMC 20-05030, subsection 6?
Okay. SMC 20.
$20.05, the rest of it, please.
20-05030,
6.
sub 6.
Okay, thank you.
And if you could just read that to yourself for a moment. Got it. And did you ever at or subsequent to a pre-application conference receive any determination that the development or any aspect is not permissible?
No.
And last couple questions, if we could go back to Exhibit 9, which was the pre-application notes. If we could go to page 9, item D as in dog, Roman numeral 1. Does that describe what the plan is proposing for the TCA 1 zone as far as townhomes and what would be required in your mind?
Yes.
Thank you. I have no further questions.
Thank you. Mr. Eglick, any further cross-examination?
Oh, yes, I've got it here. So looking at 20-05030 sub 6, which you were just talking with STCA counsel about, did you request an appealable preliminary determination by the department?
No, I did not know that we needed to request that.
Well, you had counsel representing you also, didn't you, in this process?
In our pre-app submittal?
Yes.
I don't believe so. Counsel was not part of our pre-app.
You weren't advised by Mr. Roos as part of your pre-app?
As far as submittal?
Well, I don't know what you mean by submittal. I'm saying as far as advising you on this project at the time that you made a pre-app submittal.
I'm going to object as this is starting to veer into attorney-client discussions. It's both irrelevant and protected.
I don't think it's privileged as to whether someone is represented by counsel at a particular point in time.
I think I would agree with that.
That's a different question.
As long as it stays to that, not what advice you might have gotten.
Yes, Steve Roos was advising. Yes, Steve Roos was advising us.
Steve Roos was advising.
Mm-hmm.
Okay.
And if you could look at, are those pre-app, those darn pre-app comments, so there was Exhibit 9. Could you look at the first page of Exhibit 9, please? What did I do with mine? Oh, thank you. Pretty bad. Okay, and are these entitled determination, anything of that sort?
I don't see that word here.
Okay, it says pre-application review comments. Do you see that?
Yes.
Okay. And by the way, throughout this process, because we've been kind of assuming that, but I want to make sure it's clear. When you had meetings with the city, well, first of all, you mentioned, I think, 3 meetings with the city. Is that correct? After the application came in, is that correct?
I'm going to object that we're going beyond the scope of redirect at this point.
Well, I'm just trying to lay the foundation for a question that I don't think does go beyond the scope, but I can just cut to the chase and skip the confirmation.
I'll allow it. You may ask your question. The one you just had.
Okay, Mr. Brennan, just to reconfirm, I'm not trying to ask you any kind of, tricky lawyer question or anything, but there were 3 meetings, right, that occurred between STCA and the city with regard to the application. Is that correct?
After first round comments, yes.
And you were at all 3 meetings.
Yes.
And is it fair to say that as the what did you say you were, the project? I'm sorry, I can't.
Senior project manager.
Okay, you were active in those meetings, were you not, as a spokesperson for the applicant?
Yes.
Okay. Would it be fair to say you were the lead spokesperson for the project?
On behalf of the developer, yes.
Okay.
So I wouldn't take the lead for engineering or something like that.
Okay. You were asked a series of questions about, and I didn't catch these, my hearing didn't get them quite right, but I think you were asked, did the city raise with you market factors? Is that, am I close to what you were asked?
I think so. I mean, sounds market was in there.
Okay. And it wasn't farmer's market, or okay. So and you said no, the city didn't raise market factors. Is that correct?
Don't believe so.
Okay. And did STCA in some documentable way itself raise market factors?
Not that I recall.
Okay. So when you were asked if STCA had been asked to provide market factor material it could have, my understanding is, correct me if I'm wrong, that that you didn't raise market factors, so the city wouldn't have any reason to ask you to document what you didn't raise, would it?
Market factors, I guess, I don't think so. That the market factor is not something that is an application requirement, but has somehow become an interesting topic throughout this discussion. And if market factors was something the city wanted to consider or wanted us to show them, we would be happy to do that.
But again, to be clear, STCA never asked the city to consider market factors. Is that correct?
I believe that is correct. For townhomes is how we were discussing that.
Okay. And I think when you were talking with council, you said that the ultimate solution for the for one aspect of the townhomes, which was a street designations, you were asked what that would be, and I think one of you, either council or you, said loss of a couple units. Do I have that right?
That's if the 30-foot setback applies to the side setback So then we would have a side setback that would be larger than how we have it currently. And so that would be an impact of a couple units on each side of the road, north or south, for the roads going east-west.
Hey, wouldn't it be more than a couple of units if all the factors that bear on this issue that the city raised were taken into account? And by couple, I'm sorry, I'm interrupting my own question to clarify. By couple, did you mean two?
I was saying 2 per side. So let's say perhaps, somewhere between 4 and 8. I'm not sure. I would, like I do every time I have our engineering firm lay it out.
Okay, but so if I assumed couple meant 2, that would be, to coin a phrase, too low. Is that correct?
Yeah, I said a couple per side of the street, so north and south. So that would equate to 4, but they're, like I said, I would have the engineering team lay it all out, and it all is predicated on whether the setback is applicable as a side setback in addition to a front setback.
Okay, thank you. And I don't have any additional questions. Thank you.
I do have one more redirect on one point of Mr. Eglick's that I think is essential to ask the app.
Okay, let me look at one of my note pages and see if I have any questions that I wanted to ask. No, I don't. Not for this one. I will allow additional redirect. Briefly, please.
Thank you. Just one topic. Going back to this code section sub 6 of 20050.030. Mr. Brennan, it might be helpful if you could just read the first 2 lines of that subsection. If you could just read those first 2 lines for us.
At or subsequent to a pre-application conference, the department may issue a preliminary determination that a proposed development is not permissible under applicable city policies or regulatory enactments. In that event, the applicant shall have the option to appeal the preliminary determination to the hearings examiner.
Okay, you can pause there.
Provided, stop there?
Yeah, that's fine. Okay, so did you receive any preliminary determination that a proposed development is not permissible?
No.
Okay, thank you. No further questions.
Mr. Eglick?
I think I will leave it at that. Thank you for the opportunity.
Okay, thank you. Mr. Brennan, that concludes your testimony. Thank you, sir.
Thank you.
Ms. Koloshkova.
I need a quick moment to grab Ms. Heverin. It'll just take me about 30 seconds.
Okay.
And my co-counsel, Mr. Roos, will be providing questioning for Ms. Heverin, so I will be turning my camera off.
Okay, thank you. I will await Ms. Heverin's camera coming up and Mr. Roos's. There he is. There's Mr. Roos. Now all we need is the witness. Ms. Heverin, if you can hear me, would you turn on your mic and your camera, please? You've got a placeholder box on the screen, so I'm assuming there's a computer somewhere that thinks you're with it. There you are. Okay. Are you ready? Can you hear me? Can you hear me? I don't think she can hear me because she's not showing any sign of paying attention to me. Ms. Heverin, can you hear me?
I will go. She's in a room right next door. I'm getting feedback, by the way. But let me go and see if she's set up properly.
Okay, because she obviously doesn't hear me. Either that or she's a hostile witness to even the examiner.
Yes. Can you see me? Hear me?
Yes, now I can hear you.
Great.
Okay, let's get Mr. Roos back to his chair. Okay, Mr. Roos, you wish Ms. Heverin to testify, is that correct?
Yes, that's correct.
Ms. Heverin, raise your right hand, please. This is interesting. My image is frozen on my screen. Am I frozen on everybody's?
No,
I have my right hand up.
I can see your hand.
Okay. Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please start by telling us your name and how to spell it.
My name is Holly Heverin. It's HOLLI-HEAV as in Victor, RIN.
Thank you. Your witness, Mr. Roos.
Thank you, Ms. Heverin. And I'm getting a feedback. Is anybody else? Oh, I'm sorry. We just need to turn a. Okay, we're set. You currently work at Core Engineering, is that correct?
Core Design, yes.
And what is your title there?
I have numerous titles, but principal and project engineer for simplicity.
Okay, and you're
project engineer for what?
I was saying project engineer for, I was being simplistic with my title. I hold many titles.
Okay.
And you've submitted your resume for the record, and that is Exhibit 1021. Is that correct?
That is correct.
And is that resume a reasonable outline of your experience and qualifications?
Yes.
Mr. Hearing Examiner, we would submit Ms. Heverin as an expert witness in this matter.
I assume no objection, Mr. Reglick?
She's licensed, so no objection.
Thank you. You may
Ms. Heverin, what was your role in the STCA project that is under appeal in this hearing?
My role was a part of the design and overall approval of the engineering components of the stormwater, in particular utility layouts, and to ensure compliance with the drainage manuals.
Okay. And did Core Engineering analyze the project's compliance with the King County Stormwater Design Manual and the Sammamish addendum to it as a part of this project?
Yes, it's done for all projects within the city of Sammamish.
And what was your specific role in that analysis?
My specific role was ensuring complete compliance with the King County Surface Water Design Manual as well as the addendum.
And did that role include preparing the preliminary technical information report dated October 31st, 2019, which is Exhibit 13M as in mother in this matter?
Yes, it did.
And did it also include preparation of a revised preliminary technical information report dated June 20th, which is Exhibit 35X in this matter?
Yes.
Okay. If somebody could give the screen control to Dean Williams, I'd like him to put an exhibit on the screen for us.
I think Mr. Sugg can do that for us.
Here, I'll give you this. I think I'm done with the problem.
Mr. Hearing Examiner, it appears that Mr. Williams has, oh, there it is.
There you go. Thank you.
And Mr. Williams, if you could blow that up a little bit so that the individual lines are more legible. and I'm going to go specifically to line 3. And let me ask you, this document, Ms. Heverin, does it provide in the 4th column under comments a restatement of the city comments on the preliminary technical information report that were provided to the applicant in March of 2020 with respect to the first draft?
Okay.
And the far right column represents the applicant's response. Is that correct?
That's correct.
Okay, I'd like to focus on.
Excuse me, what's the exhibit number, please?
35Y.
Thank you.
The third line here indicates as a comment that the applicant should, or the TIR should, specify level 3 flow control consistent with report and text. Were level 3 flow controls incorporated in your project engineering?
Yes, level 3 was used.
Okay, and can you provide briefly a summary of what level 3 flow control means?
Yeah. Level 3 flow control is the highest level of flow control as established in the King County Drainage Manual. Level 3 requires a flow control facility be sized on site such that it matches the pre-developed durations from half of the 2-year storm event all the way up to the 100-year storm event. It's considered a flood control establishment.
And do you have an opinion on whether level 3 flow control as proposed here will result in an improvement in flow conditions or flow control compared to existing conditions?
In my opinion, yes. The current site is vegetated, but mostly grass, shrubs, some impervious surface, and then a few smattering of trees. But per the King County Drainage Manual, the pre-developed condition has to be analyzed as 100% forested, which would have a much lower runoff rate. So the rate that we have to match in the developed condition is actually lower than what currently exists right today.
You'll see on line 4 here that the applicant is asked to note projected, quote, flow control BMPs. You see that?
Yes.
And you see that then skipping down to line 10, and maybe Mr. Williams can just go down to line 10, that there's a reference there to lid BMPs. Do you have a professional opinion on what that term LID BMPs means in the engineering context?
My professional opinion would be that it refers to the flow control BMPs that are listed in Appendix C of the King County Surface Water Manual.
So that term LID BMPs has an established meaning as flow control BMPs that are in Appendix C of the manual. Okay.
Correct.
And did your technical information report dated June 2020, which is in the record as Exhibit 35X, did that provide an analysis of flow control BMPs as requested here?
Yes, it did. In Section 2, we go through all of the minimum requirements and how that the project has met the minimum requirements of the drainage manual. Minimum requirement 9 is flow control BMPs. So we evaluate the feasibility of each opportunity in Section 2.1.9.
And did the department conclude that the project satisfied the requirements for flow control BMPs in the manual?
Yes, based on the decision, I believe it's page 23, the staff analysis of the stormwater portion of the project was deemed compliant.
Did the department indicate at any point that the project needed to meet additional LID requirements in order to meet the requirements of the manual?
No, it notes the project needs to meet the criteria in the King County Drainage Manual and the addendum.
And it concluded those have been met.
Correct.
Okay. You've referenced that the UZDP decision in this matter on page 24 makes a reference to quote unquote land use management LID. Have you reviewed that part of the decision?
I did see that, yes.
And you see the distinction that the decision seeks to make between quote stormwater LID and quote land use management LID. Is that correct?
Yes, that is correct.
Is the term land use management LID defined in the King County Stormwater Manual?
No, it is not.
And is it defined anywhere in the Sammamish addendum to the manual?
No, it is not.
And to your knowledge, is it defined anywhere in the Town Center Development Code, SMC 21B?
Not that I'm aware of.
Okay. You testified again that the term LID BMPs means flow control BMPs. Is that right?
Yes.
And do you have an opinion on whether flow control BMPs fall into the category of stormwater LID or land use management LID or both?
I think they go hand in hand. They fall into both categories. The definition itself of the LID is that it's a strategy, singular, that would combine both those uses. There's a land use component to every LID feature, and there's a stormwater component to the LID features. So they go together.
So to take as one example, bioretention, which is that mentioned as one potential flow control BMP in the manual?
Yes, it is.
And would you consider that a stormwater measure or a land use measure or some combination of the two?
That would be a combination. From a stormwater aspect, it relies on specific soils and infiltratable ability. From a site standpoint or a land use management standpoint, it's a a roadside feature, so it's definitely a land use management feature.
Are you aware of a Chapter 21B 85 of the Town Center Development Code titled, quote, Development Standards dash Interim Stormwater Standards?
Yes.
Okay. And have you reviewed the City of Sammamish's first round of comments dated March 2020 on this application?
Yes, I have.
And did any of those first round comments mention SMC 21B.85?
Not that I saw. Oh.
In looking at this exhibit 35Y in front of us, and if you could put 35Y in front of us, sorry. And you see, if you scroll to the top, Mr. Williams, that the 1, 2, 3, 4, I guess the fifth column, which is titled category, lists a category, or I take it a source for the city's comment. In this case, for example, under line 3, specify level 3 flow controls, the reference there is to the 2016 KCS WDM King County Surface Water Design Manual. Is that correct?
Yes, that's correct.
Okay. So the reference to BMPs here on line 4 and the reference to LID BMPs on line 10, in both cases, the source is KCS WDM. Is that right?
That's correct.
Is there a reference there to SMC 21B.85?
Not in this document, nope.
Did you have any indication from the city's first round of comments that it would use 21B85 to require more than LID BMPs under the King County Surface Water Design Manual?
No, I had no indication.
And was there any reference to the term land use management LID anywhere in the city's first round of comments?
No, the first time I had heard that reference was in the denial.
Okay, I have no further questions.
Mr. Eglick, any cross-examination?
Are you familiar with the provisions in Chapter 21B.85 that you've been discussing here with Mr. Roos?
I am familiar with 2185. I'm not sure which provision you're specifically speaking of.
Well, you were telling Mr. Roos that the comments that the city made were the first you had heard of, let's see, where's the, I don't know if I have the right page here. Were the first you had heard of the land use LID, is that correct?
From the city comments, correct.
I think that
had you heard, oh, I'm sorry. I can't tell if someone's talking or not.
That was me. I just think that mischaracterized her testimony. I think she used the term land use management LID.
Okay, sorry, I left out the word management. Is that a concept that you've dealt with regard to other applications?
In all the projects I've worked in Sammamish, land use management LIDs has never come up.
Is it a term that you have had any familiarity with in other jurisdictions?
No, it is not.
When you saw the city's comments, did you take a look at SMC 21B15230?
Let me pull that up.
Is
there a specific city comment that I should be referencing?
Well, just pull up that section if you would, please.
Perhaps Mr. Williams can pull up the section. Put it on the screen, 21B.15. 0.230.
So the definition of LID, yes, I've seen this.
And can you read the first sentence of that, please? Or maybe it's the whole sentence of it. It's a long definition.
Low impact development is a stormwater and land use management strategy that strives to mimic pre-disturbance hydrologic process of infiltration, filtration, storage, evaporation, and transpiration by emphasizing conservation of on-site natural features, site planning, and distributed stormwater management practices that are integrated into the project design.
So, just so I can understand your testimony is, you're familiar with LID, and I think, and you think that that is equated with flow control BMPs. Is that what the kind of basis of your testimony was?
Yes, in my experience, the LID component has been related to the flow control BMPs as established in the King County Surface Water Design Manual.
But flow control BMPs relate to stormwater, is that correct?
Correct.
But this definition in the code talks about stormwater and land use management, correct?
It does, but it also states that it's a strategy, singular, that's the point is to mimic pre-disturbed hydrologic process, therefore stormwater.
So it's your testimony then that the BMPs, which relate to stormwater, are all that is encompassed, and that land use management doesn't add anything to the.
No, that's not what I'm saying. I think.
I'm sorry, I couldn't hear you.
Apologies. I was saying no. I'm not saying that the land use management has no impact or no component. It's a strategy that works together. It's hand in hand with the flow control BMPs. All of the flow control BMPs are also a land use management strategy. It's just never been separated out before, in my experience.
Okay, then could you take a look at 25B 85010, please?
25B?
Oh, I'm sorry, 21B 85010. It's getting late.
I'm sorry, you're gonna have to say that again.
Sure, 21B.85.010.
Okay. Hi there.
All right, you're there?
Yep.
I can see it on the screen, I think, but you're there as well. Okay, so could you read the last sentence in it's under sub 6, but I'm not sure whether it's part of sub 6 or just
I think it's a
dangling.
I think it's a standalone statement.
Okay.
That's how I'd interpret it, given the line break between 6 and the start of it.
I think it's fair enough. Could you read that, please?
The purpose of this chapter is to require that development proposals within the town center sub-area fully incorporate the interim stormwater standards and low impact development into all aspects of project design.
So, again, the stormwater standards are followed by an and low impact development. So is it still your testimony that the BMPs are kind of the total expression of what this is talking about, what the code is talking about?
I think the low impact development portion of this relates still back to that previous definition, which is in the same municipal code, that it's a strategy. So therefore, by meeting the stormwater LID standard, we meet the land use management LID standard.
Just to be clear, because I can never keep straight how these manuals all work, because there's one for the state too, isn't there, that's different than the King County one or the Sammamish add-on or whatever it is, and there's a separate one for ecology even?
Correct, there's quite a few.
Okay, so, but when it refers here to interim stormwater standards, that includes these BMPs you were talking about, right?
Correct.
Okay, all right. Thank you very much. No other questions.
Ms. Hebron, I have only one question. You said in your testimony you had never encountered uh, a certain something in all the projects that you had worked in Sammamish. How many projects have you been involved in for various clients in Sammamish? Approximate total.
At least 15, if not more.
Thank you. Mr. Roos, any redirect?
Just a couple of questions. Mr. Eglick was referring you to a couple of occasions in 21B85 where the term, quote, low impact development is used. Is that correct?
Correct.
And that definition of low impact development is in 21B.15.230, the definition we were just looking at. Is that correct?
That's correct.
And does the King County Surface Water Design Manual also have a definition of, quote, low impact development?
Yes, in the definition section it does.
And is that definition, how does that definition compare to the definition in the municipal code?
It is the exact same.
So the definition of low impact development in the manual is identical to the definition of low impact development in the development code.
Correct.
And I take it that the city determined that the project met all LID requirements in the King County Surface Water Design Manual. Is that correct?
That's my understanding based on the decision, correct.
Okay, no further questions.
Any recross?
30 seconds, please.
The other stuff is just records.
Yeah, I have a question. I think the examiner asked and how many projects you had done in Sammamish, or worked on Sammamish, and I think you said 15. Is that correct?
How many projects I have been a part of, correct.
And how many of those were UZDP projects?
One.
Is that the one we're about here about today, or about here today, or whatever the phraseology would be?
No, one before this. I helped with the Ichijo project as well.
Okay. And are those projects, are the other projects you were involved in plats? Subdivisions?
I believe that one was a binding site plan.
You mean for the Ichi, whatever you just mentioned?
The Ichijo was a binding site plan.
Okay. You're at least for me, and it may be my hearing it. I hear the Ichi, and I don't remember that name. I've heard it earlier today, but the end of it is kind of dropping off for me. So, go ahead if you could just repeat that. Which was a binding site plan for what?
The Ichijo townhome project on the side of 228. That was
okay.
I think that
was a binding site plan that you were involved in.
Correct.
Mr. Eglick, I think the last two letters in that name are J-O.
Yep.
I'm not
okay.
sure.
Thank you.
At least phonetically, that's what it always sounds like.
Yes.
Yeah, I appreciate it. Maybe my hearing isn't good, but it seems like things are falling off on the ends of words or sentences. So you've got one binding site plan that was part of a UZDP. Mm-hmm. Then you have this project, and what were the other? That I guess that leaves 13. What kind of projects were they?
There were plats, short plats. I don't believe I've done any commercial in Sammamish.
Okay, so they weren't anywhere near the scope of this project, were they? Short plats, I mean.
Those would not have been, but the Ichijo townhomes would have been.
And what was the what was the scope of that was a binding site plan. So was it also a UZDP?
I believe it was, yes.
Okay. All right. Thank you. No other questions.
Thank you. And thank you, Ms. Everett. Appreciate it.
Thank you.
Mr. Roos, do you have another witness?
I do. I'd like to ask Curtis Koger to unmute and show his face. I believe there he is.
There he is. You think this might get done in an hour?
I certainly hope so.
Okay. Mr. Koger, if you'd raise your right hand, please, sir. Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please tell us your name and how to spell it.
Curtis, C-U-R-T-I-S, Koger, K-O-G-E-R.
Thank you, Mr. Koger. Your witness, Mr. Roos.
Mr. Koger, can you please provide your professional address?
Yes, I work for Associated Earth Sciences. I'm located at 153 Castle Avenue in Winthrop, Washington, 98862.
And you currently work with Associated Earth Sciences, is that correct?
Yes.
And what is your title there?
I'm a senior principal geologist and hydrogeologist.
And you submitted your resume for the record as Exhibit 1019, is that correct?
Yes.
And is that resume a reasonable outline of your experience and qualifications?
Yes.
Mr. Hearing Examiner, we would submit Mr. Koger as an expert witness in this matter.
Mr. Reglick, any objection?
No, he is licensed.
Thank you.
Mr. Koger, are you aware of the location of the approximately 8.09 acres that is considered the project area for the UZDP application at issue in this appeal?
Yes.
And you, along with others, provided a geotechnical evaluation of this area, is that correct?
Yes.
And the original report is, I believe, Exhibit 13H in this matter, and a revised report dated June 22nd, 2020, which I understand is Exhibit 35M. Have you or AESI prepared those reports?
Yes.
And can you briefly summarize the geotechnical investigation that you performed and provided in those reports?
Yes, so we were working on the southwest quadrant. We completed a series of exploration pits, a series of one exploration boring within the southwest quadrant. We reviewed documents from other geotechnical reports, conducted site visits, so basically do geologic reconnaissance of the site, and then take that information and move into doing analysis and reporting.
And can you briefly summarize then what you concluded regarding the subsurface conditions within the project area?
Yes, so we encountered lodgement till, very low permeability material at ground surface. And then, one second, we've got something going on in the background. Sorry, we encountered low permeability lodgement till at the ground surface. And in deeper explorations, there was also an even lower permeability material at depth below the lodgement till. So very low permeability materials seen in exploration pits and in exploration borings, which obviously has implications tied back to groundwater and the ability to do stormwater infiltration or the lack thereof.
And without getting into a lengthy geology lecture at this hour, can you just briefly describe what till is and how it was created many thousand years ago?
Yeah, so the Vashon lodgement till is the material that was literally being deposited at the base of the Vashon ice sheet as it was advancing and retreating into the Puget Lowland. It is essentially called nature's concrete. Many people refer to it locally as hard pan, and it's commonly used as a material for dams, earth dams, because its permeability is low. And that would be consistent with the presence of wetlands on the upland. The very low permeability of the till and depressions is a very good place for wetlands to form.
Based on your analysis, did your report reach a conclusion regarding the viability of low impact development given the site's soil conditions?
Yes, we identified the site as being infeasible for infiltration, consistent with the definition of infeasibility contained in the King County Surface Water Design Manual. It's also consistent with the Ecology Stormwater Management Manual also.
And you are aware that the project proposes level 3 flow control, is that correct?
Yes.
Okay. Have you reviewed the portion of the decision on appeal on this issue as it relates to LID and specifically pages 22 through 25 of the decision?
Yes.
And you notice that on pages 24, it distinguishes between land use management LID and stormwater LID, and then identifies certain techniques that are suggested as worthy of exploration. And that's at the bottom of page 24 and the top of page 25. Is that correct?
Yes.
I'm going to ask whether you have an opinion on whether the specific techniques that are identified there would be effective or viable at this site. And if you do have an opinion, I'm going to ask you what that opinion is. Is that fair?
Yes, it is fair. And yes,
okay.
I do have an opinion.
Okay. Let's start with the effectiveness, feasibility of rain gardens, given the flow control, level 3 flow control and the till condition.
Yeah, so the rain gardens are most effective, of course, in soils that have an infiltration component to them that make them viable if you are actually trying to use them as part of your flow control and return water to the ground in that specific facility. Otherwise, they need to have an underdrain in them when they're in a very low permeability material like the lodgement till. And it's can be part of a bigger stormwater system. But when you already have level 3 flow control, you are meeting that requirement. And I would also point out that there is a water quality component to a rain garden, but that component can also be met via other vehicles available as a BMP for stormwater management.
How about the effectiveness and viability of green roofs given level 3 flow control and the till condition?
Yeah, so the green roofs, again, the primary objective there would be to assist in flow control. So if you have already achieved level 3 flow control, then there'd be an underlying question as to what would be the purpose. It would not be necessary to achieve the flow control requirement of the BMP suite that's available when you're working your way through the ecology or the King County manuals.
So is it fair to say, I think what you're saying is if you're already providing level 3 flow control, what's the point of doing additional green roofs at this site?
Yeah, it wouldn't be necessary for flow control. It wouldn't be necessary for water quality if you're also treating water quality. And my understanding in this case is that the site is being treated to the lake standard. So it's already a very high level of water quality treatment also.
Okay. How about the possibility of reduced impervious surface or a reduced building footprint, which is also suggested or identified in the decision?
Yeah, so the objective that is typically tied back to those reduced footprints is if you have a viable location for stormwater infiltration on the site so that you can accommodate the infiltration facility. The very low permeability till ends up developing an interflow zone under the natural condition, under the natural forested condition. But of course, in a very high density, intense development project, there will be grading and the interflow zone will be removed. So the interflow zone, the storage that's available in there has to be replaced, and that's been replaced by the level 3 storage, level 3 requirements. So flow through the interflow zone will follow the topography and essentially flow laterally across the very low permeability till, and then it would have to be picked up at the margins of whatever I guess available green space there is in order to be conveyed to an adequate facility for storage and then ultimate release.
So what is your conclusion about whether this is an effective LID technique given the site's till condition and the level 3 flow control?
Well, it wouldn't be effective as a flow control method if you were trying to depend on the very low permeability till as a method for stormwater disposal. You have to pick it up and get it into a storage facility somewhere so that it can then be released at the required release rates.
Okay. How about the retention of vegetation? Well, the retention of vegetation at this particular site.
Yes, the vegetation at this site is going to have very little positive benefit for flow control. And I think Holly already identified that as one of the considerations in the level 3 sizing. So of course, when you're looking at a large site such as this one, and in fact, the entire town center, and you need to look at it in context of the entire natural environment. What are the opportunities and constraints for stormwater management since that's the topic we're on, and what do the soils allow you to do. So basically, you're trying to understand the subsurface plumbing conditions and what would make the most sense for dealing with the stormwater runoff based on the reality of what the soil conditions afford you.
Okay, and the last one, this may be related to your discussion of reduced building footprint, but there's also a reference to minimizing soil disturbance or building excavation depths.
Yeah, and that, it's just simply not realistic in a high density town center situation to avoid significant grading. You just have to have grading in order to achieve this type of density. So the various elements that you see that are identified as LID BMPs are tied back to, in my understanding of having been involved in, many big master plan communities, you're looking at where can you put water into the ground if you've got places for it. And if you don't, then how do you achieve the flow control? And what areas do you leave as natural areas? And that's typically the critical areas are left alone. And then you provide hydrology to match pre-developed conditions in areas that need to continue to have hydrology. And then you deal with release rates where you have to pick up the stormwater and get it conveyed to a storage system and then released into the drainage at the forested condition pre-development rates.
No further questions from Mr. Coker.
Thank you. Mr. Reglick, any cross-examination?
Yes, thank you. Mr. Coker, I'm the attorney for the city of Sammamish. So I don't know if you've been listening in today, so I'll introduce myself. I agreed to your testimony as an expert engineer, but I want to make sure that we have the full extent of your credentials. Are you a certified arborist?
I am not an arborist. I'm not an engineer. I'm a geologist, engineering geologist, and hydrogeologist. So the licensing is different.
Right, but it's a state licensed function. In fact, I have your licensing.
I'm sorry, you dropped off.
Oh, I said it is. An engineering geologist is licensed by the state, similar to how a geotechnical engineer is licensed, a different title, though. Is that correct?
It's definitely a different title. Yeah, geology is definitely different than engineering.
Okay, but whatever else, you're not claiming to be an arborist, are you?
I am not.
Are you claiming to be a landscape architect?
I am not.
And you referred to the site here, and I hope someone will tell me if I'm too close or too far away from the mic. You referred to the site here, and you said we have to think about, look at the size of the site. And when you said that, what were you meaning by site?
You're a little too close.
Yes.
Answer
Sorry.
Your question. Go ahead, Mr. Coker.
Yes, thank you. Thank you for the question. From my perspective, I think about the site where I have backed out. So my apologies. I'm thinking about the entire 200 and whatever it is acres of the entire town center. And the reason for that is because very early on, we were asked to look for potential opportunities for stormwater infiltration across a much larger land area than the subject of this current UPDZ application. So that was the context that I was thinking about at that moment.
So when we're talking about the site for the UZDP, it's not 200 acres, is it? It's 8 acres, isn't that right?
Correct. It's only 8.09 is what I understand.
Right. So on this 8.09 acres, you said something about, and I want to make sure how it applies to this. You said retention of vegetation at this particular site has very little, and then I missed the word, very little blank for flow control. What was the word I missed?
Probably beneficial use or benefit, something like that.
Okay. You're not testifying, are you, as an engineering geologist who is not an arborist or a landscape architect, that retention of the vegetation doesn't have any benefit, are you?
No, I'm, as a hydrogeologist, what I am testifying to is that the lateral flow through the interflow zone has to be picked up at the margins of any green space and conveyed into the built stormwater system.
Okay. Do you know what percentage of the site, and by this I mean the site for the UZDP, is characterized by vegetation?
Under the existing or proposed?
Well, I'm going to ask you about proposed in a minute, but you're ahead of me. I'm asking you now about existing.
Existing, as far as I know, under existing condition, it's a fairly significant. I do not know the exact numbers. I assume that that would be available in the civil documents in the TIR.
Now, you kind of anticipated my next question. Do you know what percent of that site is going to be characterized by trees that have been retained or other notable vegetation after the proposed UZDP project? I'm basically asking you about vegetation and particularly tree retention. Do you know how that's going to work?
No, I don't.
Okay. You're not testifying here today that tree retention is not possible, are you?
No.
And you're not testifying that retention of significant vegetation is not possible, are you?
No.
And thank you. No other questions?
I don't think I have any questions. Mr. Roos, any redirect?
Yes, just one question. You mentioned that you were looking for opportunities for infiltration, or that opportunities for infiltration had been explored throughout a significant portion of the town center. Did that include looking for opportunities for infiltration within the 8.09 acres within the project area?
Yes.
And I take it none were identified, is that correct?
That's correct.
And that effort to look for opportunities for initiation, that was initiated by STCA, not the city, is that correct?
Yes.
So the STCA undertook this at its own initiative?
Yes.
Okay, no further questions.
Mr. Eglick?
Did you also look for opportunities for, is this a word that I think I know this word, transpiration?
We did not.
Thank you.
I've changed my mind. I do have a question on a totally different subject, but related to geology and hydrogeology. Mr. Koger, are you familiar with the city's um, critical aquifer? What's the third word? It's CARA. Recharge. Yeah,
Yes.
critical aquifer. You are familiar.
Yes.
Are you aware that a city map, a generalized city map, depicts an edge of a designated CARA, C-A-R-A, encumbering the northeast corner of this 8.09 acre site?
Yes.
Okay. Are you able to tell me anything about in your opinion, the effect of this project on that CARA, assuming for the sake of well, if you may not even want to assume it, but I was going to say, assuming for the sake of argument that that CARA line on the city map is accurate, what effect, in your opinion, does that have on the project? Is it something that one needs to factor into a design, et cetera, et cetera?
Making the bold assumption that the CARA line is in fact correct and that the capture zone as depicted is realistic, the effect really is de minimis. And there is actually documentation embedded in the Sammamish Plateau Water and System documents that show how deep the aquifer system is. And when they look at the details of capture zones for water supply wells, you will always find that they do not match the circles that are perfectly concentric circles. And the reason for that is there's always some kind of a gradient, and it will be elongated up gradient. So the capture zones as depicted are simply not realistic, but they are a convenience and are commonly used by water districts as a method to identify areas that are of special concern to a water district. So in this location, because of the very low permeability of the till, which has an infiltration rate that's, instead of being measured in inches per hour, which is what you need to see when you are expecting to infiltrate stormwater into an infiltration facility, it would infiltrate at about an inch a month. And the material that is beneath the till has an even higher fines content than the till does, and it would infiltrate at the probably an equivalent rate of about 0.1 inches per month in the possession drift below the till. So this area simply is not an important contributor to the wells that the plateau, the Sammamish Plateau Water and Sewer District use, that are located in near the extreme northeast corner of the project, overall town center project site.
If I recall correctly, the city's rules on CARA, among other things, encourage infiltration. Presumably, it would make sense to me anyway as a geographer. I'm not a geologist, but I am a geographer way back when, with the notion of let's infiltrate stormwater so that it can go down and supply the aquifer. And am I understanding your testimony that in this case, we can't infiltrate because the soils are so dense to begin with?
Yeah, the fine grain content is really the primary issue. So even in glacially consolidated soils that are sand and gravel that are classified as dense, those materials you can infiltrate into. It's the high fines content, very fine grain material, silt clay, that ends up limiting the infiltration potential. And it's why lodgement fill is used as an earth dam material, because its permeability is so low, it forms a very good liner. And the material that's present beneath the lodgement till, I referenced possession drift. Possession drift has a very high silt clay content, and material like that can be used as a liner in landfill type projects because its permeability is so low.
Okay. Thank you, sir. Any question from either of the two council based on my question to him?
No, thank you.
No? No? Okay, thank you very much. Mr. Roos, any redirect?
I was just going to ask if the examiner is interested in Mr. Koger's thoughts on transpiration, that term that Mr. Eglick used, what it means, and whether it's a significant contributor here or whether we should call it.
Since I realize that transpiration is the movement of water from plants into the air, and Mr. Koger is not an arborist nor a landscaper, I don't want to hear his answer. Oh, does that mean we are finished with Mr. Koger?
I had no further questions.
Okay.
Mr. Examiner, good to see you again after I don't know how many years, but I first saw you in the middle 90s, I believe it was, when you're hearing examiner at Snohomish County and Deputy Examiner Donahue.
My goodness. Yeah, I apologize, sir. I do not recognize you.
I've gone quite gray since you would have seen me 30 years ago almost.
Well, I'm gray and have a lot less hair than you saw me 30 years ago. So nice to see you again, and thank you very much for coming to testify. You're excused, sir.
Thank you.
Mr. Roos, where to now?
STCA has no further witnesses at this time.
Okay, so you're resting, is that correct?
Correct.
How about we start with the city tomorrow morning?
May I ask what witness will be starting with tomorrow for the city?
Chris Hankins.
Okay. Then it is, what time does it say? It says 7:36. We will continue our hearing tomorrow morning at 9 a.m. The arrangements remain the same. The login to go to meeting remains the same. Since this is a continuation to a date, time, and manner certain, there is no requirement for any further public notice, nor will any be provided. It is now 7:37. We stand adjourned. Mr. Sugg, thank you for your work these last 3 days. I think we get Ms. Schaff tomorrow. So you may turn off. You may turn off the recording. What?
We did receive video links, Mr. Examiner, so far for the first 2 days. We'll check those, but Mr. Sugg has been great to circulate those. Thank you.
Okay. Thank you all. See you tomorrow morning at 9.
Thank you.